Good morning, or technically good afternoon, because it is technically the afternoon on Tuesday, January 21st. Slight delay on the stream today because it is book day. We need to talk about book day. No spoilers. I have barely gotten to begin reading. For everyone who's like, what are we talking about? It's Onyx Storm release day. Something that I love dearly broke my heart at about 2 o'clock this morning. We're going to have to talk about it. Everyone, let me know where you're coming in from, what you're drinking, and please stay safe, stay warm. Like, this cold front is wild. And seeing that like New Orleans is going to be getting snow, like what in the world? So y'all stay warm, plan for your power, and all of the rest of it. So we're going to have to talk about my broken heart this morning, and then my toe, which they say is not broken, but is still giving me all of the business. And then we've got some quick housekeeping on what's coming up later this week. And then we're going to jump back into what seems to be the world's most divisive lawsuit, even though we're just at the complaint stage. So we will get into what we didn't finish on Thursday, because as I said on Thursday, when that lawsuit dropped while we were streaming, I had an appointment that I couldn't reschedule. Why? Because sometimes you have appointments that you can't reschedule. And because I made the mistake once or twice of mentioning where I get my nails done on social media, I can no longer get in to see my wonderful nail tech because she is so booked. A, I love that she is so booked. B, I hate that it is so hard to now get in and get my nails done. That's just what it is. It is a actually growing issue, but that's what it is. So let us get into all of the things. I know I made the mistake. Well, and a few people locally asked. And so when people locally ask, I want my amazing nail tech to be booked and busy. But when it's so booked and busy, I can't get in. I'm just like, damn it. So Judy, you got this, said your toe needs to toe the line. I'll see myself out. No, it's true. The toe is killing me. The toe is killing me. The toe is killing me. So it just, again, the toe is not healed yet. Also did not give me a great chance to run through the aisles of Target this morning. We're going to talk about Target. We're going to get to the intro. We're going to talk about Target. And for those who will inevitably come in and be like, I thought that this video was about these lawsuits. Yeah, we're gonna do that. Everything's timestamped down below. We have a pattern here of how we talk about things. So with all of that, let's get into today's show. It's good to see all you guys staying warm and how freezing it is where y'all live. It's wild. I've also got homemade cappuccino. Did we have time to go to Starbucks today? No, we've got lots of things to do. Heather Long in the chat said it snowed in Baton Rouge. That's wild. It's look, this weather pattern, man, it's going to be cold, and it's going to be cold really far south. And what I know just from the brief period of time that I have lived in Middle Tennessee is that we're not built for this. So for all of you that are not going to be able to get out of the house, just stay safe, stay warm, and driving in the snow is a whole different situation. So be careful. All right, let's go. Hopefully all of you have like 4-wheel drive and it's going to be fine and not too snowy, but it's definitely cold. Let's get into today's show.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Heather in the chat said, I've been without heat since last Sunday. That is not helpful. So to talk just briefly about my broken heart and not my wrecked toe, that they say is not broken, but is still taking its sweet time to heal. Also, time is a construct and I am impatient. So there is that. It still hurts though, which is really frustrating actually, but it is what it is. And it's the most ADHD thing in the world. It's like, I can just move this one thing and then it's like an avalanche of things. I did put the ampersand back into the background. A lot of you said justice for ampersand. So ampersand is back for now. We will decide if it gets relegated to a different shelf later, but it's there for now. So for all of you that woke up in varying levels of the middle of the night to try to purchase a book on Target's website, how did that go for y'all? Because it was like iPhone, the very first one they did online pre-ordering for type drop, everything crashed. I don't know about you. Everything crashed. Everything crashed. And Target's like, oops, we can't, you can put it in your cart, but you can't check out. But if you try to check out, the app's going to crash. And if you go onto the website, it's going to crash. And if you want to do it for in-store pickup, oops, you can't do that. But if you don't want to do it for in-store pickup, then you're going to have to put it in your cart and check out. And if you can't check out, then the website's just going to crash. 30 minutes. 30 minutes of me at 2 a.m. trying to do all of the things. And it wouldn't ship. For all of you being like, what book? We're talking about Onyx Storm. It is the third in the Empyrean series. We are talking about dragons and romantasy fantasy. We will see what this one is. Am I very far into the audiobook yet? No, I'm not at all. But I will be later today, but no spoilers. We're going to give people their time. And people who are waiting for their physical copies that didn't get them, because a lot of people pre-ordered them and the physical copies have not arrived to doorsteps yet. And for those that are waiting on library and what have you, we will not spoil. But Target had a limited Target only edition, different than the pre-order limited edition. And the limited Target pre-order edition, or the limited Target edition was not pre-order, was only available today. I thought was only going to be available in store. And then it was like, no, it's not just available in store. It's available on the app starting at 3 a.m. Eastern time. 3 a.m. Eastern time. So I set an alarm. I got up and tried to get the Target limited edition. Why? Because it looks cool AF. And it's got different sprayed edges. For those of you that are like, what the fuck is a sprayed edge? It's when there's like art on the pages of the book. So when you hold the book shut, you can see it. For those of you that are Andarna stands, like it makes sense, because who doesn't love a sassy teenage dragon? And crashed. Everything crashed. It was so frustrating. And then a lot of people have said that ordered the special edition, not the Target limited. I don't even know what they're called. There is a collector's edition that was a pre-order, and then there's the Target limited edition. At one point, it looked like Target was taking not the Target edition and putting it in people's carts, but like subbing it out for the pre-order edition, which is not the same thing. And I was like, wait, what is this in my cart? Like, it was swapping the one I was trying to buy and the one that was the pre-order that's now available in stores. So for those of you that want to go in to store, you might be able to find the one with the multiple dragons on the sprayed edge, but it seems that the Target special order debacle is just done. It also didn't seem that they had any cart limitations on how many you could add. It was maybe not well executed on that end. M, thank you so much. M said there's a Target exclusive and a deluxe limited edition. Thank you for the proper names. So the Target exclusive wasn't a pre-order and was announced well after a lot of people had ordered their deluxe limited edition. But it seemed like people had started getting notifications that their deluxe limited edition got canceled. Like, just canceled. Just sorry, we're not shipping. And then the Target exclusive, they said everywhere it may sell out, but they were not prepared. Everything crashed. It was not well executed at all. It was not smooth. It was incredibly frustrating. I imagined that this morning at Target was also a total shit show. And then for people who live far from Targets, there were people like, okay, well, if I can order it and have it shipped, then I can do that because I can't like get to a Target. And that's the only place to get this limited edition that actually looks cool. And that was not easy either. It was so for everyone who was up in the minute, it was so frustrating. Katrina said they announced it way after. No, way after. I'm losing patience with publishers like changing covers in the middle of a series. Hell no. Katrina, I hear you. And a lot of people were like, look, we ordered the limited edition pre-order. What do you mean you're dropping another edition that is Target only, that is blah, 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 blah. So it was just wild. Casey Haig said, my Target was actually really well done. That's awesome. I'm glad to hear it. I'm really glad to hear it. I did not go in person this morning. It's 10 degrees and my foot is not trekking around Targets. I was like, you know what? At this point, we're going to let it be. If they relaunch this thing though, I might lose my mind. So I pre-ordered the deluxe limited edition. It will be here sometime next week. We will see. But I have the audiobook, so it will all be fine. Am I sad? Yes. It was not a smooth experience. Frustration at 2 a.m. is never delightful. So it was, but hopefully those that went in store were able to get them in store and it was fantastic. So hopefully everyone who wanted it got them. The local bookstores do have them. They do not have the Target limited edition. I have no idea how much control authors have with that. Like I really don't know. I think that's a lot publisher determined. So we'll see. The book series title has been in the chat, Green, but it is the Fourth Wing series. It's called the Empyrean series, but it is the Fourth Wing books. So this is the third one. Aaron said, no, the authors have no control. And that's got to be hard too, because I'm sure people are going to say to the author, this was a shit show, and the author literally can't control Target's app. Cheryl Ray said, Emily, I went down the Traders rabbit hole, even got to the UK version. Traders is so good. Traders is so good. Traders is so good. Amy Zimmerman said people are leaving horrible reviews due to not being able to order. I hope not horrible reviews of the book and that they direct that at Target, because this was a Target issue. Like, this was a Target issue. But I feel for the author who's like, I wrote these books for our community, and then the publisher decided to launch a Target limited edition, and it was a shit show. So, all right. Lilibet made an excellent point. Target's not a bookstore. They have no clue what happens when a book gets super popular. Bring back midnight release parties. Lilibet, yes, I miss them. Though Barnes & Noble in our area did do a release party, I had no idea that was happening, but they started selling the deluxe limited edition at 11 p.m. because I had pre-ordered it, though it's not going to be here for like another week. And I have the audiobook. I decided just to wait, but I didn't realize they were doing that and I didn't sign up, but they were doing a sign up like release party at like 9 p.m. So next time I'll take a look. And thank you for the chat for adding it in for all of it. And then I will take a look. A lot of the local booksellers here are mostly used, pre-loved historical books. So that I don't think anyone's going to have that Target pre-order. What's frustrating to me is I think Target did not prepare for the botting of their website for people to get their hands on that book to put it up on eBay and such. I think they probably weren't prepared for that because that's one of the things that just crashes stuff out. And that's really frustrating because a lot of people who love this series wanted both versions of the book with the sprayed edges and are frustrated. So I get it. And I was with you, so frustrated. You'd think Target would have been able to handle this since they are also the exclusive sellers for Taylor Swift merch. You would think, you would think, but again, the readers broke Target today, and it just, it's a bummer. But we'll get into the book. So the series name, somebody just put it in the chat, and I'll just pin this. Pixie Patty, thank you so much. It's a great series. It is there is some light, spicy bits. It might get spicier as the series goes on, but there are some light, spicy bits. And there are pretty thorough content warnings on it, but dragon writers at a war college Kate Manning said they were not prepared for the storm. They were not. Neither am I. I'm like nervous. I'm ready to read this book because of how the last one ended. And I'm also, I'm nervous. I'm nervous. But I did go through I felt very seen in the very beginning of the book when it said for everyone who read books under your desk. And I was like, us, that's us. That's us. We are reconnecting with the kid who read books under their desk while other things were going on in class. But I'm nervous. So I'll keep you posted on how I'm feeling. And we'll see. I'm still not really recovered from finishing Throne of Glass. So it's just what it is. And we have novella-sized lawsuits. So we have not novel level lawsuits to get to, but we have some housekeeping first. So Idaho. We got to talk about Idaho. There are supposed to be 2 days of discovery hearings in Idaho later this week. We have put that on the calendar. We are ready to cover Idaho. However, the court wants all of the hearings on discovery sealed, like closed door. Like what? So I don't know if we are going to have hearings for the Kohberger case later this week or not. So for all of you being like, what did Idaho do? No. Sorry. For the Bryan Kohberger prosecution in Idaho, the court has determined that the discovery hearings would be closed or sealed. There are supposed to be 2 days of hearings this week. We have scheduled around 2 days of hearings. Like we're ready to stream Thursday, Friday. So we will be getting to that if we are able to, because today they are having a hearing because the defense is arguing that at least some of the fight over discovery should be public. So the defense, the prosecution, and the new judge, Judge H, are having a hearing today to try to determine what will be public. Crystal said, are we able to get transcripts? No, we aren't. We aren't able to get transcripts. If it's sealed, we aren't able to get anything. And that is frustrating at a minimum. So I'm going to go here. Let's do this real quick. That hearing is today, but it is Mountain Time. So that hearing is sealed. We won't know until later today. I'll update you in the app, but the plan for this week is to cover that hearing. I hope some of those discovery hearings will be public. The defense is asking for it. And let's see, this is from January 15th. Let's just pull this up and take a look at what the court said so that it's clear. And then we will go into everything else. But am I frustrated? Yeah, I'm real frustrated. I can understand when it comes to maybe the DNA regarding the FBI and the other agencies' collection and distribution, because that evidence might not come in at trial. So I can understand maybe when you're talking about FBI procedures. Yes, I forgot, chat, sorry. That was way too quiet. When you're talking about FBI procedures, maybe we need to do that out of public view, maybe. But now we have all of the discovery fight being sealed, which is frustrating because I really want to know what's still outstanding. Script Goddess said, wait, I thought the defense was wanting everything private so a fair trial could be secured. Now they want things public. I'm confused. They did change midway. Initially it was, we want everything sealed. And then midway through, they're like, no, we want everything public. So it shifted, and the defense has been arguing for it to be more public. I wonder if that change of heart came when stuff started getting difficult for them to get. There have been difficulties in getting discovery in this case just from the amount of motions we've seen filed, because they're all sealed. But we can see that the motions are filed on the docket. At least there's that. I appreciate that even when they're sealed documents, we see what the document is. You can't read the document, but you see that a document has been filed. Ruth said transparency should be prioritized more than it has been in this case, I think. I would hope so. The court's going to court. Sylvia's daughter said, Em, I love the nails. Thank you. We got new nails on Thursday. They are a little bit black, a little bit gold, and a little bit like geode. So thank you. They're fun. Did we get a pedicure? No, that's gonna be a minute, unfortunately. All right, let's take a look at what the court said real quick, and then I will stop venting my frustration on the fact that we planned our whole week around being in court for 2 days and then not. Law Junkie said, are the nails for Onyx? Yeah, they are. We're a dork like that. Brittany said, thank you for the Idaho update. I was checking the site the other day and was hoping you'd give us a rundown of the newer docs. We will do a rundown of the newer docs. There has been so much going on. We will do a rundown of the newer docs that we can get to when we see what's going to happen with this hearing. So I wanted to leave space for us to watch these hearings. We know from all the last motion hearings that a full day is really what's likely to happen here. So let's just take a look at what the court said. This is notice of hearing. This is today's hearing, January 10th at 10 a.m. Mountain Time. I appreciate that this judge clarifies the time zone. I've messed this up in the Corey Richins case more than once because I forget if I'm on Mountain Time or Pacific Time, and I get, time zones are wild, but I get confused between the two way too much. The court will hold a closed, sealed hearing. What does that mean? That means the public cannot attend. The public cannot attend in person. The public cannot attend via Zoom. The public cannot attend at all, period. Angela said, applying for jobs today. Wish me luck. Good luck, Angela. So, and then Brittany said, wait, is Idaho in 2 different time zones? Also, yes. Part of Idaho is Pacific. Part of Idaho is Mountain. Just like Tennessee. Part of Tennessee is Central. Part of Tennessee is Eastern. Do I forget that all the time? Yes. Yes, I do. However, when I map things on like Apple Maps or whatever, it says time zone change, but I still have to ask my husband when we have to go to like band competitions and stuff. I'm like, well, it's a 2-hour drive. He's like, we have a time zone change. I'm like, that's right. Like, oh, I'm going to go down to Atlanta and meet friends for lunch. He's like, you have to add an hour. It's like, damn it. Emily's always on Pacific time. That's actually incredibly accurate. That's incredibly accurate. So good to see you, Nuria. The court will hold closed, sealed hearing by remote video means to 1, hear the defense motion to unseal materials related to its request to suppress evidence stemming from the use of IgG DNA. And 2, consider what portions, if any, and under what circumstances should the various motions set to be heard on January 23rd and 24th be open to the public either live and or by video. If you're going to let people into court, also, you need to have it televised. Come on. Brandon said EDB is on EDB standard time. Yes, EST in my world is definitely Emily standard time. It's ADHD standard time. The court will provide a video link to the attorneys of record who request a link and the Ada County Jail so that the defendant may appear via video. Today is not an in-person hearing. Today is a sealed hearing. Most of the attorneys will probably appear by Zoom to figure out the appropriate time for what, if any, to figure out what, if any, of these hearings will go forward. I want to know. These are the hearings regarding regarding the fruit of the poisonous tree argument, regarding like, hey, if they used that IgG DNA, the familial DNA, if they got to that DNA improperly and identified Kohberger improperly and then did all the searches improperly, what stems from that may or may not need to be suppressed? I think suppression hearings are really important. And I think with suppression hearings, we need to see what's going on. So the argument from the defense being, you got to this top piece of evidence, whatever that top piece of evidence is, you got to this top piece of evidence the wrong way. From this top piece of evidence, you were able to get to this other evidence, and then all of this other stuff goes. Like if the top part goes, it all goes. Hopefully that makes sense. That's essentially a very simplified version of the fruit of the poisonous tree. Hopefully there will be an order online. When we know, we will move forward. I don't know why all of this would need to be sealed, but we will see. Mom Unscripted said the state is embarrassed, rightfully so. If we're talking about the state's attorneys, we will see, because I don't know. And Robin asked, does he have a private attorney? Bryan Kohberger is represented by Ann Taylor. How Ann Taylor is employed at present is more confusing really than it should be, because Idaho has completely restructured their public defender program, but these are appointed counsel. They are very good counsel, and Ann Taylor has fought every single piece of this case, and Ann Taylor's team, even though they brought motions that we knew weren't going to go anywhere, even though we saw arguments that we knew weren't going to go anywhere, they have preserved everything for appeal. And in a death penalty case, that's really what you would expect. And so when we're looking at that type of vigorous lawyering, though there's times it's like, okay, this argument, we know it's not going anywhere. The judge knows it's not going anywhere. It's been preserved. When the other attorney is like, the Magna Carta, you're just like, sir, we're not redoing the standard for a grand jury. Like that's a grand jury's not going to be beyond a reasonable doubt, but the Magna Carta, no. So with all of that, we will see what the court decides to do. So let's see. Alias said, if evidence A gets dismissed, there's no ABC. That's a very good way of explaining it. We will get into this. If it is streamed, we will stream whatever is available or not available, and we will go from there. So I don't know what's going to happen on Thursday, Friday, but there is not going to be a stream on Wednesday. We are going to do a members only Wednesday. Because we were going to stream Thursday, Friday, I booked in things that I can't move for Wednesday. So we will do our members only later on Wednesday. And then because my foot required trips to the doctors, we will be doing our members only evidence that we missed, the days that we missed for Depp Heard the following week. So we will be doing members only tomorrow either way, and I will let you know. So we will notify you guys what time, and then we will notify you what's going to happen Thursday, Friday. If we don't have the hearings, then we will cover other stuff that we haven't gotten to yet, because there are so many other cases. There is so much happening in the Diddy cases. There's so much happening. There was so much happening. So, for those of you asking, Depp Heard, yes, Jeray, we talked about this last week, but there are some days that I did not cover with the law nerds because I was traveling at the very beginning of the trial. And when people go through the trial and the playlist, we regularly get emails. We regularly get comments saying, where are these days? They're days I did not cover originally. So us and the members are going to go back through them so that they are in the playlist, and we have some of those witnesses that we missed. It's something that the members have been asking for a while, that the channel has been asking for. So we're going to go back through that with the members, and then we'll put it up on those playlists. So we have those witnesses, of course, with all the disclaimers of we are watching this years after this is resolved, but let's look at what this witness has to say in the vacuum of what this witness has to say, because we missed a cross-examination. We missed Isaac Baruch and some of those things. So we're going to go through that with the members the following week, but we'll do our regular members only. I got a new book that was sent for members only. So thank you. We'll go through that too. All right. So, and Lifestyle by Kay said, I'll have to watch it when I get a membership. We're going to put that on the channel. I'm going to record it live with the members, and then we're going to record it. We're going to put it live on the channel once I cover it. All right. Are y'all ready? Let's go through the road so far. Let me pull up documents. We have documents to go through. We have some new filings that we need to go through. Well, a new filing that we need to go through. And yeah, we have documents that we did not get to because I said we didn't have time to get to them on Thursday, which, you know, is what it is. Let me grab these documents and we'll do a quick road so far of what we've covered, what we haven't covered, where we are in the very earliest stages of this lawsuit. And I posted on Thursday the entirety of the federal Baldoni versus Lively et al. Suit, but I don't think we've posted anywhere the Lively et al. Federal suit because I haven't covered that one. So we will post that too. And if we need to, we'll just, well, on the app, we'll put a folder together with all of those, but they are the videos that we cover with the lawsuits. The lawsuits are tagged underneath each of those videos. So the entirety of the lawsuits are there, which with all of the public lawsuits, we have made those links available, especially on Thursday when I said we weren't going to cover the entire lawsuit because we did not have time for, 179 pages of lawsuit. So let's do a quick road so far of what we have covered, what we haven't covered, and go from there. So when we are looking at the It Ends With Us saga of litigation, we are still at 4 filings. The first one, and I've gone through these in chronological order. The first filing that was filed in court was the PR lawsuit with Stephanie Jones and Jones Work versus Jennifer Abel, Melissa Nathan, Baldoni, Wayfarer et al. We went through the entirety of that lawsuit. That is a New York State Court lawsuit that was filed on December 24th. That lawsuit is largely referenced somewhat substantially in the other lawsuits because both sides have opinions about whether or not it was lawful for Jones Work to provide the text message extractions or full cell phone extraction. We don't know which it is, but the cell phone extraction of PR agent Jennifer Abel to seemingly the lawyers for Lively's team and seemingly to the New York Times. The New York Times has never said what they reviewed. They just said, we've reviewed thousands of text messages and emails. We can presume that it's the same things we saw clipped into Lively's CRD complaint, which is not filed in court in California at this point. Could it be in the future? Yes. We haven't seen that yet? No. The thing that concerns me about the PR lawsuit from December 24th, as I said in Quick Bits, is that it doesn't seem to be docketed yet. That lawsuit was provided by, I think, TMZ, and we attached that link, but it was hey, the clerk's office received this, but it hasn't been officially filed yet. I have not seen it officially filed yet. It's normally not that hard to find the lawsuits in New York State Court. I've gone through and through New York State Court, and I can't find it. So we will see what happens with that one, but I'm putting an asterisk on there and I'm keeping my eye on it because it's I'm curious as to why it's not on the docket yet. There's enough time for it to be on the docket now. So I'm wondering what it could be a clerical issue, but asterisks on that one. I've got questions. We've referred back to it a lot because, again, Stephanie Jones was just like, oh, this is everything that happened in the employment lawsuit. And that is talked about in the federal lawsuit, but not talked about in the other lawsuits. So we're going to have to wait and see on that one, but we'll talk about what is said in both of them when we get to that part of the federal lawsuit. Then we covered the New York Times defamation lawsuit. Those were in the same stream. Then we ran out of time, but the PR suit and the New York Times defamation suit from December 31st, 2024, we covered both of those. We did not cover the Lively federal suit because the day we covered the other two, we just simply ran out of time to cover the Lively federal suit. We have not covered that yet on the channel because we haven't had time. I think I gave a very brief overview of what the causes of action were, and that was it. The Lively federal suit was filed December 31st, 2024. It's referenced in the lawsuit here heavily, service of process and what have you, is referenced in the New York federal Baldoni suit. So we're going to have to name them because for all of you saying I need a chart, yes, we're going to have to name them. Devlin, we do have playlists for all the trials. So they are there. So then we have the Lively federal suit that was filed December 31st that we have not had time to go through yet. And then we have the suit that was filed while streaming on Thursday, the Baldoni suit in federal court. So I think we've got the Baldoni suit filed in New York federal court on this January 16th, the Lively suit filed in federal court on December 31st, the PR suit filed in New York state court on December 24th, but not docketed yet, asterisks. And then the CRD complaint that was part of the underlying article for the New York Times. That's where we're at with all four filings. The CRD complaint has not been filed in California yet. Will it be? Maybe. Will it not be? Maybe. I don't know, because a lot of the causes of action are in the federal suit. So the causes of action, and then we're going to go into the suit that we did not finish on Thursday, because on Thursday I said we're going to finish the suit on Tuesday. So we will go through, I don't know if we're going to get line by line, but we will go through the big chunks of that suit. I also covered it on Quick Bits. The causes of action in the Lively civil suit in federal court in New York, largely under California law, which is not different than the Baldoni suit in New York federal court that is largely under California law, is, so these are the 13 causes of action in that suit. Sexual harassment against the companies. The parties are Lively, Wayfair versus Wayfair Studios, Baldoni, Jamie Heath, Steve Sarowitz. It Ends With Us Movie LLC, Melissa Nathan, Agency PR LLC, and Jennifer Abel. So mostly the same parties. The 13 causes of action there are sexual harassment against the companies. It Ends With Us and Wayfair. Retaliation against the companies. It Ends With Us and Wayfair. Sexual harassment under a different code against the companies. It Ends With Us, Wayfair, Baldoni, and Heath. Retaliation under a different code section for the companies. It Ends With Us and Wayfair. Retaliation under a different section of the California code against It Ends With Us movie and Wayfair. Failure to investigate, prevent, or remedy sexual harassment under California law for It Ends With Us and Wayfair, again, the companies. Aiding and abetting harassment and retaliation against Nathan, the PR company, and Jennifer Abel. Breach of contract for the actor loan ad agreement against the companies. Breach of contract for the contract writer against the companies. Intentional infliction of emotional distress against all of the parties. Negligent infliction of emotional distress against all of the parties. False light invasion of privacy in violation of California law, which we see in both of these lawsuits and the New York Times lawsuit, against all of the parties, and then sexual harassment under a different California code against Baldoni and Heath. So yes, there are different code sections here, but I saw a lot of confusion with people saying, well, was this ever a lawsuit? Yes, it is. I haven't had time to go through it. We haven't gone through it, but yes, there is a lawsuit in federal court. Of course, we see Baldoni's side saying it was only filed because there was criticism online about it not being filed, and that's the only reason it's filed. So that lawsuit and the lawsuit we're going to go over today are both now before the same federal judge. They have been not consolidated, but they have been deemed to be related cases. So those cases are all with the same judge. That's not unusual. That makes a lot of sense. They're clearly related. It's almost all the same parties, or it's largely all the same parties, I should say, because Baldoni's suit brings in additional parties with Ryan Reynolds, Leslie Sloan, and Vision PR, but it's largely the same parties for both suits. So this is a great question. Rhapsody in Blue asked, why are the suits being filed in New York if the specific law was broken and being cited in the suits are in California? It's jurisdictionally weird to me. Yes, and why choose to file it in federal court in New York and not federal court in California? I'm not sure. I'm interested in when we'll be able to suss out the strategy there, because this is a strategic decision. However, there was a lot of action in these that happened in New York because a lot of the things took place in New York. A lot of the filming took place in New York. I imagine from what has been revealed in the lawsuits so far that the contracts are all in California because that is where the contracts were made and signed, and that the contracts likely, and this is an asterisk, have a choice of law provision. I don't know if that states it in the federal lawsuit from Lively. We haven't been through that one, but I am assuming that there is a choice of law provision, meaning the law from this state governs, but it doesn't mean you necessarily have to file in that state. The strategy between picking court in New York versus picking court in California, I'm not sure. It could be that because Lively chose to sue in New York, Baldoni et al. Were like, okay, if we're in federal court, we're in federal court. Let's go. Let's just be in federal court in New York, because Baldoni et al. And Wayfarer sued the New York Times in California and in California state court. So there's a lawsuit in California state court, New York state court, and 2 in federal court in the Southern District of New York. I'm interested in what the strategy is behind that. We will see. I don't know what the strategy is behind that, but we will see. Let's see. The Junk Farm in the chat answered a question. I'm going to try to grab this real quick because I saw it answered a question that's going to come up later. So I'm saving that. Thank you. Thank you for that. So that's the amount of cases we have. Kitty, this might well be the case. Kitty said no cameras in federal court. That's why. Which, again, I would think that these parties seem to want this to be in the public, that this would be in state court, but maybe not. It's just, I don't know. It might be the reason. Neophyte Review said, sorry, I'm lost. Wayfarer is in the furniture company. No, Wayfarer spelled differently, the production company for the movie that is partly owned by Baldoni. It's a lot of lawsuits. There's a lot of strategy behind that, and we will see what the strategy behind that is as this plays out. It took a while for me and Depp Heard, excuse me, my drinking coffee and the lips got weird. In Depp v. Heard to really see the strategy behind the filing in Virginia. It started becoming more clear as we looked at the laws in California with the anti-SLAPP and the fact that there was, at the time of filing, not an anti-SLAPP in Virginia that worked the same way in California. There can be strategic decisions on where to file to get into discovery, not to get into discovery. I think we will probably see anti-SLAPP litigation in the New York Times suit. It's interesting seeing that the New York Times suit was filed in California that has that anti-SLAPP law and not in New York. It leads me to wonder if the New York reporter shield laws are stronger than in California, I don't know, but we will see. So why are they followed in New York? We'll see what the strategy is there. And it could be as easy as this is where we think we have the best venue. Also, California state law is going to take longer. Like California state law is just going to take longer. And the state court in the state court in California with the New York Times lawsuit set the very first court date for May. It's California courts, especially state courts, are so backed up that one's going to take forever. It might simply be that this will resolve faster and not be as expensive going through the federal courts in New York. It could be that. We'll see. So I think we will see anti-SLAPP litigation or venue jurisdiction litigation in the state case. We're not there yet. Nobody's filed yet. Those are going to take forever. Then we will see what happens down the road. Barry SD said, would you interview Baldoni's lawyer? I mean, when this is all done, sure. We still haven't gotten to interview Saltz yet when things are done. But while it's ongoing, no, I'm not a reporter. I'm not going to interview the lawyers on either side. I cover court documents. I'm a legal analyst. I tell you what I think of the lawsuits and what questions I have and see if those questions get answered. And that's it. Like there's questions here. I want to see what happens. So I cover how the lawyers lawyer. Sometimes I think the lawyers are overwrought. Carrie Morrissey has caught a lot of smoke from me about the filings rewriting history because it's so much. It's so much. Spyro hasn't really caught much smoke from me in the Jay-Z case because the federal court did it first, but some of Spyro's filings going after the other attorney just became so much. And I covered that really on Peter Lawyer His channel. We went over that. It's just wild. Annalise said, Emily, what are your thoughts about this case? Who is looking guilty? I am not here to cast judgment on who's looking guilty, who's looking not guilty. First, these are civil cases. We're here to talk about civil liability. I don't talk about the parties until we see the parties testifying, and then I will give you my thoughts on the parties. What I will talk to you a ton about is how the lawyers are lawyering, what the strategy is that we can see or not see behind the lawyering, what things are specifically needed, and what things are maybe not specifically needed in a filing, but thrown in there anyway. We'll talk about the allegations in the shade. We'll talk about the sassy footnotes. We'll talk about the lawyers. We'll talk about whether or not the lawyers say, what if anything, 1,000,000 times over in a lawsuit to the point where I don't even want to listen to them. We will talk about the lawyers, but we have a rule in the chat of no name calling because we're going to wait to see. Also, I think what we learned well from the Gwyneth Paltrow case is that people can look at a party and then look at the evidence as it comes out and go, oh, well, that's not as it was presented in the filings. That's not as it was presented in court. That's not what happened at all. Also, in the filings, in a lot of the cases, as things come out in trial and you have more context, we learn more. So what's going to happen in a case is we're going to talk about where there's strengths, where there's weaknesses, and where there's questions, and go back and forth on that, because until you see people testify, you never know. You never know. Even with text messages, you see what the text messages say, but for those to be evidence in court, you also need to bring in the evidence that's gone through the process to be evidence. Because right now, the reason I talk about these being receipts, it's not evidence yet in the court sense. In the court of public opinion, probably. In the court sense, none of this is evidence yet. It hasn't gone through that process. Will it be evidence down the road? Probably, but we will see it. We've seen the way lawyers talk about text messages. I'm always going to call back to watching with secondhand embarrassment as a lawyer is sitting there going, did I read that correctly? And all of us screaming, no. I mean, you read it correctly, but you interpreted it wrong. Like, am I reading that correctly? Sir, that's not what that means. Because once you have the context for a text message that's been pulled out of context in trial, you can see all of the meaning. So we will get to all of that. We are at the complaints. The complaints are allegations and shade. And these complaints, all of them, are so much shade. They are so much shade and allegations. So we'll go through all of it. RK said, I can think of other uses for your neck. Yes. And we were all screaming at Rottenborn saying, oh my God, that's not what that means. Like, it's obviously not what it means. But lawyers are going to lawyers, right? That's what their job is. Lawyers are advocates for their side. Civil law is not incredibly civil. I worked, a lot of you know this, some of you don't, who are new. A lot of you know this, but when I worked, before I went to the DA's office, after law school, I worked as a research attorney. And working as a research attorney, I took in documents from both sides and went through the documents and worked with the judges on what was legally proper. Were there times that I was in my head as annoyed with filings as I have been in this and other cases? Yes. If Carrie Morrissey had filed all of those filings across my desk as a research attorney, I would have sat there out loud and been like, what in the ever-loving fuck is this? Like, this is your fourth motion. This is your fourth motion rewriting history. Are you fucking kidding me right now? This is a waste of everyone's time. So as a research attorney, you take them in and break down and distill the legal arguments. The rest of it goes. The court doesn't want to hear it. And we see that sometimes with the courts. And there's times it's fine. And there's times it's annoying, truly, when attorneys are making their record and the court's like, I don't want to hear any of that. It's like, excuse me, we do? We do? We want to hear it, though. We would like to hear it. We would like to hear it. But there's times that courts will say, I don't need any of that. They want to strip it down to what are the facts that go to these causes of action. And I don't need the rest of it. We just saw the federal court do that in the Jay-Z case. The federal court was like, stop it. Stop it. We don't need all this back and forth. We're going to get all this back and forth early on in these cases, and we're going to get a lot of it. And then we might get a federal judge that's like, no, we're not doing that. And we'll see. We'll see what the judge does. But at some point, the judge is going to say, stop. Right? So we're going to go through these the way that I see them as the documents. I said it on Thursday. I think I spent like 10 minutes saying it on Thursday, that we're here to call balls and strikes and take a look at the lawyer's lawyering. I'm not here to tell you if a party is wrong or a party is right. That's not what we're here for yet. We're too early in the process. I have been an attorney almost 20 years at this point. And what I can tell you for sure is we do not know all of what's going on in these cases, even at all. Even at all. Not even close. Like, we don't know even a fraction of what these attorneys know. We're just not there yet. So we'll see what the lawyers say. We'll see how strong their claims are. There are some claims in the initial Wayfarer federal complaint that may not survive. We'll see. There are some causes of action that we just don't know yet. So how do I think the sides are doing in this? I think we're going to get a lot of fighting in the media, and we've got two very different perspectives from the parties on this case, and they are painted so differently. Is the court of public opinion already decided what's going to happen? Maybe. Is it possible that one party wins the court of public opinion and doesn't win everything in court? Also maybe. We've seen it happen. But we've got a lot of lawsuits and a long way to go, and that's if they get to trial. I don't know if these parties are inclined to settle, but there's going to be a long way to go in all of this and a lot more to come. So what I said on Thursday and what I've said again today is try to keep an open mind on these cases. Remember that what is in all of these filings are allegations at this point. Will those allegations be proven to be true or not? We will see. But at this point, we do not have all the information in this case. We're not going to have all the information in this case yet. So I try to say keep an open mind, but not everybody wants to keep an open mind in this case, and that's okay too. But I'm going to call balls and strikes. I'm going to talk about the attorneys and how they're lawyering. And I know that, again, like all the other cases that I've covered, if I don't like what the attorneys are doing on the side that you like more, I get that that's frustrating and people get frustrated. But when the attorneys are overwrought, I'm not going to tell you anything different than this is overwrought. Some of the things in these lawsuits are just not legally significant. They're not. I'm not going to tell you that they are legally significant if they're not. Does that mean that the attorneys didn't have a purpose for putting them in there? No, not at all. Of course the attorneys had a purpose for putting them in there. Was it needed? No. Am I going to tell you that? Yes. Because, again, there is no need for a 179-page complaint for the court. There's just not. Is there for the public? Yes. Is it advocacy? Yes. Again, is it all legally significant? No, it's not. Does that change anything? Is the court going to say, what in the world is this? No, the court's going to say, okay, are we done yet? And the court will start imposing page limits as we get there. The federal rules say a short and concise statement of the cases. Are any of these a short and concise statement? No, they're not. Have we seen cases that are? Yes, they are. However, these parties are fighting lawsuits on multiple fronts. So they are going to be fighting lawsuits on multiple fronts, and they're going to use the lawsuits to do that because of litigation privilege. That's why. It's litigation privilege covers what you say in a lawsuit. And so are the things that we are seeing in some lawsuits crossed over and answered in other lawsuits? Yes. That doesn't happen very often. Normally you see it within the same suit because you have a lawsuit and then you have an answer and then you have the rest of the litigation. Here we're seeing one filing address another filing that's not even in the same court, but they are addressing both what is going on in court and what is going on outside of court. And there are, it seems, going to be two tracks in these lawsuits: what's going on in court and what's going on outside of court, because these are going to have both going on. Marilyn, I didn't see this. Marilyn said, EDB, are you going to cover Sarah Boone's retrial news? If there is retrial news, yes, I haven't seen that. But I spent a lot of the weekend, A, reading hundreds of pages of litigation, and B, trying to figure out what the fuck was going on with TikTok. So I have not seen that. For all of you that says there is breaking news, I generally do not cover breaking news. I think you guys can understand why. But if we have time for it, we will talk about it. But I see that you guys are saying that there's been more stuff that's out there. If we don't cover it today, if we need to cover it, we will. I generally do not cover things that aren't in court filings. So we'll see. Will I cover it on stream yet? Probably not. I don't think we're going to have time. So we'll see. But do I cover stuff that is breaking while I am streaming? Often not. Do I cover things outside of the filings? Also, often not. So let us continue with all of this, because we got through the initial position statement of this, and then we will go through it going forward. So let's see. Shelly Ann said, with so much hate for Lively, it will be hard to select an unbiased jury if it gets that far. I wonder, well, I mean, we saw that too in Depp Heard. They always find a jury that doesn't care, doesn't pay attention. And that went on for years. So I don't know if they will or if they won't. So we'll see. All right. We got through quite a few pages. Are we going to go through all 179 pages today? I don't know if we will, but we are going to get through the things that are pasted into this that we haven't gotten through. But first, as we go through this suit, and as I tried to condense this, I did a terrible job of condensing it for Quick Bits because Quick Bits were over an hour long because it's so much stuff in these lawsuits. We did not go through all of the causes of action. And I've said there's some causes of action I have questions about. So I want to take a look at the causes of action first. And then as we go back through all of it, see what causes of action we have and then see where we go. This is true. Lexi said, EDB said in previous videos that what would happen when she was a research attorney is they would stop reading at the page limit. It depended on the filing, but yeah, often we would. Because one of the judges I worked for was like, the page limit is the page limit. We stop at the page limit. Some judges were like, we'll see. And some judges were like, if the attorney asks for extensions on page limits, then we'll allow it. So one of the things that was asked earlier in the chat is, why are these in New York and operating under California law? Here's footnote 24 that talks about that specifically. What we are looking at now is the lawsuit that we covered on Thursday, in part from Baldoni et al. Going forward. So, civil extortion is the first cause of action. Footnote 24. Lively has contended that California law applies to any dispute involving plaintiffs or the film, without conceding that Lively's statutory claims are properly brought, and without reservation of all rights and remedies, plaintiffs assert their claims under the substantive laws in the state of California. Here's what I think. I think that this is a choice of law provision in the contract. That is very common. That contracts say this contract is governed under the laws of whatever state. If there's not a choice of venue provision, it means you can file it anywhere. But there are both, depending on a contract, choice of law and choice of venue. So if there's a choice of law, then we will go there. So I saw a couple questions in the chat. Aaron is correct. It is a sexual harassment suit. There are no allegations of assault here at all. It is all sexual harassment claims in the federal suit. I went through all those claims and lined out all 13 of those, and we'll just link both lawsuits down below so that you guys have them if you want to read them. So this footnote, I think, gives a part of it. Law Junkie said, is it even sexual harassment or just harassment? It's both. In the Lively federal suit, it is sexual harassment, retaliation, and failure to investigate harassment. It's all stemming out of workplace sexual harassment, retaliation, and aiding and abetting the sexual harassment and failure to investigate. Those are all work-related claims. So that is what is stemming from that. Let's see. So I think there's a choice of law provision in the contracts. We haven't seen the contracts, but that would be my guess. If the court wants it to change, we'll see. So we'll see. This cause of action I've got questions about. When we go through this, I understand their cause of action against Lively and Reynolds. I don't understand the cause of action as well against Sloan and Vision. Also, this seems to be all plaintiffs against all defendants. I don't know if we're going to get to civil extortion for all plaintiffs. I think this specifically goes more to Wayfarer, Baldoni, and Heath. I don't think this goes to the other plaintiffs, the other PR agents. So I think we'll see this tailored down. But as it's written, it is all plaintiffs. I don't think we see allegations of extortion as to all plaintiffs. But as we go through it, that is one of the questions that I have. I think it's going to be narrowed down between those three plaintiffs and Lively and Reynolds, because I don't think there was any statements about Sloan, but maybe there are. So we'll take a look. Plaintiffs hereby reiterate everything above, which we're going to go through. Defendants made threats to plaintiffs that they knew to be wrongful, including threats to breach contracts, defame plaintiffs, and injure. So that is the heart of what they say the civil extortion claim is. And there is something very loud outside my house. And for that, the threats included demands of money, property, services, or other sources of value. We'll go through those. And that plaintiffs complied with the wrongful demands. So we'll see as we're going through the civil extortion, what are the demands, and were they complied with, and were they money, property, services? And they were harmed, defendants' wrongful threats, and demands were a substantial factor in causing plaintiffs harm. So we will see those as we go forward. Why did it blip all of the screen? I don't know. Oh, it's because I'm using the wrong browser. That's why. So we'll put it up so it's cleaner. Why? Because I hate looking at the URL line because it's distracting and not cute. All right. But we've got both lawsuits pulled up. We are looking at that should be better. Let's see. We are looking at the causes of action so that we have context as we go through all of the different claims. All right, let's go back to, well, really the end, start at the end, back to the beginning. Again, civil complaint, New York, January 16th, Wayfarer Studios et al., which is Baldoni, Heath, it ends with us, Movie LLC, and then the two PR agents, Melissa Nathan and Jennifer Abel, against the defendants here, Lively, Reynolds, Sloan, and Vision PR. So as we get to the end of this, so we can go through the causes of action, because scrolling through 179 pages is going to never be fun. We were looking at the extortion cause of action. Again, we will see. I don't think this will end up being all plaintiffs against all defendants. I have questions. Because it really, we'll see. I've got questions. Second cause of action, defamation, and this is against all four defendants brought by all plaintiffs. And they are saying that all defendants made statements about all of the plaintiffs to the New York Times, which includes the PR companies, the businesses. Again, we'll see how this shakes out. I think this has more, a lot of it's information and belief, but it doesn't stretch the imagination to think that if you have the PR agent talking to the New York Times and the parties talking to the New York Times, that they were talking about all of the plaintiffs here, because all of the plaintiffs, to the best of my memory, were in that New York Times article and are brought up in the New York Times civil suit, more so than necessarily the extortion claims. Defendants made, and this is all of them, one or more statements to persons other than plaintiffs, including the New York Times. So this is the New York Times through its agent, the reporter, who had those conversations. And they say that the heart of the defamation here is that the statements made were that plaintiffs engaged in, permitted, or failed to prevent sexually inappropriate conduct towards Lively and others. That's all those causes of actions that we went over in the New York suit, or that I spelled out. We didn't go over them thoroughly. And that plaintiffs retaliated against Lively and others for reporting the alleged sexual misconduct, including propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. I think it's a really concise statement of what the article alleges and what's alleged in the Lively suit. That's pretty much it in a nutshell. That's what's alleged, that there was complaints made about inappropriate behavior on set, that those complaints were not taken seriously, and that there was retaliation afterwards for it. I think that summarizes the position of the other federal lawsuits, that the persons to whom defendants made those statements reasonably understood that the statements were made about plaintiffs, I think that's clear. Statements made by defendants were intended to and did have the effect of exposing plaintiffs to, and this is all the languaging for defamation, right? Hatred, contempt, ridicule, obloquy, or of causing them to be shunned or avoided. And again, this language is all very specific to defamation, and of having a tendency to injure them in their occupations. Specifically, the persons to whom defendants made the statements reasonably understood the statements to mean that plaintiffs had engaged in, permitted, or failed to prevent sexually inappropriate conduct towards Lively and others, and that plaintiffs retaliated against Lively for that reporting. I think it summarizes what was said. And then they go through the rest of the statutory allegations, saying that it caused harm, that it was communicated to third parties. I mean, more than that, because it was in the New York Times. Third cause of action, false light, invasion of privacy. This is in both of those federal suits and in the New York Times suit. This is all. But the reason I pointed out what we were talking about, or the reason I pointed out which plaintiffs, which defendants in cause of action 1, this one narrows it down. This is some of the plaintiffs against the defendants, not all of the plaintiffs. The company plaintiffs aren't in here. I don't think they can be legally, but this narrows it down where cause of action 1 does not narrow down the parties. It's all plaintiffs against all defendants. And I think we'll see that tailored later. So this is not all plaintiffs. This is some of the plaintiffs, the non-companies, against Lively, Reynolds et al. We went over false light, invasion of privacy when we talked about the New York Times suit, but it is that casting in a false light. It is the impression. It's a California specific cause of action. I do not know which different states have a false light invasion of privacy. This is under the California Constitution. It is similar but different to defamation, but it is leaving that impression. It is a casting someone literally in a false light at its most basic recitation. So they go on to spell that out, saying that it casts all of the plaintiffs in a bad light by disclosing professional decisions, things about moral character, private life, and family, which show Baldoni, Heath, Nathan, and Abel in a false light. So another way of saying, look, what they said about me being all defendants, no, all plaintiffs in this case, what all defendants said about all plaintiffs, not the companies, is not true. And it portrays us in the wrong way. And that subjects them to scorn, pity, ridicule, humiliation, and other suffering, and that was done with a reckless disregard. It'll be interesting to break down the differences, if we want to, between false light, invasion of privacy, and public figure defamation. I imagine that as they are going through the strategy on this, that the false light invasion is going to stay through all of this, because it has different quirks than that actual malice that you see in defamation, which is an interesting thing about California law. And I wonder if that's why they're not going to fight California law maybe as much, because then you have this cause of action. So this is damage to professional businesses, reputations, etc. So the conduct of defendants described herein was a substantial factor in causing plaintiffs Baldoni, Heath, Nathan, and Abel's harm, constituted a serious invasion of their rights to privacy, and was an egregious breach of social norms that shocks the conscious. Again, standard languaging for that cause of action. Fourth cause of action is the breach implied covenant of good faith and fair dealing. This is against Lively only because Lively is the one that owes that duty under contract to probably not everybody. I would imagine Lively owes that duty when we get to it to Wayfarer, the company. I would have to think about whether that extends to Heath as a member of the company and to Baldoni as the contractual obligation to be in the movie. I don't know if that covenant of good faith and fair dealing is owed between Lively and the PR plaintiffs here. And I think we'll see some of that get narrowed down as well, because I don't know how you get to that duty with the PR company that Wayfarer hired. So we'll see. Again, I think some of these are going to get narrowed down. They say all of the conditions required, if any, for Lively's performance had occurred, or in the alternative are excused. That's contractual obligations. Lively engaged in conduct that prevented plaintiffs from receiving the benefits contemplated under the contract, specifically, which I appreciate because they narrow this down. There's a lot in this complaint. There is so much in this complaint, but narrowing down what we are talking about matters. Lively interfered with the production by making repeated threats and demands in order to seize creative control over the production, editing, and marketing of the film, such that defendants were deprived of the opportunity to produce, edit, and market the film as contemplated by the contract. This cause of action is really going to go to what is in the contract, what is Lively's role in this movie, and then what role did she take on? None of the other stuff. Which is why I don't think this is going to go to the PR plaintiffs, because I don't think that contract really impacts them. They don't have a contract with Lively. But this is going, if this is outside of the contract, if the behavior is outside of the contract, and we haven't seen a response to this in any of the lawsuits, because the Lively suit came before this one, and it is silent as to creative control of the film. But if creative control of the film is outside the contract, then do you have a breach of contract? I think that's really, when we talk about factual bases, isn't going to be factually difficult to prove. What does the contract say? And then what happened? It's going to be what it is, right? At the end of the day, where a lot of these causes of action are not going to be nearly as cut and dry. This one will be more cut and dry. But again, I don't think that goes to the PR company. And I think we'll see this narrowed down too, because I don't think that goes to the PR company. Fifth cause of action, intentional interference with contractual relations against Reynolds and Lively. We went over this on Thursday. This, again, is going to be one of those things where you should be able to see if these conversations happened, and then you would get either a yes, no on this. So the contract, again, this is not going to go to all plaintiffs. This is going to go to Wayfarer and Baldoni specifically. I think we'll see this narrowed down. There's nothing alleged anywhere that the PR agents had a contractual relationship with William Morris Endeavor, referred to as WME, throughout this. There's no indication of that. I think this cause of action will get narrowed down between Baldoni and Wayfarer and Reynolds and Lively going forward. So we'll see. But they say that Lively and Reynolds prevented performance of the contract and made performance more expensive or difficult, specifically upon information and belief, which means discovery needs to happen here, because discovery needs to happen here, that they say Lively and Reynolds made threats and demands to induce WME to cease performing under its contract with plaintiffs. That is going to come out in emails, discovery, in depositions, and the rest of it. So we'll see. Defendants, they say Lively and Reynolds intended to disrupt the performance of this contract. Plaintiffs were harmed. Defendants' conduct was a substantial factor in causing that harm. Again, we know that Baldoni was dropped pretty quickly after the New York Times article. I don't know the dates. So again, we will see. Some of these are going to be, did the thing happen or did the thing not happen? And I think the last two causes of action are going to be, it happened or it didn't. I think some of the other causes of action are going to get a lot more difficult. Sixth cause of action, intentional interference with prospective economic advantage. It is a similar but different cause of action for that contractual relationship. Look, this relationship could bring future economic advantage. This relationship was interfered with, and therefore you don't have that future economic advantage. This again will get pared down to the same plaintiffs. I don't think we have anything to do. I don't think this has anything to do with the PR agents. Seventh cause of action, negligent interference with prospective economic advantage. Same as the one above, and a different standard because it's negligence. It's a lower standard, that they knew of the relationship, defendants Lively and Reynolds. They knew or should have known that the relationship would be disrupted. And this lawsuit alleges that that was the intent. The intent was that the relationship would be disrupted and that they failed to act with reasonable care. We see these conversations in the Stephanie Jones lawsuit as well, the interference with contract, the interference with relationships. We see that in that other suit. And then the prayer for relief that we went over. So that's the questions I have. I think some of these causes of actions are going to get narrowed down because I think some of these causes of actions are specifically between Baldoni and the company and Reynolds and Lively, and not the PRs. So that's what I'm looking for as we're going through this. I'm going to zoom back up to the top so that we can zoom back up to the top and then pick up where we were on Thursday, because we got through the very wrought beginning of it, but we didn't get into all of the text messages. Some of them I covered in the New York Times lawsuit because we went over that page by page by page, but not all of it. Nita asked, why also add PR then? I think some of the causes of action do involve Melissa Nathan and Jennifer Abel. Melissa Nathan and Jennifer Abel are looped into the New York Times suit. So when we got those defamation causes of action, they're looped in here. In the other causes of action, they're not. And that's fine. You can have lawsuits with like these plaintiffs versus these defendants. It just wasn't narrowed out here. And I think that it will be. But again, when I have questions, I'm going to tell you what questions I have. So I have questions about that. But with the defamation, the allegations of defamation are that, look, none of this was true. You're alleging a smear campaign. This lawsuit says that smear campaign isn't true. Like the whole argument here is you wrecked it for yourself. This was all organic. People were frustrated and they were mad. The two lawsuits, well, the complaint and the civil federal lawsuit by Lively's side say, no, there was a negative PR smear campaign. That's the retaliation. This side says there's no retaliation from us. We got PR to combat what we thought you were going to do, not to proactively plant stories. There are some questions when we get to all of the text messages about that, because there are some questions when we get to the text messages about all that. So we'll go through them when we get there. M said, I mean, I saw people dislike her because of her own behavior. I didn't see anything that suggested retaliation. And we'll have to see, because it might well be the case that people were just like, ew, what? There are some text messages that I have questions about. We will talk about the text messages I have questions about once we get through all of them. So there are some things that I still have questions about, and we'll go to it. So I've never seen a PR campaign being the workplace retaliation that's alleged. That's a very different type of retaliation. In workplace retaliation, you often see things like people being fired is a very common form of retaliation. You see allegations that a boss has kind of called others in the industry to try to block somebody from working again. Those types of things in retaliation. You see people who file retaliation lawsuits, and in working in civil, you see them unfortunately too much, but people ask for accommodations at work and then all of a sudden are demoted, or people bring up inappropriate behavior in the workplace in a lot of different ways, and then are demoted, fired, reduced from full-time to part-time. That's normally how we see retaliation come up in employment litigation. I've not seen retaliation alleged like this. It seems to be incredibly specific. Does that mean it didn't happen? No. Does that mean it did happen? No. Does that mean it's going to be difficult for courts and I think for lawyers to explain how this pattern works under the law? Yes, it's a different context than we normally see. But does that mean it doesn't happen? I don't know. So we'll see. All right. Baldoni and Wayfarer purchased the rights to It Ends With Us. We had gotten right around to this part, when I had to leave and get my nails done. So Baldoni co-founded Wayfarer in 2019. From the beginning, Wayfarer was dedicated to being a different kind of studio, one that produced world-class entertainment driven by a powerful vision for change. So, hey, this is different. We have a purpose beyond just being a movie studio. Cat in the chat brings up a point that we're going to talk about more as we get through this. This is not a normal workplace. Yes, this is not a normal workplace. And that is going to make all of this a very different kind of a suit to go through, similar to what we've seen back and forth in the Lizzo suit. So we need, a lot has happened in the Lizzo suit. We need to check back in with the Lizzo suit. But in the California, I think it was in the anti-slap ruling from the judge, and it's been a minute since we've gone through that, but I believe it's in the anti-slap ruling by the judge in the Lizzo suit. The judge was talking about the difficulty of putting workplace norms into creative workplaces, something that might be completely out of left field in a workplace that is a more office setting, is not necessarily completely out of left field in a creative work environment. And the judge went back and forth. It's been a while, but the judge went back and forth with, how do we discuss workplace norms in a creative environment? And how do we navigate workplace norms in a creative environment? And where are the boundaries of that? And so in the Lizzo suit, there were allegations of discrimination, sexual harassment, and more, and discussions of weight and other things. And the judge was talking about, look, when you're talking about costuming of a dancer, how do you talk about costuming of a dancer if you don't talk about the dancer's body in a way that might not be appropriate in an office setting, but might be appropriate in a creative setting? So how do you balance the two? And that is absolutely going to be a challenge here as well, because in the creative process, you're going to have conversations that might not be okay for your boss to come up and say to you in a more traditional workplace. It's the same with, did we cover, I don't remember how long it's been since we covered some of the moderation lawsuits on social media, but it's the same there, that the videos people see in moderating social media platforms are not things you'd normally see at work and would not be okay at work, but when it's part of your job, it's different. So yeah, there are going to be some difficulties here because it is also a creative work environment. And that's where you're going to see, if depending on how this goes down the road, that's where you're going to see experts in the industry coming in the way we saw in the Baldwin case in Rust. You see experts coming in saying, look, this is how movie sets are supposed to work vis-a-vis how a normal how a different type of workplace would work. I don't want to say that movie sets aren't normal. They're normal for normal places. So Baldoni, whose film career was dedicated to producing and directing meaningful films and to have a positive impact in the world, was deeply moved when he read the book It Ends With Us and genuinely believed he could make a film that could save lives. His last 2 films were created as a result of a deep sense of responsibility to share meaningful stories. We are not going to go through the entirety of the resume because it's not really legally significant, like at all. But we're not going to go through the resume portion of this. The resume is, look, he has a history of making movies to have impact. That's what he was doing here. And that's why he signed with this movie. The legally significant part of this is, hey, he signed this movie because they are alleging a takeover of this project that they owned from the beginning. And so they're going back to, yes, we owned this from the beginning. When It Ends With Us, author Colleen Hoover watched 5 Feet Apart, a previous movie, in theaters. She told Baldoni, "You are the right person to make this movie," referring to It Ends With Us. The early emails demonstrate his commitment to doing so in a manner he envisioned that would be most impactful. In fact, it was Hoover who suggested Baldoni portray the lead male character, Ryle, which they have in the emails. When you look at juries who are going to look for information that is persuasive, and ask yourself this too, when you've watched trials, if you've watched trials all the way through, are the things you get that are happening in real time then not testimony necessarily that comes after? Does it change how you see something? Do you tend to put more weight on what people were saying in the moment versus what is said after years of litigation and depositions and what have you? Is that more persuasive to you? And I wonder if we will see that in this case here. Will it be more persuasive what was said at the time versus what is said later? So this is between Baldoni and Hoover from February 1st, 2019. This is an introduction. Such a pleasure to meet you. Thank you for being open to having me potentially option your book. Quick backstory. And then he talks about who he is, how he approaches things. If you'd like to see an early screening, I can make that happen. Where are you based? Wanted to say the reviews I read for this book. This one stood out to me and makes me so excited to potentially work with you. Your fans love you. What a gift you have. And then it looks like it copies and pastes within the email a review of the book. Of all the heroines I've ever read, Lily was most certainly one of the ones I admired most. I loved her from the first few pages, but having finished the book, I truly couldn't be prouder of her. And then it goes on with a book review that he said was impactful to him. Yes, please send over the ebook, but I also just purchased it on paperback as I like supporting authors. Looking forward, Justin. So it sounds like as of February 1st, he had heard of the book and was reading the book and was ready to talk to the author about the book. So, and then we get the next email in what looks like a thread from April between Baldoni and Hoover, or from him to her. Colleen just finally coming up from air from the release of a film, but shooting Jane for another 2 weeks, referencing Jane the Virgin. By the way, were you able to see it? Would love to get your thoughts. We actually start filming the final episode today. Crazy. So I haven't been able to get It Ends With Us out of my mind. Such an important story, so damn romantic and beautiful and tragic and hopeful. I always say that both in art and in life, the best stories are always 2 things at once. And this is so much of what your book is, which is interesting. These lawsuits are like a million things at once. He says, this is what your book is: joy and pain, love and sorrow. You did a beautiful job of covering incredibly difficult subject matter and playing it out in a realistic and unforgettable way. But what I love most is the opportunity to let so many women feel seen on the script via this particular story. I can't even imagine how many women there are who are stuck in a relationship like this, and via this story couldn't find the strength to create a better life for themselves and for their children. There are so many opportunities to partner with organizations and create impact with a story like this. I love that you held nothing back from the pain of the character's past. I love that they really are no, quote, bad guys, and that we are the sons of our experience and our trauma. I love the opportunity for narration and the stunning and gorgeous impact of the title payoff at the end. So it's going through the book. On a separate note, the screenplay, 4 or 5 Feet Apart, was adapted into a novel and has been on the New York Times bestseller list. So I know you have your charity, and I would be happy to donate some copies for the Bookworm Box. Like, hey, I love your work. I love this book. I want to work with you. I think it matters. But we know that they owned the movie. This one is coming back in response. I'm sure nobody ever thought, like, these are all written genuinely in the time. None of these are written in anticipating litigation, right? None of these are written anticipating that this will ever end up in legal filings. I mean, there's memes online saying, right, like it's going to end up in a lawsuit, but they're not writing with that. And I think that is important. Nishay, I saw in the chat asking about 2005, the year Emily became a lawyer. Yes, it is. I know. It hurts. It just feels so long ago. Colleen, and not at all at the same time. Colleen Hoover responds saying, and that's the author of the book, "Thank you so much for the email. I wasn't expecting you to read it so quickly. I would love to talk with you more about the project. You quote unquote get the book." I think they included all of these emails so that there was context to include this email, showing that everybody was on board with the with the movie being made and the thought behind it, because a lot of the allegations in this lawsuit center around the marketing of the movie, where Lively's suit says that Baldoni went quote unquote rogue on the marketing of the movie to cover for why the rest of the cast didn't want to be seen with him. He says, no, this is always how we saw this project from the earliest days, and we were marketing the movie the way we felt after you excluded us from the movie. So we were doing what we wanted with the movie all along. We weren't doing this as like quote unquote cover. So that's when we're seeing these play out, I think that is the reason this is in there. Does it need to be out, or does it need to be in the initial complaint? No. Is it going to be in a suit that's so high profile? Yes, because if you're the lawyer and you've got this email, you're like, look, we said we weren't doing this as quote unquote cover. You excluded us. This is always what we wanted. Here's the emails from 2019 showing this is what we always wanted. That's what it is. Let's see. Thank you for your email. I wasn't expecting you to get it so quickly. You quote get the book. That's the most important thing to me. My biggest fear is that I'll option it to someone who thinks it's a hot romance and they'll take it in the absolute wrong direction. I expect that we will see this part of this email come up in this case a lot, especially as we get into what was the marketing plan in this movie. In the Lively complaint, they attached the talking points for marketing the movie that they say are from Sony. This lawsuit says supposedly from Sony. That does not necessarily align with this. So I think that this conversation is going to come up again. I really do. What do you guys think? I really, my biggest fear is that I'll option it to someone who thinks it's a hot romance and they'll take it in the absolute wrong direction. I'm going to be upfront with you about a couple of things so you can decide if you want to move forward. Also, appreciate this from the author saying, these are my concerns. Let's talk about my concerns. I've sold several film options and realized not all of them get made, and I'm okay with that. I mean, I think that is probably the case a lot of the time for authors. One of the film options was not a great experience. The producers started a fundraising campaign for the film without my knowledge or permission beforehand, and ended up taking over $100,000 from my readers. The film was never made, my option was never paid, and I ended up pulling the plug on the project, and the producers never refunded the readers their money. Can you imagine how pissed you'd be as an author? Like, authors live and die really by their communities. That's what pushes book sales forward today. So I get it. Like, I get it. And that sucks. So I feel terrible that my readers were the ones who were punished. And if you guys can hear my fan, I apologize. It's cold. It's cold today. It's cold in my office. I want to be positive that crowdsourcing is not something that will be done when it comes to this film. It's important to me that a funding plan is in place that won't affect the supporters of this book. Fair. Fair. I mean, fair. While that experience wasn't a positive one, I had a wonderful experience working with a producer on Confess. It was a 7-episode series that was picked up by Awestruck and Go90. I have no idea what any of that is. But unfortunately, right before it released, Go90 declared they were shutting down. Because of that, Confess released to an already defunct platform just a week before they were about to be shut down. What is Go90? Let's see. Luckily, my readers got to watch it, so not all was lost. And the overall experience was so much fun and very surreal. I don't really have a lot of involvement beyond reading the script and getting the dailies. I just handed it over and let them do their thing because I was immersed in other projects at the time. It Ends With Us is important to me, though. I would love more involvement on this film. I've actually been working on a script for it already, along with a producer friend of mine who lives in LA. She's redacted, dear friend of mine, huge fan and supporter of the book. We sat down for a week and outlined it last month, but I had to put it on pause because I'm on deadline for this book. I'm writing, which I can't imagine. I don't know how authors do it. It fascinates me. We can talk about books and authors and writing and all of it another time. I don't know how they do it. Fascinates me. Absolutely want a deep dive into what all of that is like. Today is not the day. We plan on picking it back up 2 weeks and diving into it. Even though I'm the author, I believe I've been able to separate myself enough from the format of the book to know what would make the best setup for a film. While I do want to please the readers who have read the book, I understand the need to make a film that will equally touch those who haven't read the book. These all seem very reasonable, right? All of this seems very reasonable to the author to say, hey, you're not crowdfunding my audience. And I want to have some involvement in this going forward. This is special to me. And these are kind of my boundaries on that. Let's just get it all out there. And it seems like those are reasonable. So when this suit says that they had a good working relationship until she unfollowed him, it seemed like they had a open communication early on. So let's, Rosalind, I tried to get this right. Rosalind, I'm missing the middle word, books. As a non-famous author, let me tell you, it's brutal. I'm sure that it is. And I wanted to pull it up, so people can go find your books, but also I'm sure that it is. I'm sure. Emily Outdoors said, I wonder how the author felt about Blake Lively not reading the book. I wonder if that's why it was in the lawsuit. Right? Because I also wonder. Let's see. Are you based out of LA? Maybe we can have a chat scheduling. Other than ensuring my readers won't be asked to donate to the fundraising of the film and hoping to have more involvement in the process when it comes to the script and production, I don't really have any other request. I realize your experience with film far outweighs mine, and based on the magnificent adaptation you did with 5 Feet Apart, I am confident you could do this book justice and that our visions will align. I watched the film 2 nights ago and immediately started the book yesterday. Sometimes I like to do it backwards. I think you did a wonderful job. And even though I'm not finished the book yet, I feel like the essence of it was captured beautifully through film. I wrote a book where one of the characters suffers from cystic fibrosis. So I've done a lot of research on this subject, and through Rachel and you, and thought Rachel and you did such an amazing job in a portrayal of what carriers of cystic fibrosis go through. And that's relating back to their earlier conversation in an earlier project. In fact, our very first donation through the Bookworm Box was to the Cystic Fibrosis Foundation. We donated in honor of a child of one of my readers. And then they talk about that, and they talk about the donations and who that child of the reader was. It's actually funny you emailed me when you did. when the email came through on the phone, I was on your website browsing Wayfarer. Love the hashtag #MeToo chat. Okay, that's enough rambling. I really do appreciate the email and appreciate you taking a chance on reading my book. My readers are so ready to support the book, and it has meant so much to so many of them. So naturally, I want them to be happy and to bring the adaptation they'll be proud of. Do you happen to read the author's note at the end of the novel? It's a quick read. If you don't get the chance to read it, my mother inspired this book, so maybe that's why I've been so hesitant to sell the rights to it in the past. I feel good about this, though. I feel good about you. I've seen your past work, your passion, and your love for humanity, and I honestly feel there's no one better for the project. Before I direct you to my agent, I just want to get your thoughts on the above. Thanks so much, Justin. I hope you and your family were able to get some vacation time in. Look, all of it goes to the author was on board with the vision of Baldoni as the producer and director of the film back in 2019. Colleen said, however this works out, I would love books for the bookstore. In fact, we just started a YA box and would love to feature 5 Feet Apart in the subscription box. If there's a way we can buy a few hundred copies at cost, everyone needs this book in their possession. And then Colleen emailing the next day, have you given any thought to whether or not, whether you would want an acting role in this, say maybe Ryle, the lead character? I could see it. So the author's like, look, this is the vision I'm on board for. This is the director that I am comfortable with, or I mean, not specifically, but you are someone I trust this project with. I trust the production of it with, and even I can see you in the lead role. So when they're saying, look, this project had a specific vision and direction, that goes back to 2019. They say soon after Wayfarer partnered with Sony to co-finance and distribute the film, which the author said, hey, I'm not doing this if you don't bring the financing for the film. Soon after, Wayfarer partnered with Sony to co-finance and distribute the film. Their agreement included, at Wayfarer and Baldoni's insistence, that the provision was a deal breaker, a requirement that 1% of the film's proceeds be donated in support of survivors of domestic abuse. That 1% was ultimately earmarked for the organization No More, with which Baldoni sought to partner with as early as September 2022. Again, there will be emails. They go on to say in footnote 4, stunningly later in the process, Lively refused the opportunity to meet with No More despite playing the lead role in a movie centered on themes of survival and resilience in the face of domestic abuse, which they've brought up a couple times in this and are not happy with at all. As they began making the film, Baldoni and Wayfarer felt an immense responsibility to do justice not only to the story of the protagonist, Lily Bloom, but to the stories of survivors around the world. Plaintiff Heath, CEO, expressed to Forbes, June 28th, 2024, his high hopes for the film. There's a footnote. That's probably the link to the article. Yes. And then a quote from the article. Again, this is June, so this is right before the marketing of the movie. This is after a lot of stuff went down, it seems. So I hope that people leave the theater feeling inspired, that for those who have been hurt, they feel seen, and that the story was told in a way that honored them. I feel like people who may in themselves, as someone that may hurt somebody may think twice about it. So I hope that people leave the film. It's an odd quote to put in the lawsuit. So I hope that people leave the film feeling like they got a glimpse into a world that oftentimes we turn our eyes away from. Well, that at the end makes sense. So again, our goal was this. That goal and vision were stolen from us. They say in casting Lively, a world-renowned actor with talent and charisma, in the leading role, they entrusted her with that vision to bring Lily to life. Although Wayfarer learned that Lively had a reputation for being difficult to work with, Baldoni at the time was not dissuaded and found her to be genuine. And then they get into the pre-production conversations between the two and the working relationship between the two. Baldoni says that this sets the stage for the working relationship going forward. They go on to say, on or about December 31st, 2022, Lively agreed to take the role of Lily Bloom. As part of subsequent negotiations, Lively was granted an executive producer credit, a title often given to talent of her stature. Lively had requested a producer credit, but Wayfair and Sony demurred, which means they just were like, yeah, we're not gonna do that. We're not gonna give a producer credit. We're gonna give an executive producer credit, and that's what we're going to do. They say that the producer credit would not accurately reflect the role she was asked to play in the production. So this is going to come down to some of the contracts in the cause of actions that we see later. This is going to come down with that good faith and fair dealing, right? The good faith and fair dealing is going to be, what does a traditional executive producer credit entail? Was what happened after that an overreach of what that entailed? Did it go grossly outside of that? Is it within the realms of that? That's all going to come up down the road. But what we saw from the Baldwin case is Baldwin saying, yeah, the executive producer credit, I'm an executive producer, but I don't hire anyone. I'm not in charge of these things, but it's going to change where your line is on the line sheet and what have you. Amy said, are these suits going to come down to the emails with Sony? Some stuff is going to come down to the conversations with Sony. Yeah, some of it is, especially when it comes down to whether or not the pressure to take over the film is part of the extortion cause of action. Yeah, what Sony was doing and saying is going to be important. Wayfair did not request nor require that Lively contribute to the film in any capacity beyond her role as an actor or executive producer. They might not have requested it. I want to know what's in the contract. We'll see. Claudia said, what does Sony have to do with this, though? Sony was the distributor, and when we get later on into this, and I highlighted them in quick bits, there are some text back and forth between Sony that Wayfarer says was Sony forcing them to sign off on stuff, and that Sony was pushing. So when we say, or when I said, when I said, as I was covering this Thursday, and even as we were covering the New York Times suit, like, how does this happen? Well, what they say in this suit is this happens because Sony, the distributor and partial financer, said, what are you going, stop it, do this. So it gets into how all this went down with the movie being taken over. They say it's hijacked. So Sony brought in the money, but Sony was also saying, can you just sign off on these things so we can move forward? Like, what are we doing? So yeah, Sony is going to come up in this a lot. And yes, Kazaros said we just rarely hear about it so public. Yeah, this is going to pull the curtain back on what's going on behind the scenes in all of this. So we will see. Let's see. So they say that Wayfarer partnered with Sony to co-finance and distribute the film. They say soon after. No idea when that happened. That's all going to come out down the road, because all of the Sony executives are going to be thrilled when they are deposed. We saw that in the executives' video depositions in Depp Heard, when you could see the executives. I don't remember which studio, but you could see the executives that were coming in that were not thrilled to be deposed. But yes, the Sony executives touching all of this are all going to be deposed. I imagine we're going to see huge requests for productions of emails and conversations and text messages and more. Sony is going to be pulled in. Thank you, Warner execs for Depp Heard. Sony is going to be pulled into this, not as a party, but as very relevant witnesses to all of this. So in casting, we went through that. So Sony comes on board. We're not exactly sure when. It's silent as to it, but before production, because money before production. On or about December 31st, Lively agreed to take the lead role of Lily Bloom as part of subsequent negotiations. Lively was granted the executive producer credit. Okay, we went through that. Eventually, we haven't seen the contracts yet. Eventually, the contracts will come up. They're very much a part of this lawsuit, and we will see what that entails, what the difference is between a executive producer credit and a producer credit and what that all means. I'm sure many of you that work in the industry know that. I don't, not an expert in movies by any means. But what those roles traditionally entail is going to be really, really relevant as we go forward, because they say that asking for dailies, asking to edit, and doing the rest of it was essentially an extortion takeover of the movie, not part of her role as an executive producer. Best Snow in the chat asked, is Sony being sued in any of these lawsuits? No. But is Sony involved? Yes. Sony's, in this point, a very necessary witness, like not Sony the company, but individual executives and representatives for Sony, because they were on set. They had a representative on set. Lively side says that Sony was in charge of the marketing plan. There are some discussions of the marketing plan in here. So there is a lot more to come from Sony. But is Sony a necessary witness in all of this? Yes. As far as the representative on set, the executives, Sony is neck deep in all of these lawsuits. Lively even felt comfortable enough to make silly jokes, redirecting a sweet compliment that Baldoni gave. Look, when I say there are things in lawsuits that I don't love, it is the editorializing. We saw this a lot in the New York Times lawsuit on what text messages say or don't say. We'll have to see. Some of the text messages in this seem to be screenshots. Some of them seem to be forensic extractions. Some of them we can tell where they came from. Some of them we can't tell where they came from. We will see as it goes. I call them receipts in all of this. They are not evidence in court yet. They haven't gone through that process yet. Will they? Yet. Will they? Yes. Have they yet? No. We'll see. So this was from May, it looks like May 11th, 2023. Me being like, wait, can we blow this up a little bit more? In what context? We don't know. Fist bump, well played. Lively, I feel the same. It's such a good feeling to get work done that we're proud of and to do it together. It just clicks when we find it. And that's just as rewarding as filming it or editing it or marketing it or releasing it. That is all storytelling. This is why we do what we do. So this is May 2023. I really want to know. Kristen said, you need to re-dye your hair. I'm going to do some of that tonight. I just haven't had time. I wonder if in May of 2023, there is an anticipation that Lively will be involved in editing. I don't know, maybe, but in these texts, is it, and we do it together, it just clicks, and that's as rewarding as filming it or editing it or marketing it. Is this her listing out the things that she expects to be a part of in the lawsuit? Or not in the lawsuit. Nobody expected to be in this lawsuit, I don't think. Is this the stuff she expected to be involved in the filming or not? I don't know. She goes on to say, thank you for your collaboration. I'm really proud of what we're doing. Again, is that a discussion of what they expect the roles will include? We'll see as it comes out. It's clear from later communications that the production team was not comfortable with how much Lively was asking for. I just want to see the contract at this point. So thank you for your collaboration. Really proud of what we're doing. Baldoni loved, I feel the same. It's just such a good feeling. And that's the above. Justin Baldoni says, I like sentimental Blake. Blake Lively says, never met her. Baldoni said, I also like asshole Blake. Don't worry. Okay, good night. And Lively says, I've met her, seemingly referring to asshole Blake. Lively says, so have my suppositories. Good night. And Baldoni laughed at so have my suppositories. So this, it doesn't read directly like a screenshot. I wonder if it's a screenshot between an Apple phone and a non-Apple phone. I don't know. But Lively felt comfortable enough to make silly jokes, redirecting a sweet compliment. I don't know if this is before or after, but it looks like they were getting along. At some point, that changed. But this is May. For all of you keeping dates, we're at May 2023, and they're like, Lively's joking about being an asshole. Okay, so May 2023, that's the date we're at. I know for all of you saying we need a chart. Yep. When was this vis-a-vis the timeline? I don't know. We'll get there. We don't have it yet. Lively begins asserting control almost immediately. Hopefully we'll get the date filming started before there was a break. Oh yes, I discuss my hair a lot with the law nerds. The hair becomes a group discussion, the group discussion. So no, it doesn't bother me at all when we're talking about the purple in the hair. I know people miss the purple in the hair, which is why I was addressing it. That doesn't bother me at all. It's something we talk about. The purple hair is because of the chat. We decided it together. So no, not a thing. It's a normal part of law nerd conversation. Do not worry. It is. Lively begins asserting control almost immediately. Hopefully we'll get the dates. Lively began inserting herself into the production process in intrusive ways well beyond the scope of her contractual entitlements. Again, we will see. Maybe yes, maybe no. Guess what? It was, we'll see. For example, Lively began to insist on creative control over her character's wardrobe. We saw this in the New York Times suit as well. I was trying not to cover so much of it because I had zoomed it in so that we could read the text messages. And then as I zoomed it out, it just got lost. All right. Let's see. What in the world? There we go. They say Lively began inserting herself and taking control immediately, was taking over control of wardrobe. Look, normally there's a whole department that does that. They talked about this literally verbatim in the New York Times lawsuit that she wanted $5,000 shoes, even though her character was just starting a brand new flower shop. And that doesn't make any sense for the character. And it cost everybody a lot of time and money because production had already gone through what the wardrobe was. And she said, nah, I'm going to redo the whole thing. In the New York Times lawsuit, they also talked about her needing to do fittings at her home, not fittings on set. We don't have dates for any of this, but we do know that from other filings that she was also had just had a kiddo and was just I think when they started filming 4 months postpartum. Do I put a lot of weight in that she required everyone to go to her place for fittings? I don't know when these fittings were taking place. And I don't know how close in time this was to her having a kid and if that was all agreed to or not. I don't know. The changing around wardrobe, I think, is more relevant than whether wardrobe was fitting at somebody's house or not. So, you guys are asking what hair dye am I using? I'll let you know after I try. And I'm trying something new. I'll let you know. For those of you asking how close was set to her home, I don't know. They say that this was onerous. It was difficult to get everything schlepped around New York to get to her. And there was not a lot of time for fittings and what have you. So we'll see. In an effort to maintain harmony at the start of their working relationship and to avoid further delays caused by wardrobe conflicts, the studio reluctantly ceded full control to Lively over the wardrobe. That concession quickly grew and proved regrettable. The first day of principal photography, I wish there was a date, but the first day of principal photography, these, again, the date questions will all get answered later. There's movie sets are full of lots of people, and those dates are going to be well documented. So in an effort to maintain harmony, they ceded control. The first day of principal photography, paparazzi captured and published photos of Lively in character wearing her hand-picked wardrobe. These images were widely reported as unflattering, footnote 6, and sparked backlash from Sony. So when we talk about how involved Sony is, from the way that they are portraying the lawsuit, and again, allegations and shade, they say, look, the paparazzi is just like, WTF is this? And Sony's like, yo, what's the problem? This will, again, all be documented in some way. They say that Baldoni received direct criticism from Sony, who voiced serious concerns about the impact of the photos on the film's public reception. So Marta in the chat asked about viral shampoo. Yes, love it. So when the first day of principal photography was, I don't know. It's before the strike, because there's a photography starts, then there's 2 strikes in Hollywood, and then principal photography resumes. Footnote 6 says, notably, Lively herself had voiced insecurities about the public perception of her casting as Lily Bloom. So they are trying, I don't know why this is a footnote. Is this just a sassy, shady footnote? Notably, Lively herself had voiced insecurities about the public perception of her casting as Lily Bloom. Lily is described as a 23-year-old young woman and a recent college graduate within the first few pages of the book, which Lively would have known had she read the book before production, despite having admitted to ordering a copy months before, which remarkably she ordered only after she had already committed to the role on December 20th, 2022. Nevertheless, when Lively learned that Lily was a decade plus younger than herself in the book, Lively asked the author Colleen Hoover to explain in a public casting announcement that they had decided to quote unquote age up the book's character for the film. Hoover didn't put that statement out in the way Lively requested. Lively was not happy. That's going to be a information and belief, but information and belief isn't even going in the footnotes. It's just a Lively was already pissed and was mad because she's not 23 and there were already issues starting on the first day of filming. So she was insecure. This all got worse. And now Sony is mad about the wardrobe and everything. First day of filming, everything's a disaster. And the author didn't put it out. I don't know how old Baldoni is. I don't know how old Lively is. I would presume that none of them are 23. I'm going to go with that. So we're going to go with nobody's 23. I don't know how old everybody is, but also I don't know. For those of you that read the book, is this supposed to be more of an age gap relationship or not? I don't know. So it seems the chat is saying Baldoni's 40, Lively is 36. Some of you are saying 37. So they are closer in age. So I don't know if chat is saying in the book they're supposed to be the same age. So, well then, if the characters are supposed to be similar in age, it seems that then the actors being similar in age makes sense. So, all of you are saying in the book they're around the same age. Yeah, okay. So that's, I mean, he is supposed to be a neurosurgeon. Not at 23. Haley said he's supposed to be a neurosurgeon. He's not going to be a neurosurgeon at 23. He would have had to have been for neurosurgery, like early 40s, late 30s. I mean, I don't math well, but he's definitely not. Catherine in the chat said, I mean, I have not read the book. Or seen the movie. Catherine in the chat said he's supposed to be a 26-year-old neurosurgeon. Okay, well, sure. Shade to that. Nobody's a 26-year-old neurosurgeon. Doogie Howser, you're right, Chad. Doogie Howser. But if they're supposed to be close in age in the book, it makes sense that the actors are close in age to me. But they're saying this is a source of insecurity, which is why this is maybe an issue. I don't know. Sassy footnotes abound. Sony, they say, is pissed. Baldoni received direct criticism from Sony, who voiced serious concerns about the impact of the paparazzi photos from day one. I wonder if there's a lot of things that are included, and then there's some things in here that just are not included. I'm interested if what Sony said is them criticizing her wardrobe makes us look bad, or if Sony is saying leaks from filming are not what we want. I don't know. I don't know. Following these events, they say Baldoni approached Lively in her trailer. Also, it's not relevant. All of this is to explain what happens next. Like, that's the background for what happens next, which is both lawsuits talk about this, and both lawsuits talking about this next chain of events in very different ways. Following the events, Baldoni approached Lively in her trailer to discuss necessary wardrobe adjustments and resetting the relationship to assert his role as director and his need to have approval over her wardrobe. The conversation, while professional, took considerable time and was later grossly mischaracterized in Lively's CRD complaint. When was this filed? This was filed January 16th. It references back to the CRD complaint that was in the New York Times. It does not directly reference back to the federal case. And it's also in the federal lawsuit as well. The CRD complaint, for those of you that are like, there are too many facts happening in this case, I don't remember. Lively said that this took hours and that Baldoni had an emotional outburst in her trailer for hours that made her uncomfortable and delayed filming. And it was like day 2 and it was a lot. So that is a broad overview of what's alleged in the federal lawsuit. But again, we'll link both of them down below. It's going to end up where it's like, okay, the trailer on like the first day of filming, there are these specific instances that are in the CRD complaint that are responded to in this complaint. And it's just a back and forth of very different recitations of what happened. But for the most part, of all of the different things that, or different instances, I don't want to say incidents because that's going to be taken the wrong way, but in all of the different instances that happen, no one is saying that they didn't happen. No one's saying this wasn't a conversation. It seems that through most of these, it is this conversation happened, but that's not how it went down from both sides. There was a conversation about this, but it didn't go down that way. The thing about a movie set is for most of these, there are going to be numerous people around. So again, very far away from this lawsuit being over, but there's going to be a lot of people that are going to be around. So then the lips are dry because there was the humidity in Middle Tennessee today, I think, is about -600. It is so cold and so dry that like the throat is dry, the lips are dry, we're just dry. So we're not going to see this didn't happen. A lot of both complaints are this didn't happen the way the other side said it happened. And then when you are dealing with a creative workspace, you're going to end up with what the judge was struggling with in the lawsuit with Lizzo, is where are the boundaries of a creative workplace? And what does the creative collaborative process look like? And where is that? So they say Lively's CRD complaint falsely characterized this exchange as a lengthy outburst. That is how it was characterized. That delayed filming and caused the crew to, quote, wait for hours while Baldoni cried in Lively's dressing room. They quoted that per memory exactly. On information and belief, Lively circulated this false account to the New York Times with the intention and result that it would be widely published. So that ties this particular conversation, instance, allegation into the defamation suit, saying this is one of the things that was relayed, and it was relayed not as it happened per this lawsuit. They go on to say this conversation did not take hours and any length of time, which do I give a ton of like this conversation was shorter than they perceived? I don't know if it will matter. What will matter more is if the way it's being portrayed, if viewed by other people, isn't believed by the jury. That's what's going to happen at the end. Is this a gross exaggeration by one side or the other? The conversation did not take hours, and you know who's going to know? The script supervisor. The script supervisor is going to know exactly how long that conversation took, because, and maybe the first AD, does the first AD keep time as well? There are going to be people on this set who know exactly how long this conversation took, because they're the ones sitting there going, are we getting back to production? So how long this conversation took, again, will it's a movie set. We'll know. So Alicia in the chat said, yes, first AD keeps the schedule going. First AD is going to tell you exactly how long this conversation took. They say it did not take hours. Any length of time it took was, not because Baldoni, quote, cried for hours. In truth, rather than taking heed of the concerns of the film's distributor and director. Oh, Baldoni. Sorry, they're not referencing Baldoni as Baldoni. They're now referencing Baldoni as the distributor. No, that's Sony. Director Baldoni. Lively took this time to, among other things, suggest to Baldoni that he was being gaslit by Sony, Heath, and the other producer, and trying to convince him to let her take the helm. So they're saying he did not have a emotional outburst in her trailer. Rather, she was trying to get him to cede control, and that Sony was gaslighting him. Baldoni did briefly become emotional during the conversation, but only in response to what he believed was a genuine compliment from Lively, praising his work as a director and actor. In hindsight, this was part and parcel of the ongoing pattern of manipulation and gaslighting by Lively. The reason the by Lively is italicized is because it's directly contradicting what was alleged in the CRD complaint. Let's see. Intended to continue to allow her autonomy over her wardrobe. They say Lively later distorted this conversation in support of her baseless harassment allegations, alleging that Baldoni made inappropriate comments on her appearance. In reality, Baldoni, the director, was relaying the distributor's concern as to the widespread social media criticism regarding the wardrobe's failure to meet audience expectations, a sentiment Baldoni shared. There will be other people party to that conversation. So the conversation with Sony and Baldoni. So eventually, there will be third-party answers. They go on to say this incident is just one, incident. They also refer to it as an incident. Incident is just one of many examples of Lively's troubling pattern of manipulation and lies. Again, this suit does not go on to say these conversations don't happen. They go on to say this doesn't happen the way that her suit and complaint, her complaint said it happened, and that saying it to the New York Times, she knew it didn't happen this way, and therefore her saying it to the New York Times is defamatory. If this all goes to trial down the road, it's going to be a trial of underlying what's the truth of how these things happened, because if it's true, it's not defamatory. And if it's not true, did the party know that it wasn't true to make it defamatory, meeting the standard? So the litigating of whose side is telling the truth is going to be the, baseline of all of this, because you can't get to defamation without getting to what people said and was it true or was it not true. It goes on to say, early in the pre-production stage, Lively sent Baldoni a long text describing how directors never permitted her to write scenes for the movies she acted in, nor gave her writing credits, even making her hand scribble her suggestions for lines so that they could not be traced to her. Lively boasted that she had even written for her husband's movies. Then Lively asked if she could, quote, take a pass at writing the rooftop scene in It Ends With Us, in which the characters first meet. This pivotal scene, much beloved by book fans, was critical for setting the tone for the movie. Baldoni was reluctant to allow an actor, rather than a union screenwriter, to rewrite this key scene. But Baldoni felt the need to allow Lively to rewrite the scene and agreed to take a look at what she put together. I don't know how much that's something that actors do or do not do. I don't know if this is usual or unusual on a movie set. Again, those in the industry who end up getting deposed in this will end up having conversations about whether this is a overstep of workplace responsibilities or whether this is part of the collaborative process. They go on to say the draft of the rooftop scene that Lively sent Baldoni dramatically differed from what had been written originally. He was hesitant about many of the changes, but thanked her for her passion and diplomatically told her that the scene would likely end up being somewhere between the original version and Lively's version. This particular scene coming up is because this goes to later conversations about Lively saying to reporters that Ryan Reynolds wrote that. And in this, she is saying she wrote it. In that report, she's saying Reynolds wrote it. And then there's emails from Sony saying, yo, WTF, who's writing these scenes? They say, seemingly stung by Baldoni's exceedingly mild resistance. Again, this is all characterization. It will come out one way or the other. They say Lively went silent for multiple days. I don't know when this was, but we'll see the text message. The way this is written, it doesn't follow in time where we are, but it seems like this is pre-production, but we don't know when in pre-production, but we'll see the text because they include it. So we'll just, instead of the characterization of the text, we'll just read the text. But they say that they perceived Lively to be mad, or her ego was hurt or stung by the resistance to letting her rewrite the scene. And in text message, she said the response, of course, didn't feel great for me or another mega celebrity friend of Ryan Reynolds to have my passion praised instead of my specific contribution. Lively was referring to an earlier meeting where Lively summoned Baldoni to her New York penthouse, where Baldoni was greeted by Reynolds, who launched into enthusiastic praise for Lively's version of the scene. Hours later, as the meeting was ending, a famous and famously close friend of Reynolds and Lively walked into the room and similarly began praising Lively's script. Baldoni understood the subtext. He needed to comply with Lively's direction for the script. This comes up as we get there later, to whether or not this was extortionate pressure on the filmmakers, Baldoni included. So that will come up, which is why they're including it. What's funny is they reference famous and famously close friend and then don't redact the mega celebrity's name out of the text messages. So they will say that this is the beginning of a power struggle on this film set. And to answer the question of, how did this all happen? They are saying the answer is how this all happened is because we understood that nothing was going to happen if we didn't appease the celebrities. So that's their response to that. They go on to say Baldoni felt obligated to text Lively to say that he liked her pages and hadn't needed Reynolds and mega celebrity friend to pressure him. Lively responded that the two were her dragons and went on to say, oh, we're going to read the whole text. We're not going to read the characterization of the text. We're going to read the whole text. They say the text could not have been clearer. Baldoni was not just dealing with Lively, but he was also facing Lively's quote unquote dragons, two of the most influential and wealthy celebrities in the world who are not afraid to make things difficult for him. Let's read the text messages in as full as they provided them. This is from April 14th, 2023. So this is before the May conversation that we looked at early on when they were joking about assholes and suppositories. Before that. Lively to Baldoni, if you send me the FDX, I'll work where I can steal moments. And yes, of course, please send to Christy. We're all on the same team with the same goal. Are those praise hands? High five. Brooklyn, I see your question in the chat. I'm going to hold on to that. I talked about it a little bit at the beginning about why it might be federal. But we can talk about that as we get through because they mention a bit of the jurisdiction at the end. It might be just so it moves faster because it'll move faster than state court. Justin said, and it's also easier to serve people subpoenas in multiple states. So hands up emojis. Great. Also was working on the rooftop scene today. I really love what you did. It really does. I think that is meant to be help a lot. Makes it so much more fun and interesting. I mean, it doesn't sound like he dislikes it from this text. And I would have felt that way without Ryan and Taylor's winky face emoji. You really are talented across the board. Really excited and grateful to do this together. Again, hey, love what you did. Helps a lot. Makes it so much more fun and interesting. It doesn't sound in these texts that he doesn't like her contribution. It also says that it doesn't seem to say that he downplayed her contribution. It seems like he was like, no, it's all good. So this is where we're going to get to them. Their reading of it is because it stung. So this is from April 15th. Is this in the same? Yeah, right in the same thread. That's appreciated, means a lot. I'm deeply inspired by the film we're going to make outside of the success of this book. We have such an opportunity not only surprise people who love the book, but reach an even bigger audience by making an undeniably dynamic and also commercial film. The moment that excited me most the other day was when you said, "You're not funny. You are going to kill that rooftop scene." With all the periods. I read it that way because all the periods, all the periods. You know it, I'm sure. Even though it was said in playful self-deprecation that we all participate in, it made me think of the process as a whole. Please know I trust that on the day you've got me, and I hope you trust that I've got you. I assume they're talking about on the day of filming, and I've got you if you want. We're in this together, and we are two of this. I think it's probably this most determined people I know. We also have very high bars set for ourselves to collaborate with that type of partner, is a gift that neither of us will squander because we both care too much about the result and also the experience. I have no motives except for you to win as a director, as an actor, as a studio, as a writer. If you win, I win. If you win, our movie wins. We are aligned, and I will bring everything I have to this. This looks like a second text in that. It looks like the beginning of a second text in that chain. It's interesting that you've got redactions in that one, but not redactions in this one. I think they probably meant to redact it all and missed one. Does that happen? Yes. Do I think it's an Easter egg in the lawsuit? No, but Taylor's name seems to be redacted out everywhere except this message. I think they probably just missed it. They go on to say, as for Blank and Ryan and redacted someone else for that matter, I am the luckiest motherfucker on the planet to have them as my dance moms level stage moms. They are embarrassingly effusive. I don't know why there's a line in this the way that it is cut, but it might just be the way it was screenshotted. We'll see. They said they're also my most trusted partners and the people I go to, or that said, not they said, that said, they are my most trusted partners and the people I go to first with anything creative I touch. And I'm the person they each go to first. That reciprocal creativity and support has been one of my life's greatest and most fulfilling gifts. When they loved and signed off on the pages, I felt good to send them to you. They asked what you thought specifically after they checked in so many times. I told them that you laughed a bunch and said it's probably a blend, but you appreciate my passion so much, which of course didn't feel great to me or them to have my passion be praised instead of my specific contribution, or even just that you didn't like the pages, which is also fine. I think this continue. It's a very long text. I think this is a direct continuation. It's hard to see. So I think they wanted you and me to see how they felt about the work because they've been by my side for far too many experiences where I've been overlooked. I spoke to you about this when we first met. I've watched me, which is probably my hand. They've watched me handwrite scripts. The way this is photocopied is just hard for me to read. And that's just my brain. So apologies for the difficulty. It is blurry. And that's not uncommon in things that are clipped into lawsuits. It's better than some, but not always. Let's see. So I think they wanted you and me to see how they felt. This seems to be directly calling back to him saying, I didn't need anyone else to chime in on that. Like I didn't need Ryan and Taylor, is what he said in the text, to pipe in. She's saying, so they wanted you and me to see how they felt about the work because they've been by my side for far too many experiences where I've been overlooked. I spoke to you about this when we first met. They've watched me handwrite scripts because the director is too afraid to send the FDX file. Yet he scans and has someone hand type all 120 pages of my pencil rewrites. They've watched me be hired as a writer and paid a significant fee for it, but on the condition that I never ask for credit, which I could give a shit about. It's more the principle of the dynamics at play. They've watched the other side of it too, where I'm told at signing that I'm wanted as a true collaborator, but once we get to work, I'm really just wanted as a quote, yes man, audience and actor, which for those of you asking what FDX stands for, we have Chazarus, I hope I pronounced that right, in the chat saying FDX's final draft script file for anyone wondering. I was wondering. Thank you. See, it's chat is bae. Appreciate you, chat. Final draft script file. So they wouldn't send over the script file to her with FDX. Also, it seems like a lot of this is, I read a lot of this as venting. You guys let me know what you think, but like, we'll see what the agreements were coming onto the movie and what the expectations were. I don't know if this is everyone not being on the same page about the expectations of how this movie would go. I don't know. I don't know. We'll see. But it seems like a lot of exposition and explanation for, I've been told I was wanted as a true collaborator. I get to work and they don't want to collaborate with me at all. We'll see. We'll see what the expectations are. It goes on to say both Ryan and Redacted have established themselves as absolute titans, as writers and storytellers outside of their primary gig, just singing or just acting, or Redacted just directing. I'm so lucky to have them as creative barometers. but also have them as people who prop me up and make sure I'm seen for all I can and do offer, because they know firsthand all I contribute. They also know I'm not always good at making sure I'm seen and utilized for fear of threatening egos or fear of affecting the ease of the process. They don't give a shit about that. And because of that, everyone listens to them with immense respect and enthusiasm. So I guess I have to stop worrying about people liking me. That emoji looks like shrug emoji. It continues on saying, if you ever get around to watching Game of Thrones, you'll appreciate, and for all of you who haven't watched Game of Thrones, you'll appreciate the reference. For all of you that didn't watch Game of Thrones, this is a character from Game of Thrones. You'll appreciate that I'm Khaleesi, and like her, I happen to have a few dragons, for better or worse, but usually better, because my dragons also protect those I fight for. So really, we all benefit from those gorgeous monsters of mine. Looks like a laughing face emoji. You will too, I can promise you. So that's a lot. Like, that is a lot of a text response to, and I would have felt that way without Ryan and Taylor. That is a lot of explanation. They are saying that this is read as a threat. So that is what this lawsuit is saying. Hey, we read this as a threat that she's saying, I have two of the most powerful people in the world on my side. And if we are on the same side, they're on your same side too. They are saying the subtext of that is, and if you are not on my side, then they are also not on your side. And that is going to be a problem. So that's how they take it. We will see. Some of you in the chat are like, do any of these people know about a backspace key? No, not in the texts, not in the text messages. They go on to say difficult proved to be a gross understatement, though Baldoni initially invited Lively to make changes to the script. Lively began altering the script daily. These are the kind of things, again, that are going to be very easy. Again, if this happened, and assuming that it did, if this happened, these are things that are incredibly easy to prove, because the script, again, everyone on the movie set is going to have to get rewrites of the script if the script is being rewritten. So there's a lot in this that's going to be really easy to document. So some of you are saying you see the script as coercive. Some of you are saying you see the script as insecure. Some of you are saying it seems like rambling, and I get it. And some of you are saying the shrug emoji is like, eh. Some of you are saying it seems like somebody's saying, look, I'm always cut out of the process and I don't want to be cut out of the process. And some of you are saying it seems like bullying. We're going to have to wait and see. That's why we read the whole text. Because again, we'll see. They say it was taken as a threat. So that is what they say. So they go on to say, though Baldoni initially invited Lively to make changes, she began altering the script daily, which I imagine would make the first AD and the script supervisor crazy, because movies, if anything, I understand that movies need a schedule, and the schedule is very, very tied to money. And if things are being changed daily, it's going to fuck up the entire schedule, which they go on to say. The frequency of the revisions alarmed producers, director, and studio. Director being Baldoni. It's always weird when they switch from talking about Baldoni as Baldoni and Baldoni as director. And the producers, there were multiple, and the studio. I think in this they mean Studio Wayfarer, who is plaintiff, not Studio Sony, but it's not clear. They said that the producers, director, and studio, plaintiffs, less the PR people, anticipated that the interference would persist every day of the shoot and disrupt the carefully planned production schedule. Each shooting day was intricately scheduled long in advance. That is one thing we do know from everything that we've seen covering movies, is that is needed. And Lively's constant challenges or constant changes placed significant stress on the production crew, not to mention the financial strain on Wayfarer. Producer, We don't know which producer, but producer, these are different screenshots of probably Jamie Heath's phone, who's also a plaintiff in this case. Are you listening to this? She's fixing the script. I think Ange's advice was actually wrong. Blake is now directing the movie. This is bad. This is from May 1st, 2023. It says at 5:26 a.m. So I don't know what they're listening to, but we'll see. Jamie Heath said, I'm listening. Talking through is better than not. Seeing what's possible as long as any decision is done with approval. Producer said, not for something that was already intimately planned. This will be every day of the shoot. Jamie Heath said, I'm not sure what can be done, honestly, at this point in terms of, and then it just says, Blake, something either is cut or lined out, but I don't know what is cut or lined out, but something is cut or lined out, and I can't read the bottom of it. I don't know if it's another sentence or if it's just split at this. I'm not sure what can be done, honestly, at this point in terms of Blake, period. It goes on to say, more than a year later, during a red carpet interview at the New York film premiere, Lively stated that the iconic rooftop scene, my husband actually wrote it. Nobody knows that, but you now. Again, does this go to all of the other causes of action? No, that's not what they are trying to insinuate here. What they are trying to insinuate here is A, there was a takeover, B, the other defendant was involved in the takeover, and C, she said one thing in the text and then another thing in the interview. So is she a reliable storyteller of what's happening, or both things can't be true? Did he write it? Did she write it? Who is involved? So it pulls in the other defendant, and it pulls in the who is the reliable party here, going to credibility. They go on to say this startling revelation directly contradicted Lively's previous insistence that she had written the scene, and certainly cast Reynolds' high praise for the written scene in a different light. The film's credited screenwriter, when asked about the claim that Reynolds had written the scene, graciously responded. And I imagine for the scene writer, or for the script writer, that doesn't feel great. The screenwriter said, so if I'm being told that Ryan wrote that, then great, how wonderful. I mean, I think, was this asked like in an interview? Like, hey, this was just said. And the screenwriter is like, what? Don't know. But they're talking about it happening at the premiere, so we'll see. Crystal said, EDB, are there laws preventing an actor from sharing the script of a movie that is in filming, like an NDA? I would imagine there is. Laws, not necessarily, but yeah, there can be NDAs regarding that for sure. So breach of contract, if there's an NDA, yes, there can be breach of contract if scripts are being shared outside of an NDA. And it just depends on how that's written. And sometimes you'll even see scripts watermarked per who they go to, and dailies being watermarked per who they go to, so that if they do end up in the public, we see this with TV shows a lot of times, that when those end up out in the public, it's watermarked so you can see where the leak came from. More with TV, but not always. Let's see. So the screenwriter, I would imagine, was caught unawares, but said, there were a few little flourishes that I did not write, and if those flourishes came from Ryan, I think that's wonderful. Footnote 7. So the screenwriter is saying there were a few small changes. Footnote 7 is the interview from People, or the article from People. It goes on to say this was also the first time plaintiffs learned that Reynolds, who had no formal role whatsoever in the film's production, had made unauthorized changes to the script in secret. Baldoni equally blind. Well, they were presented as Blake's contribution. So they're like, these are unauthorized changes. Well, they were presented as Blake's changes, and it seemed that they were incorporated in, but there are also a lot of rules in Hollywood about who does what. So we'll see. They say he made unauthorized changes to the script. Baldoni, equally blindsided by the news, which he discovered in real time during the recorded interview with Access Hollywood, reacted by also praising Reynolds so as not to harm Lively. Reynolds, they say, who apparently wrote the scene, and possibly others during the strike or the film. We don't know. I know they're going to throw shade at like Reynolds was doing work during the strike or Lively was doing work during the strike. I don't know from when these texts are, if it was during the strike, because Baldoni seems to say, I'm working on the rooftop scene today, April 14th. So we'll see. But he was working on the scene, but he's the director. She's a producer. I don't know what work's allowed to be done and what work's not allowed to be done. The Screenwriters Guild was on strike. The Directors Guild was not on strike. The SAG-AFTRA was on strike. So SAG and writers are not, or were not to be working. Directors were allowed to be working. Now, were directors allowed to be working as writers? Probably not. So I don't know. Will we learn more later? Yes. The WGA strike, the Writers Guild strike was May 2nd. So it looks like, thank you, chat, for those of you that noted that the WGA strike, we'll get to it later. And here there's a lot of dates. But if the WGA strike started May 2nd, this scene was already presented to Baldoni by April 14th, based on the timeline in the texts. So they say this happened down the road. This says they were all working on it in April. We'll see. That's why I like the text. The texts have timelines. We appreciate the timelines. We want the timelines. Just give us the timelines. We need a map with the timelines with this one, because it does jump around a little bit. So let's see. The screenwriter, it seemed, got caught off guard and said there were a few little flourishes. They say that Lively's remarks about Reynolds' purported contribution to the script raise eyebrows sky high at Sony, who told Wayfarer they, quote, certainly needed some clarity on public comments made about Ryan Reynolds' potentially contributing writing services for the rooftop scene. This is an email on August 9th. So this all came out as the film was being edited, which is why we've now jumped in time to August 9th, 2014. No, Emily, really? August 9th, 2024, with Sony Legal Affairs to Wayfarer Counsel, lots of emails and names redacted. That's not surprising. Hi, redacted. We certainly need some clarity on public comments made about Ryan Reynolds potentially contributing writing services for the rooftop scene. Can you provide additional information on this, as there are no contracts? His services are not in the chain, nor is his name anywhere in the credits. One of the many media reports which cite this claim made by Blake Lively linked, thanks for clarity or clarifying. If services were rendered, obviously we require signed documentation immediately. Sony Legal Affairs is just like, bro, what? You've got legal. What? No, what? No, what? There are formal processes for all of these things. There are unions involved in all of these things. The email back from Wayfarer to Sony Legal Affairs says, hi, your email was shared with me by Redacted in order to address this issue. We are not aware of any writing services rendered by Ryan Reynolds, regardless of what is being said publicly. This is not something we are aware of. We are learning about these allegations in real time. Please let us know if you have any questions. Thank you. Everyone was like, what? Still during the pre-production phase, so we're now back in time to before production started. Still during the pre-production phase, Lively and Reynolds raised entirely false allegations of fat shaming against Baldoni, an accusation that, as evidence will show, was categorically false. Baldoni had been introduced to trainer quote unquote Dawn. Let's try to, now that we're going to go back to reading text messages. So we're going to have to zoom a little bit. Baldoni had been introduced to trainer Dawn, who became Baldoni's personal trainer by Lively. Dawn directed Baldoni's preparation for the film role, including nutrition and exercise, making special accommodation for Baldoni's back injury. Baldoni even paid to receive the meal service. Okay. This is them texting back and forth. Speak to you later. Got the program. This is our workout schedule. They say privately, Baldoni reached out to Dawn as his personal trainer to ask what Lively weighed so he could train his back muscles in preparation for a lift scene. This was important to avoid injury, not only to Baldoni, who suffered from lifelong back injuries, multiple bulging discs, and chronic pain, but also to Lively if the lift could not be completed successfully and safely. Notwithstanding Lively's recent attempts to deny the existence of any such scene, it was only nixed in her insistence after having been planned and rehearsed. Baldoni says that this scene was always in the movie. Lively's complaint said there was never any such scene in the movie. Again, it's going to, if it was, it'll be memorialized. If it wasn't, that will be memorialized. Both sides have said just different things. He says that the scene was taken out because of Lively and Reynolds. They say the next morning, Baldoni was summoned to the penthouse by Lively and greeted by Reynolds, who swore at Baldoni and accused him of fat shaming his wife. Quote, "How dare you fucking ask about my wife's weight? What's wrong with you?" The confrontation from Reynolds and Lively was so aggressive that Baldoni felt he had no choice but to offer repeated, they say, and completely unwarranted apologies for what was a good faith and reasonable question to ask of his trainer. We don't know what dates these are from. We know what dates the texts are from. We don't know what dates the conversations are from. So it's in the timeline, hard to get a sense of when this conversation took place. It goes on to say that Reynolds demanded Baldoni remove the scene entirely. Lively's complaint said no such scene ever existed. They say it didn't exist because we pulled it because you complained about it. So they go on to say Lively refused to perform the lift scene in the end, even after it was rehearsed with a stunt double. In her own complaint, Lively flat out lies about the absence of the scene by claiming the scene wasn't in the film. Are lawyers lawyering? Are lawyers lawyering? Are lawyers lawyering? Lawyers. The complaint says the scene wasn't in the film. I think that's accurate. The scene wasn't in the film. They're saying the impression is not accurate. The impression that it leaves is that the scene was never written to be in the film. But this is parsing. The scene wasn't in the film. That seems to be technically true, that the scene wasn't in the film. They say that this is a flat out lie in the complaint. I think the impression it leaves is the problem. I don't think that's a flat out lie. The scene wasn't in the film. It wasn't in the film. This is the lawyers lawyering. This is the lawyers lawyering. The scene wasn't in the film. And they're saying, right, the scene wasn't in the film because you yeeted it from the film. So yes, it wasn't in the film. You yeeted it. It was in the script. Oh, the parsing. So do I think that's a flat out lie in the complaint? No. Does it leave a misimpression that it was never in the film? Yes. So they go on to say the only reason the scene wasn't in the film is because Lively and Reynolds ensured it was taken out of the film. They yeeted it. So lawyer parsing. And we're going to get to some more of that in this because, again, lawyers write complaints in the light most favorable to their client to support their advocacy for their side. I think it is, though, well documented that Baldoni does, in fact, have back issues. I think that is well documented. So again, how do these things get handled on movie sets is going to be the question. Because the question is not, how does this get handled in a normal job? The question is, how does this get handled on a movie set? How do people train for stunts on a movie set? And what are those conversations on how stunts are trained for on a movie set? That's going to be the question, really. So they're like, the complaint lies. It's like, well, all right, let's continue. The lawyers be lawyering. So the scene wasn't in the film. Why was the scene not in the film? Because you kicked it out of the film. So yeah, it wasn't in the film. In fact, they say Lively had earlier expressed insecurity about her postpartum figure, and Baldoni made every attempt to genuinely reassure her. In this exchange, he stated as her director, quote, anything you feel insecure about, we will talk through and get creative together and make you comfortable. I just don't want you to stress about your body. It's the last thing you need. And then we have a text with that. They say that when he later tried to do just that, Lively responded with allegations of sexual harassment, followed by a lawsuit. This is from February 2023. Lively said kicking ass, but it's still a ton of work with not a ton of time. What's the chance we can do body scenes at the end of the schedule? Also from February 17th, 2023. Baldoni says, I'm sure you are. Honestly, there's 1 billion moving parts to schedule right now. I just turned in the rewrite, and so they are hard at work. So much of it comes down to locations and other cast availability, etc. So to be really honest, I have no clue. It looks like a separate text in that same thread, pretty close in time in that same, well, actually no, from 1737 to 2128. We'll see when all the texts are done. I want you to know that you will look amazing. Anything you are insecure about, we will talk through and get creative together and make you comfortable. I just don't want you to stress about your body. It's the last thing you need. As soon as I have a rough schedule that's even remotely accurate, I'll share. I'll make sure the team keeps this in mind as well. Heart emoji. Let's see. Dido in the chat said, I want to know if this scene reached the rehearsal stage or was omitted beforehand. I guess we'll see. For some of you saying it's the stunt, this is the job of the stunt department, not the trainer, and that the stunts assess the risk. Again, this is why experts testify in trials, because the experts will be like, this is not in context. This is not what happens on a movie set, or it is what happens in a movie set. Hot 3 said, why would this go through stunts? Don't they choreograph and rehearse stunts only? My assumption would be going through a trainer to train for stunt rehearsal, ? Was there even a stunt department for this film? We don't know, but we know that stunt persons were hired, but we don't know. Why is this all in here? Because it's in the other complaint as part, and I think this is in the New York Times article, as things that made Lively uncomfortable on set, and they are pushing back on this. This is misrepresented, and this is not, it didn't go down the way it's being portrayed. The text goes on to say, thank you for your voice memo. It's deeply appreciated. You are everything you promised to be as a collaborator. This is now from February 18th, like the next day. You are everything you promised to be as a collaborator. Thank you. I know my job here, and this piece is a big part of my job here. We both understand the assignment, actors in the roles, but also as producers and also as marketers. When we see that, we've seen this in a couple texts now, with reference back to the producer role. We understand artistically, yes, but we get what we need to do in all aspects for this movie commercially. As woke as we both are and work to be, this movie requires a certain aesthetic what does that sentence even mean? Somebody help. Like, what? It's a part of the job that we both excitedly signed up for. I don't shy away from it because it's not problematic. It's the assignment. What are we even talking about? Like, where are we? Emma Mack asked, but was she a producer? She had an executive producer credit at the beginning. What? Okay. Let's see. I don't know what they're talking about shying away from. Like, I'm lost for context here. Based on what we're provided. She goes on to say, it's part of the job we both excitedly signed up for. I don't shy away from it. I don't know what it is. Because it's not problematic. It's the assignment. I don't know if they're talking about getting in shape, maybe. Some of you are saying that in the chat. I don't know. Like, when someone is about to start an athletic event, it's their top job to be in top shape. My husband and I both look at certain roles as athletic events. I imagine most actors do. And this is one of them. It's not always a part of the job, but on this one, it is, and that's great. As much as I'd love to not think about it, I think y'all are right that she's talking about the body scenes and weight and body. As much as I'd love to not think about it, that would be irresponsible and also impossible because it's unrealistic to not acknowledge what I need to do. Right, going back in context of the, can we film the body scenes at the end? And him saying, we'll do whatever we need to do to make you feel comfortable. I want that. That's weird. As much as I love to not think about it, that would be irresponsible and also impossible because it's unrealistic to not acknowledge what I need to do. This is my job here, and I meet my responsibilities with extreme work ethic. I look for solutions to achieve my high goals instead of lowering my goals. We all win when we're each firing at our highest capabilities, and you and I both are and will continue to. I just need as much time as possible because I just had my fourth baby. Okay, that gives, now we're back to context. I understand that you'll never personally know all the nuances of the challenge unless you've lived this physical moment in time. I'm in with this physical road ahead. So having your understanding and support has helped me pull this off is critical and very, very appreciated, not just in my experience now, but also healing from experiences past. So thank you. We're going to kill it. And be so fit, they have to Lola us to look less banging. I don't know what that means either, but it's at the end of it, it's gonna be banging, and let's go. So they put this in. It seems to be like, look, he was supportive. So the characterization that anyone was being shamed is not, they're saying, an accurate retelling of what happened. They say Lively delivered an ultimatum. If Baldoni could not get on board with her work methods, he had 2 weeks to recast her. I don't know how this follows. Like, I don't know where we are in time, and I don't know how this follows. We're going from them saying that Ryan Reynolds yelled at him about asking the trainer about his wife's weight to an ultimatum. I don't know when this happened. Chat is bae. Pumaster said, Lola is software that makes people look younger and thinner. Lots of NDAs involved with that one. Thank you for the context. That is so helpful. No, not Lola from Big Mouth. Not the music. Thank you, chat. That is very helpful. Again, this is why experts testify in trials. Chat is just an expert here. So they'll have to Lola us to look less banging. So from that context, it sounds like it's we're going to be so hot that you've got to reverse us so we're not too hot. Chat, Chad is now singing, which is funny in context. I'm lost now where we are in time. I don't know when this ultimatum happened. I don't know what's happening. If Baldoni could not get on board with her work methods, he had 2 weeks to recast her. When did this happen? Again, lost in time. They say implicit in this ultimatum was a threat to destroy Baldoni's reputation and career, as implicit means how they're interpreting it. They say, as Lively well knew, Baldoni has worked hard throughout his career to earn and deserve a reputation based on his passionate advocacy for women's rights. They seem to be saying this is in time with the allegations of shaming, but we don't know when that is. I don't know where we are in filming. Sam in the chat said April 2023 based on the messages. I don't know, but we'll see. There are some things that definitely could be spelled out more. I don't know when this ultimatum is from. But they say implicit in this ultimatum is a threat to destroy Baldoni's reputation because he worked in his career to earn and deserve a reputation based on passionate advocacy for women's rights, a reputation she would later exploit and weaponize against him. If Lively were to back out of the film, especially based on accusations of fat shaming, okay, that's how we got all the way down to here. Baldoni's reputation and life's work would be left in tatters. He had no choice but to bow to Lively and Reynolds' demands. Concerns about Lively's undue influence over filming began to grow. So sometime between asking the trainer the yelling, and then the rest of it, again, we'll see. I'm curious for more information about this, but they are lining this out as, hey, this is part of the undue pressure. This is part of how we got to the whole movie being overtaken. My question is, were there other conversations here with if we can't shoot the body stuff at the end, then you can recast me in 2 weeks because I'm not going to be ready? I don't know. But they are saying this is part of the pressure that led to all of this going a different direction. Again, we'll see. But if you can't get on board, you have 2 weeks to recast her. They say that they believed that was in direct connection to what they call fat shaming. There's more context there that we just don't have, I think. April 20th, 2023, producer, he can't let her have opinions on everything. Jamie Heath said Blake, producer, or she's going to be co-directing this film. Yes, Heath. Yeah, we were talking about that a lot yesterday. Producer, exactly. This is where everyone is starting to lose it. We have been talking about the same thing for months. Heath said, yep, it's starting to get resolved. Producer said, no, it's not. Producer's like, no. I want to know when this happened. Like, when in time are we? They say filming begins. So was this all pre-production? It seems like it. And if pre-production is hey, you've got 2 weeks to recast me, in pre-production seems like the only opportunity to do that. But there is some jumping around in time in that. They go on to say filming begins and Lively builds her takeover strategy, because that is their theory of the case. That this was all the complaints was like laying groundwork to take over the movie. Okay, here we go. Principal photography for the film began in early May 2023. We're 33 of 173 pages in, and we've gotten to when principal photography starts. Great. Fantastic. Lively continued to maintain what later appeared to be a facade of a close, caring relationship with Baldoni, even as she continued to make escalating demands for creative control. They say by the time production began, Lively and Baldoni had worked closely together for months, and Lively expressed warm gratitude for her collaboration with Baldoni on the eve of filming. And Baldoni's side is going to say this was all laying the groundwork, and Lively's side is going to say, yeah, things were fine until shit got weird on set, and then things weren't fine. So we're going to get both sides saying, right, things were fine until they weren't. Cast Iron Mama said jumped in a bit late, but this is so repetitive. It's because we went through, yes, and it's because we went through the New York Times lawsuit, and a lot of this is in the New York Times lawsuit as well. But yes, there's a lot of things that are said, but some things that are not said clearly. This one clearly comes from a forensic extraction of Baldoni's phone. This is from May 15th, 2023. From Lively to Baldoni. Again, the other part of the allegations here is the other side clipped a whole bunch of text messages with no context. And then this lawsuit has a bunch of text messages that are just one message. They're like, the other side, you guys put in one message and you can't do that. And then they're like, but here's a message saying that everything was fine. And this was part of a hostile takeover. This note means so much to me. I'm excited to start tomorrow. So it seems like they start filming May 16th, but it's only one piece of the journey we started months ago. And I'm grateful for all we've built so far. Thank you for caring so much and putting every bit of you into showing it. You have given so much of your time to fight for great, and that hasn't gone unappreciated or unseen for a moment. They are saying this isn't genuine. They say throughout the first filming period, Lively continued to share her open and unguarded thoughts on life and her character. She talked about wardrobe choices to make her character, quote unquote, much sexier. This goes back to the allegations that I think Baldoni was making comments about Lively's wardrobe being sexy and her saying that's not what I'm going for. There's also allegations of a comment to somebody else on set about their pants being sexy, etc. This is, let's see. Oh, this is about the beanie, which this was in the New York Times as well. I would like to see the rest of the text thread. This is May 17th. We'll show you both ways, but the beanie is much sexier. It's the look, feels TV without, especially with a crop top in the snow. It's a choice. It justifies the rest of the skin, and also is a girl I would check out walking down the street because it washes the effort of the rest of the look. So discussing wardrobe, they characterize this text message the same way in the New York Times suit, saying that, hey, in the New York Times suit, they said, look, this is Lively saying she wanted to be sexier. Her character wanted to be sexier. Read it as you will. I think the beanie is the sexier choice for the character. They say Lively continued to express warm appreciation and respect for Baldoni as filming continued, even as she acknowledged she could be difficult and critical of others, using the kind of language she herself would have alleged to be inappropriate. Footnote 8. Lively's use of the word ballbuster would certainly have made it into her 17-point list had it been Baldoni who said it. They're just like, she would have complained about this had somebody else said it, but it's okay for her. Baldoni and Lively texting May 23rd. So this is after filming has begun, it seems, or a few days into filming. For those of you saying the footnotes are nothing but shaded in this lawsuit, shade and links to articles. Shade and links to articles. Let's see. Baldoni said, I'm not going to tell you that you were amazing. I'm not going to tell you that you were amazing because you teased me for being so sentimental, but you were amazing today. And then this is boxed in red because they want it to catch your eye if you're scrolling through the lawsuit. Lively said, thank you. I do appreciate it. I'm just a ball buster, but it means a lot to me. I care a great deal and always want to deliver. You were terrific. I'm proud of everything we did today, but really every day. It's like high fives. Baldoni says, thank you. They're saying this is the type of language that was acceptable on set. So her lawsuit is overwrought and making a mountain out of a molehill. And this was the behavior on set. Let's see. Lively's intimate comfort with Baldoni continued as filming progressed. In June of 2023, after the alleged harassment and, quote, uncomfortable situations allegedly occurred, she even invited Baldoni into her trailer to rehearse while pumping breast milk. This is from June 2nd, 2023. I'm pumping in my trailer if you want to work out our lines. This is in the New York Times lawsuit, portrayed differently. In the New York Times lawsuit, they portray this text message saying, hey, she invited them into her trailer, so it wasn't weird that he was in her trailer, and she complains about people barging into her trailer, but really she invited people into her trailer, so there can't be complaints of her barging into the trailer because she invited people into the trailer without. So it's portrayed in that lawsuit as the behavior was invited. In this lawsuit, it's portrayed as, well, she can't be uncomfortable if she's inviting people into her trailer. They go on to say Lively was so close and comfortable with Baldoni that she freely breastfed in front of him during meetings. She took photos of him holding and soothing her crying baby in her penthouse. They laughed deliriously during late night writing sessions. All of these events took place after the alleged sexual harassment. Lively's accusations seemed to come out of the blue. Footnote 9. Out of respect for Lively's privacy, this complaint does not include any images of her family. Okay. So look, everybody's getting along on set. Nobody knew anything was wrong. All of this was news to us. Everything was fine filming in May, and then there's a strike, and then we come back from the strike, and then everything is out of the blue. They say she even knew his tea order, which I guess goes to them being friendly. En route to you, can I get you anything from Baldoni? No, all good, thank you. I'm getting you a hot matcha. Do you know what Brandon likes? They go on to say Lively set the tone for professional discussions on set, including what language was acceptable. For example, on one occasion while filming a restaurant scene, Lively sat on the floor in painfully expensive shoes while discussing with a group of male cast and crew how sexy her shoes were. Footnote 10. Lively had no issue using the word sexy herself, but apparently took note both times Baldoni said the word in her presence. Trying to remember in the complaint. In the complaint, it says that another cast member was commented on about her pants being sexy, and that cast member objected to it, and he said something like, "Oh, it's okay, my wife's here today." I think that's what was in the complaint. But Lively had no problem using the word sexy, but took note both times Baldoni said the word sexy. They say she was loose and relaxed in her speech on set. She was increasingly stringent in the demands imposed on production. She rewrote her own dialogue constantly and took it upon herself to make unilateral changes to other characters' lines. I imagine that is something actors don't do regularly. I imagine that's not the norm. So I imagine that's not the norm. They go on to say this pattern of domineering interference caused unending interruptions to the production process. And then we get to the labor strikes. They say that they allowed this. They say they allowed this out of fear of repercussions from Lively and her allies. And they constantly tried to accommodate it because of Lively and her allies. And chat, a lot of you are pointing out, yes, Lively was talking about the shoes being sexy or the beanie being sexy, not about herself being sexy. I do think there's room for nuance there. They are trying to broad swath it with, no, this was acceptable language on set. This is always acceptable language. That's not how it is written in the other complaint. But again, when we're getting to what happened on set, it's going to be a lot of back and forth of, you said this and it made me uncomfortable. And it's like, well, we're talking about this because you said this language was acceptable. Hey T, you home from school? Obviously, because you're standing here. How was your day? Good to see you. Everybody okay?
Yeah, no, it was one person and they were driving way too fast and way too close to the edge. So on the road right next
Sorry, my teen is retelling me that there was a collision on the way to school.
so right by the convenience store, someone was going too fast,
Okay.
too close to the edge, and literally just drove off the edge.
Just drove into a ditch. Bummer. Everybody's okay? Glad it wasn't you. Yeah.
It's just really funny observing because I'm like,
Not him. Yeah, not him. Look, that's what happens when people are driving too fast and it's like 4 degrees outside. All right. It's why I always say drive fast, dive fast, dive fast. And by the way, ending up with your car in a ditch in Tennessee is a whole different thing because the side of the roads just go like whoop. They just go whoop. Yeah. So we're going through a lawsuit. Go eat.
the water in my water bottle from overnight was frozen. So that was interesting.
Of course the water in your water bottle froze if you left it in your car. It was like 4 degrees last night. All right, love you, buddy. I'll let you know when I'm done. Thanks. My teen is like, yeah, just drove into a ditch. Everybody's okay. This is the thing about high school. It is just teen drivers. So for those of you saying, so not like the ditches in California, no, the sides of the roads, oftentimes for water, it seems to move, have ditches, but you're not like going off the side of a cliff. Sometimes there's that too, but they are not always shallow, but they are truly ditches. The thing about Tennessee is somebody will drive by with a pickup truck and be like, oh, I got you, and just like pull you out of the ditch. Which is a whole different thing. People are just like, I got you. But I keep telling him, I'm like, we did not, well, he grew up driving here, but I'm like, look, driving in cold weather is different. You are a new driver. Slow and steady, like slow and steady, people, slow and steady. That's the way we do it. All right. During labor strikes, they say Lively moves to seize absolute power of the movie. We saw quite a lot of this listed out in the New York Times lawsuit. We're going to get to what they included about this. The dates, though, are helpful. So they had been filming in May. On May 2nd, the WGA went on strike. On June 7th, production was shut down. On July 14th, SAG went on strike. There were those like overlapping strikes that were happening. And so this was the overlapping strikes that put production out of production for almost everything for quite a while. And they use part of this as explanation as we get forward in both lawsuits. Both lawsuits, Lively's complaint and this lawsuit, both of them say, hey, because there was a strike, everyone wanted to move forward with filming the movie. The crew had been out of work long enough money had been put into this. So both sides in this say, because of the strike, we have to get this thing back up and running, and we have to resolve whatever discomfort there is to move forward on set. And everybody wants to keep filming, because if Lively was already taking over the set, why keep filming on their end? And if you are uncomfortable with what's happening in filming, why keep going? Both sides say why keep going is because after the strike, everybody wanted to keep going and everybody was focused on getting the movie done and trying to move forward with one another. So that is part of it. They go on to say Lively expressed excitement over returning to shoot in fall in New York, making no mention of discomfort or harassment that would be brought up only later after months of being apart. And her suit says that this was brought up through HR processes and addressed to Sony, and that it was rebuffed. And so When it was rebuffed, they said, okay, it needs to be addressed before filming resumes. They say Lively didn't bring it up to, it seems, Baldoni. We'll see. They're going to say, hey, this shows that she wasn't uncomfortable and that this was a plot to take over the film. If her lawyers are going through process, I don't know if you expect somebody to bring it up directly. Maybe you do, maybe you don't. We'll see what the emails from all the lawyers are behind the scenes, if there were complaints or if there were not. In some of the text messages, it talks about whether or not there were complaints. So we'll get to that. They say before and during the strikes, Lively's eager involvement in the production took on a more insistent and manipulative tone as she asked for access to dailies, footnote 11, and early cut scenes, both inappropriate and unorthodox requests, footnote 11. This is not a shady footnote. This is an explanatory. This is what we normally see for a footnote, but not in lawsuits. Always the shady footnotes. The sassy footnotes. Dailies refer to raw footage of what was filmed that day, including the many quote unquote takes. This is not shared with cast. But often production. The author was asking about dailies too, which was interesting. This is from a forensic extraction from Lively to Baldoni on June 13th. Hey, would you mind giving me access to dailies? And I'm curious what takes you liked of the scenes you showed. Redacted name, my manager, redacted name. Flew out to visit set, leaves tomorrow. He heard all about it from Warren, and I'd love to show him. I appreciate you may be too slammed right now to make this happen, but maybe someone else can facilitate. Thanks so much. It goes on July 19th from Lively to Baldoni. Hey, I hope you and your family are well. I watched the selects you sent. So great. I was so happy and energized. Such solid work from everyone on and off camera. It was really cool to see. We were working so quickly. There was never the time to look back, so it was nice to revisit from an audience perspective. Please let me know who to reach out to get access to the full gallery of dailies. I'm so looking forward to seeing all we have in the can. And of course, any scenes you cut together, I'd love to see. I hope you're having a good summer and hopefully a good edit. Will your assembly be done soon? Question mark X from July 19th. They go on to say Wayfarrell Baldoni and another producer of the film strategized how to respond to Lively, which became common practice, so as not to trigger backlash from Lively. The text exchange below demonstrates animate objection to giving Lively the dailies. Not only was it an inappropriate overreach, but there was a very real concern that a simple ask, such as rewriting a couple scenes, would turn into a complete takeover, i.e. rewriting the script. They rightfully feared that giving her the dailies could turn into her demanding to edit the whole movie, which is ultimately, they say, what happened. Which doesn't seem to be controverted that there were multiple edits of the movie. I haven't seen any contradiction to that. This looks like it's from July 14th, 2023. It's a screenshot. Oh, it's a screenshot of the text we saw above from the forensic extraction from Baldoni to producer saying thoughts. Producer said, I say no, but check her contract first, lol. And then from Jamie Heath saying, I was waiting for someone else to respond first. Shock faced emoji. It's an absolute no for me as well. Respectfully, not sure the best way to respond, being how delicate it is. Other producer, I think you can either not respond until tomorrow. You can either not respond until tomorrow or say you need to talk to the team or just say, no, you're not comfortable with it. He said, maybe we let this be a Sony decision and you can respond with that for now. It's like, make Sony deal with it. Make Sony deal with it. Tell Sony to tell her no. Baldoni said, thank you. Spoke to blank too. I think I'm just going to say yes and send her a playlist of a bunch of good takes from different scenes that last for 3 or 4 days. Redacted said, no, lol. Producer, we all said no and you're going to send? Question mark. And then presumably Baldoni because he's in blue. And these are screenshotted from his phone. No, she liked the idea of a playlist. No to access of all dailies. I wasn't clear in text producer. Okay, copy. I don't know why some of these are forensically extracted and some of these are screenshots. A couple of you have asked in the chat. I don't know. I really don't know. Maybe because they had already gathered these before. I don't know. But some of these are, yeah, some of them are and some of them are. So they're just like, make Sony deal with it. It reminds me of being at work and being like, yeah, sorry, there's not much I can do. You can go talk to my supervisor. My supervisor can say no. Let Sony say no. Let's see. Producer says, okay, copy makes sense. Basically, send her a playlist of what I showed her agent. And then if or when she responds and says, can you send me everything? That's what I'll say I'm not comfortable with. And that as I haven't even seen everything, Name Redacted believes she will then start to edit the movie and tell me which takes to use if she has access to everything. Producer, yes, I agree with that. Also, this is exactly how the writing process started. She asked if it was okay, if she could take a pass at some dialogue, tweaks on the rooftop scene. Period. This looks like it goes to the next day. Just talked to Blake. She's in very good spirits and seems very happy about this. Very nice conversation. Producer, good. Heath, great to hear. And then a screenshot saying, am I hearing Blake's not available? I don't know what that's related to. We'll see if it connects. They say they were considering how to respond, and then Baldoni politely pushed back. This was from July 20th. Hey, sorry for the slow response. Yes, family is good. Brutal being away for so long and happy we are finally together. Lots happening. All good things overall. Had to hire new editors who I adore. They are going through everything now. I'm so happy you felt energized by what you saw. I think she said that she perceived her performance to be energized, but that's how I read it. Again, we're all reading text messages on the internet that we don't have the entire context to. So this case is going to boil down to, I saw it this way, and the other side going, I saw it this way. And then there will be a whole lot of documents in the middle, and we'll see what happens there. So happy you felt energized by what you saw. Your performance is really, really beautiful. Stunning, actually, regarding the dailies. Obviously, you know, I want your input. That's why I sent the 5-hour playlist. But at this point, it's too early for me to share all the dailies. I start my cut in early August, given the new editors, and still going through the rest myself. Also figuring out our shoot plan as I have to cut and combine and find ways to scale down for budget. Once I am physically in the edit and have touched some scenes myself, I'd love to share with you. Hope you enjoy the time off with your family. Talk soon. They say at this point, Lively reluctantly paid normal lip service to the notion that Baldoni, the film's director, was entitled to that time and space for his directorial cut, but continued to push. This is the same day. Lively said, I don't want to interfere on your time with your cut. Of course, don't feel the need to send me cut scenes. I was just excited to see. Regarding the dailies, none of the producers have access to the dailies, ? It's just you, ? I read that as, who else has the dailies? I don't know. They say that they continue to say that that's not genuine. I read that as, who else has the dailies? They go on to say Baldoni shared limited scenes with Lively, feeling uncomfortable all the while, yet he already knew that he had to bow to Lively's demands. So they're trying to ask the questions of why, and some of you in the chat are saying, no, she's thinking of who else to ask for the dailies. Maybe. I didn't even read it that way, but maybe. Like, what other producers have it? But again, she keeps saying producer, not executive producer. And Emma Max said in the chat, it's why, who else has them, and why do I, a producer, not get them if others do? And they are saying she's an executive producer. And some of you are saying, no, she's fishing for who else to ask. And some of you are saying, I think she feels entitled to it as a producer of the film. And this is why you got to put people on the stand and ask them what they meant when they sent the text. They say finally he put his foot down, sending Lively one final scene and telling her he would not be sending any more cuts. This is from July 20th. Sorry, back-to-back meetings, all good. Love the excitement. I'm excited to show you when the time is right. No, not just me. Redacted and Jamie have access to the dailies, but not the assemblies or cuts. So that's who has them. This is this still about the dailies? August 25th, 2023. So a year before the film's getting marketed. Happy birthday, Blake. Coincidentally, today is the last day of my edit as we are closing the room until we shoot again. It's been wildly successful and I'm so happy. You are so fantastic in the film. I'm sending you over one of my favorite sections. I won't be posting or sending anything to anyone after this, but I'm excited to show you more in person when we come back. Please watch before Sunday as all PIX accounts get shut down on Monday. Until we are back up, can't wait to hear what you think. Have an amazing day. X. The WGA strike ended on September 27th. The SAG-AFTRA strike ended on November 9th. They say months before, Baldoni had made Lively's representative aware that they would continue pre-production in order to hit the ground running when the strikes end. Lively and her lawyers, they say, had been busy devising other plans during the strike. And this gets to the 17-point list of conditions for return to work that we have seen in all of the other litigation, not the PR litigation, and in the New York Times. This is from November 9th, 2023, so before the return to work. Wayfarer team, this is from, they don't list who it's from, but this is from Lively Counsel in the redaction up there, but this is from Lively's counsel. Let's see. With the tentative resolution of the SAG strike, we are writing to address how to handle a return to the set of It Ends With Us, the film. It's no surprise to the film's producers that the experience of shooting the film has been deeply concerning on many levels. The complaints of our client and others have been repeatedly conveyed and well documented throughout pre-production and photography. While we reserve all legal rights, at this stage, our client is willing to forego a more formal HR process in favor of everyone returning to work and finishing the film, as long as the set is safe moving forward. In order for our client to feel safe returning to the production, we are attaching a list of protections that we will need to be guaranteed and observed by the film's producers. If the production is unwilling to accept or uphold these protections, our client is prepared to pursue her full legal rights and remedies. This letter is not intended to constitute a full statement of all facts and circumstances relating to this matter. It is not intended to be, nor should it be construed as lawyers, as a waiver, release, or relinquishment of any of our client's rights or remedies, legal or equitable, all of which are hereby expressly reserved. Sincerely, lawyer. Marvin the Robot in the chat with the super chat said, editor here, it's customary to send dailies out in a playlist during production to all producers. Thank you, Marvin. I think the question will be, do executive producers count? Is there a difference? Is it going to depend on the contract of what the expectations were? And we will see. But thank you for that. Wayfarer and Sony attempted to revise the document to make it factually accurate, being that their representative of set culture, their representation of such culture was inaccurate, and sent comments through Wayfarer's attorney, who incorporated Sony's notes. Lively's counsel's response made it clear they were not open for negotiation. We don't have the response to Sony's. No, we don't have the response from Wayfarer's counsel to Lively's counsel. We only have the response from Lively's counsel. I wonder why that was not included, seeing how much else was included. Normally I wouldn't ask, but when so much is included in a suit, when we get not both sides of the email chain, now I'm curious because everything else is included. If it's not 179 pages long, I'm not asking that question, but because it's 179 pages long, I am asking that question. This is November 13th from Wayfarer team, or to Wayfarer team from Lively's counsel. The list we provided was not intended to be a starting point for a negotiation. Rather, it is a set of protections that we need to be in place in order for our client to return to work. So the lawyer's saying, we're not we're not returning to work without these things happening. That's it. Rather, it's a set of protections that need to be in place for our client to return to work. Let us know as soon as possible whether Wayfair will agree to accept all the protections included in our original communication, including without limitation 11 and 12, with the following additional clarifications. 14, in addition to a stunt double, Wayfair to engage Blake Lively approved body doubles for both characters for all simulated sex scenes. Number 15, this requirement applies to any future filming as well as any footage that has already been shot. Number 16, we can limit this requirement to scenes involving nudity, partial nudity, and or simulated sex. They go on to say it was clear that Wayfair would have to sign the document as is, despite the falsity of its insinuations. Don't do that. Don't do that. Don't do that. I don't know what you do in this situation, but we will see if it's memorialized elsewhere. Leela said, wasn't there 30 items in her complaint? The 17-page or the 17-point memorandum was in the complaint. There was a separate 30-point, like, these are the issues we were having. And then that was distilled down, I think, to the 17. The 17 is what was represented as being signed and agreed to. And the 17 was memorialized in an addendum or a rider. So that's what the 17 points are. But the 30 points were not signed or agreed to. The Baldoni side say they never saw it. Lively side said these are the concerns that we had, and that was for the concerns on set was my understanding of that. They go on to say it's clear that Wayfair had to sign it as is, even though they didn't agree with it and that the insinuations were false. The alternative was to lose millions of dollars, cost hundreds of people their jobs after being out of works for months, and destroy the relationship with Sony. They say the demands themselves were agreeable and some were already in place. So they're saying, look, we agree with the things on set. Some of them are already on set. So it's like, you agree that set will happen. And they're like, yes, set's already happening. Of course, we agree that set will happen. They disagreed with the way it was written and the insinuation, they say. They go on to say to illustrate the distorted and downright fictional basis for the 17-point list of demands. Each one of them is addressed in turn below. And they go through every single one of the 17 points. Why? Well, A, I think for the public. B, because they are saying, again, it's defamatory because this 17-point list was presented to the New York Times as true, and they are saying the insinuations underlying it are false. Does that make sense? So, dual. Intimacy coordinator. Lively demanded that an intimacy coordinator be present at all times when Lively was on set. In fact, an intimacy coordinator had already been engaged during the first half of production. That might be a distinction without a difference, or it might not. Having someone engaged and having someone present on set may be different depending on what was happening before, and depending on the role that the intimacy coordinator was playing. So an intimacy coordinator being engaged or hired versus being present on set at all times might be different. But we'll see. Where were we? The intimacy coordinator had been engaged for the first half of the production. Wayfair took no issue with this request, despite both Lively and her attorney knowingly insinuating that there was none. Again, I don't know if it insinuates that there's none or if it insinuates that somebody wasn't on set. I think having someone engaged and on set may be different depending on circumstances, and I don't have enough information yet to know which one it is. On or about March 20th, 2023, nearly 2 months before filming, Baldoni met with the intimacy coordinator, and in early April of 2023, more than 6 weeks before production commenced, she was engaged. Okay. Lively was aware. Baldoni had informed her in writing, and on or about April 6th, Lively's attorney was also aware. As documented in the May 8th emails between Wayfarer's attorney, within which Wayfarer provides the intimacy coordinator approved nudity rider, followed by written confirmation. So this is the email saying we're attaching the rider from May 8th. We engaged the intimacy coordinator. We're attaching the rider. These are customary rights. Here's all your information. And do you have written approval from the intimacy coordinator for the exhibit that you can share? So back and forth with the lawyers. Hey, it's attached. Let me know if you need anything. Although the presence of an intimacy coordinator is not, so this is not the engagement, this is the presence. Okay. Although the presence of an intimacy coordinator is not a SAG rule, but rather a recommendation, Baldoni was eager to engage one from the start to ensure talent, including himself, felt safe during intimate scenes. It was also important to him that the coordinator be a woman to help, to help craft sex scenes that would speak to the mostly female audience of the book and be written from quote unquote the female gaze, a fact Lively later mocked in both her complaint and CRD complaint, footnote 12. What paragraph is that? Paragraph 34. I wish they would quote it because I don't know what they're talking about, but I wish they would quote it. But they're saying it was mocked. Given both Lively and Reynolds' firsthand knowledge of these facts, Lively's insistence in her November 9th return to work demands on the constant presence of an intimacy coordinator was baffling. However, because Wayfarer had already engaged an intimacy coordinator, they had no issue with the request. Given the request came with the threat that Lively would not come back to work after months of filming and planning. Wayfarer acquiesced. This acquiescence, given with the written caveat that Wayfarer disagreed with the characterizations, was later used by Lively to falsely suggest an acknowledgement that there had not been an intimacy coordinator at all. And I don't remember if it was insinuated that there was no intimacy coordinator at all, or if there wasn't one on set every day. I don't know if it would be normal to have someone on set every day if those aren't the scenes you're filming. It seems like that would be a lot if you're not filming scenes that deal with the intimacy coordinator to pay someone to be on set. So we'll see. But the demand was what? Intimacy coordinator on set. So intimacy coordinator on set. Point 2, limiting review of intimate scene footage to those with essential business reasons. Given that this was already standard practice in the film industry and in practice on the set, Wayfarer agreed to this demand, though without any reason to believe that the demand was made in response to any inappropriate conduct. Despite having filmed for over a month and despite having been provided a nudity rider and the opportunity to negotiate, finalize, and sign, Lively had never asked for a closed set. However, production had always adhered to this and had no problem agreeing to this demand. For clarity, no intimacy scenes were even shot prior to November 9th. So they're saying, why are you asking for this? We hadn't even shot these scenes. And I think the other side is, well, there were concerns, and because there were concerns, these are the things we were asking for. Both sides are like, see this. The return to work demands, therefore, under no circumstances did Lively shoot intimate scenes, quote, without a nudity rider. And it seems that the nudity rider was provided in May. Again, they'll have a date it was signed. They'll have it. It's not like we're not going to know when scenes were filmed or not. That's all going to be well documented. So we'll see. They are saying this didn't happen. There was a nudity rider and it was provided in May. They say the one simulated nude scene filmed prior to the strike on break was a scene Lively wrote, knew of in advance, and directed the action for, and she never requested a nudity writer or intimacy coordinator for that scene. Okay, wait. Was that filmed prior to the return to work, though? Because it sounds like that was filmed. They say nothing was filmed prior to the return to work. Under no circumstances did Lively shoot intimate scenes, quote, without a nudity writer. But then they kind of say that that happened. Am I reading that wrong? Under no circumstance did Lively shoot intimate scenes without a nudity writer, as suggested in her complaint. The one simulated nude scene filmed prior to the strike on November 9th was a scene Lively wrote, knew of in advance, and directed the action for, and she never requested a nudity writer or intimacy coordinator for that scene. Which sounds to me like there wasn't one. But then they had one. That is confusing to me, but that might be the parsing of the language. It is a long complaint. And I don't think you have to request a nudity writer. Isn't that just standard part of your contract? But they also go on to say later that she was given the contracts and never signed them. So all of you are saying maybe simulated nudity. Return to production demands a scene Lively wrote, knew of in advance and directed the action for, and never requested a nudity writer for. One simulated nude scene. Though simulated nude scenes are... Thank you, chat. Leanne said nudity scene and intimate scene and simulated nude scene are different. So, again, parsing. Lively did not shoot intimate scenes. Thank you, chat. Chat, yes, you are reading it wrong. Thank you. Lively did not shoot intimate scenes without a nudity writer. There was a simulated nude scene, which was not an intimate scene, and that was filmed without a nudity writer. Thank you, chat. My brain stopped. They say this demand, as written, suggests nude or intimate scenes were filmed with non-essential personnel present. But, okay. Later in the complaint, Lively alleges that during a scene, the birthing scene, she was mostly nude with her legs spread wide in the stirrups with only a small piece of fabric covering her genitalia. They quote that directly. And that there were, quote unquote, non-essential persons present, footnote 13. And then they cite that back to paragraph. Oh, this cites to the federal complaint, back to paragraph 52. They say this allegation is knowingly false. Again, this goes, well, if that's not in the New York Times, it won't go to defamation. In that case, I don't know if it is or is not. I just don't remember. They're citing it back to the lawsuit, but in the lawsuit, it being knowingly false is not. They're saying, look, we can't believe anything in this because this is completely dishonest. They go on to say, to begin with, to describe Lively as mostly nude and naked from below the chest down is dishonest. Footnote 14. Lively was wearing black briefs and a pregnancy suit that covered her midsection, and her top was covered by a hospital gown. Those are wildly different. And again, are these the same point in time? Because those are wildly different. Being in stirrups naked with a piece of fabric over your genitalia is very different than wearing shorts, like briefs or underwear. Those are not the same. But the complaint says, they've quoted directly, and I imagine that they quoted the complaint accurately, says mostly nude with her legs spread wide in stirrups and only a small piece of fabric covering her genitalia. That is what that says. They say she was wearing black briefs and a pregnancy suit that covered her midsection and her top was covered by a hospital gown. They say her legal complaint, footnote 15, deliberately suggests all she was wearing was a small piece of nude fabric glued around her genitalia by stating that this is generally what female actors wore. I mean, if it says that she was mostly nude, they're stating she was, not that's common practice in the industry. They're straight up saying that that's what she was wearing. So what Lively was wearing is going to come up because guess what? It's a movie set and people are in charge of all of that. So someone will know what this is. Those are two very different perspectives of nude, except for like a piece of fabric, and wearing shorts. That's not the same at all. They say if Lively is referring to her character being mostly nude, i.e. her pregnancy suit was exposed, her statement is misleading and still false. The only nude part of her body exposed were her legs. Again, somebody would have dressed her for the scene. And they're going to say this and this, and that is that. So somebody dressed her for the scene. Again, it's what is wild to me is how different these are if we are talking about the same point in time. And it seems that we're talking about filming a birthing scene. I don't know if there was scene filmed before lunch and scene filmed after lunch, and it was rehearsed with shorts on and filmed with shorts off. I don't know at all, but these are very different recitations of what was happening when that was filmed. It doesn't say when that scene was filmed, but it seems that that was after work returned. So we've gotten to them saying, no, this was completely misrepresented. And there weren't unessential personnel on set. They say, moreover, film footage clearly demonstrates that the set was not chaotic, as she alleges. Only essential individuals were present for the scene and doing their jobs. Lively knowingly and falsely alleges that the film's financier was present during those scenes and insinuates he was watching her nude, which he had no desire to do. He was not even on set during the filming of the scene. Again, things that can be proven seemingly pretty easily. Who was on set and who was not. He arrived later, they say merely stopping by for a brief moment amid his busy business schedule. Business. And was present during the filming of a scene in which Lively's character spoke with a female OBGYN, a scene in which she was fully clothed. They say no spontaneous improvisation of scenes. So this is going through the 17-point document and responding to the 17-point document. No spontaneous improvisation of scenes involving physical touching, simulated sex, nudity, which must be choreographed with an intimacy coordinator. They say contrary to Lively's knowingly false claims, it was Lively who refused to meet with the intimacy coordinator. They put this text in for this same proposition in the New York Times suit. I think the text will speak for itself as we get through this. They say Lively refused to meet with the intimacy coordinator to plan out the scenes, putting Baldoni in the awkward position of meeting alone with the intimacy coordinator and later relaying sex scene suggestions and plans to Lively in the intimacy coordinator's absence. These meetings often took place at Lively's insistence in the couple's home, and often while Lively's husband was present. Lively's method of work was unconventional and uncomfortable for Baldoni. To suggest Baldoni was the one who created this scenario is knowingly false. And then they create the screenshots, which we saw in the New York Times suit saying just hired intimacy coordinator, who I love, will set you up to meet. FaceTime with her next week for intro. Billy Lively said, I feel good. I can meet with her when we start. Thank you. Again, need more information. I'll meet with her when we start. I don't know what time that was, but we don't know what date that's from, but it looks, there's no date on any of this. I don't know what date that is, and I don't know when we start. Baldoni texted this to a female producer saying, just FYI, just wanted to tell you about this. Seems she doesn't want to meet intimacy coordinator until we start. Okay. Which may make which may mess up the workflow, but I can still meet with her, of course. It seems like this was pre-production. That's fine if she doesn't want to meet her now. You'll just have to walk her through what you and coordinator are thinking. Going forward, it says many sex scenes were not written with simultaneous collaboration and input from both Lively and the intimacy coordinator. So wait, were they all writing the scenes? I don't understand. Was it anticipated that they were all to write these scenes together? Because part of the complaint here is that Lively was just writing scenes, but it seems like these scenes were anticipated that they would be written together. They say, as a result, many sex scenes were not written with simultaneous collaboration. It seems like that was expected, and input from both Lively and the coordinator as Baldoni had intended. So it was intended that there was some collaborative writing in this movie, it seems, and that Lively, as Baldoni had intended through, let's see, it says the female gaze that Lively distorted in her CRD complaint and on Information and Belief circulated to the New York Times for its publication weeks before filing her complaint with the court. I don't remember that. We'll see. In the end, they say Lively rejected all of the intimacy coordinator's proposal to rewrite the scenes herself. They say most egregiously, Lively later used these circumstances created entirely by her to accuse Baldoni of insisting Lively do uncomfortable or gratuitous scenes that were in fact proposed by the intimacy coordinator and, by all accounts, very typical asks of any actor performing simulated sex. If they are, so the chat said, writing choreography for the scene, separate from writing out dialogue from the scene. Thank you, Kristen. And less writing, more choreography. That makes sense. Thank you, chat. So, choreography for the scene. Which a lot of you have pointed out and said that would probably have been in the nudity writer. Right. I imagine if you're choreographing scenes, everybody works together on that. Makes sense. Thank you, chat. It goes on to say this is well-documented and handwritten notes Baldoni took during meetings with the intimacy coordinator and later read to Lively. Lively and her recent allegations despite the fact that they were workshopping scenes for their characters. Lively's inability to discern the basic premise of the divide between collaborating on a film and personal interactions with her co-star and director is woven throughout her claims of sexual harassment. They go on to say in support of what Lively positioned as the impetus for these demands, she alleges that Baldoni personally added graphic content, including a scene in which Lively was to orgasm on camera. Oh, back to the argument over who was going to orgasm on camera, which came up in the New York Times. And when we got into that during the New York Times, I'm like, what? What? Okay. They say this is false. During a creative meeting, which Lively requested to take place in her home, Baldoni read to her his notes from the intimacy coordinator, including a suggestion that Lively's character orgasmed during the scene, similar to the book. This is where they're going to come back with a footnote saying, which she would have known if she read the book. Asterisks. The intimacy coordinator is like, it's in the book. And them being like, but it's in the book. Bring the sassy footnote now. Asterisks. Asterisks. Similar to the book, Lively remarked, oh no, I'm too old for that. And I'm just going to say, one is never too old for that, but okay. Oh no, I'm too old for that. And Baldoni offered another suggestion, also from his notes from meeting with the intimacy coordinator, and then moved on. Lively's later complaint sheds light on what this point was alluding to in this demand, which at the time was baffling. And upon review of the filmed evidence, it's unequivocally based on a lie. I think we've skipped into a different section of the lawsuit. Okay. I think we're done with the intimacy coordinator part and we've skipped into other things. Yes, it looks like we have moved on to Lively's later complaint shed lights on what this point was alluding to. What point was alluding to? Are we referencing back to no spontaneous improvised scenes of physical touching? Okay, we're using another example of point. We're only on point 3. Let's see. Lively's later complaint sheds light on what this point was alluding to in this demand, which at the time was baffling and upon review of the filmed evidence is unequivocally based on a lie. Production was filming a quote-unquote romance montage of the characters on their date. One of the producers played music to set the mood so the characters could slow dance. Lively, consistently unable to take direction, insisted that she liked the idea of the characters constantly talking because, as she described, she and her husband liked to keep talking and talking and talking. Baldoni, her director, and the film's assistant director, who was directing the scene, because Baldoni was acting in the scene, disagreed. In an attempt to encourage her to take his direction, Baldoni offered up that he and his wife often just look into each other's eyes silently, to which she responded, quote unquote, like sociopaths, and laughed. Baldoni laughed and shook it off, while Lively once again started talking about how she and her husband can't not talk. Baldoni said, "I think that's cute," and complimented the couple, to which Lively responded, "I think it's more than cute." Lively continued arguing and tried to direct him for the scene while they were supposed to be in character filming the scene. At some point, Heath and another producer, irritated, called Baldoni aside to express that they can't capture the intended shot because Lively won't stop talking. He was instructed to somehow get her to stop. While there was a brief verbal exchange, Baldoni, heeding the instruction of the AD and producers, continued to try to bring them back into character as they were acting in this montage scene. Lively continued to break character and speak as herself rather than as Lily. And this is the back and forth of who was in character and who was not in character, and who was acting out of character. Let's see. As they were acting in the montage scene, Lively continued to break character and speak as herself rather than as Lily, which was extremely confusing for Baldoni, who was trying to balance directing the scene. I thought the AD was directing the scene within his artistic vision while also acting in character while filming and trying to get Lively to do the same. Lively apologized for the smell of her spray tan and body makeup. Baldoni responded, "It smells good," and continued acting, slow dancing as he believed his character would with his partner, which requires some amount of physical touching. Lively took them out of character again and began to joke about Baldoni's nose, which he laughed off and joked in turn, even as Lively joked that he should get plastic surgery. Rude. Footnote 16, Lively alleges Baldoni inappropriately commented on her physical appearance. It was the other way around. I think it's clear from the text of what they said. I don't know if you need a footnote for that, because they are saying that wasn't in character. I don't think that sounds like it would be in character, because isn't this the scene that Lively said was being recorded without sound? Like this scene was meant to be a montage, so it's meant to have music over it and no sound. So whatever back and forth they're having, there's no sound, so that wouldn't be in character. They go on to say Lively, oh yeah, it is. Emily, keep reading. Lively incorrectly alleges that this scene was filmed without sound. Right. Baldoni was wearing a microphone and the entire exchange is captured on camera. Chat, remind me, does it say that the scene was filmed without sound, meaning that this was a scene where, oh, something just hit the window, meaning that this was a scene where dialogue wasn't needed? I don't remember if it was a, hey, there was no sound, or if it was a, hey, there was no dialogue because this scene was meant to have no sound. I don't remember what the initial I don't remember what the initial complaint posited it as. My takeaway from it was that it was a montage, there was no dialogue, and that Baldoni was talking out of character And she said, and it's out of character because this scene doesn't have dialogue. That's my remembering of it, is that it was going to the point that there was no dialogue between the characters and that he was saying things that were out of character. And he's saying, no, you were saying things that were out of character, including commenting on my face. They say Lively incorrectly alleges that the scene was filmed without sound. Baldoni was wearing a microphone. The entire exchange is captured on camera. Any suggestion that this scene was filmed in any manner other than pure professionalism by Baldoni, is unequivocally countered with actual evidence. Her allegation of sexual harassment is a documented and knowingly fabricated lie. A lot of you are saying that this is the scene that was leaked today. I haven't seen it. I hate it when things happen while I'm streaming, because her description of the sound the scene is different than his direction of the scene. Do we need to just go look, chat, at what her description of the scene is and what his description of the scene are as we're talking about this scene? I'm not going to go watch it. We're going to finish getting through this. But do we need to look at both descriptions of the scene? Because if that's all right, I'm not going to go breaking news, look at we'll talk about it later. But I want to, chat's like, yes, pull up the other ones. Okay. We'll pull up the other suit real quick. I'm going to leave this where it's at. So he's describing this scene as a montage scene that was not a scene that had dialogue, that was, Lively apologized for the smell of her spray tan. He said it smells good, continued acting and slow dancing. And then she started making fun of his nose. She was talking out of character. She was being inappropriate. And they are saying, well, let's go see what they are saying in the other suit, because I just do not remember, because there are so many lawsuits. Let's see. How are we going to get to the new filing? Ugh. We're going to have to zoom at some point. Okay. We'll make it work. Where is my other lawsuit? Let me grab it real quick. I didn't have the other federal suit up. Let's see. This one. When the folder has 5 subfolders, it is, and we're only at docket item 1, it's all of it. All right. We're never going to get back to covering everything in all the other suits if everyone's suit is 180 pages long. Miguelina, if you'll look at that and then let me know what you think. Okay, I love the organization too. I love it too. All right, we haven't gone through the federal lawsuit yet. I'll attach it. It's 111 pages. And that is the Lively filed federal lawsuit. Let me see if I can find where this scene is real quick. Let's see. The word smells should probably get us there if we control F ourselves. Okay. There we go. Page 18. We are switching lawsuits real quick to look at how these two, looking at how this instance is portrayed in both lawsuits. So we're going to take a look real quick. We are switching gears from one lawsuit to the other just so we don't get lost, because we don't want to get lost. And that is what it is. No, Miguelina, I have a new filing. All right. Also, if that is wrong button. Miguelina's saying nope, wrong button. That's dropped by TMZ. So I don't know if we can watch it on screen. I'll watch and take a look, but I don't know if we can because TMZ gets all spicy with the copyright claims. Fighting with them is always fun over copyright, but we'll see. All right. Hi, George. Baldoni ignored well-established, this is from Lively's federal lawsuit in New York that was filed on New Year's Day. Baldoni ignored, they say, well-established industry protocols in filming intimate scenes and exploited the lack of controls on set to behave inappropriately. They say that Wayfarer failed to adhere to guild rules as well as Miss Lively's contract and standard industry safety protocols set forth by SAG and others, including the signed nudity riders, though this lawsuit says, we sent them, you didn't sign them. They go on to say, without these protections in place, Baldoni improvised physical intimacy that had not been rehearsed, choreographed, or discussed with Lively, with no intimacy coordinator involved. For instance, Baldoni discreetly bit and sucked on Lively's lower lip during a scene in which he improvised numerous kisses on each take. Mr. Baldoni insisted on shooting the full scene over and over again, well beyond what would have been required on an ordinary set and without any advance notice or consent. On another occasion, okay, not the same thing. On another occasion, Baldoni and Lively were filming a slow dance scene for a montage. So this is what we were just looking at in Baldoni's suit. We are now looking at it in Lively's suit. Baldoni and Lively were filming a slow dance scene for a montage in which no sound was recorded. No, they do say no sound was recorded. So they don't say no, it was a scene without sound. They say sound was not recorded. Right. Mr. Baldoni chose to let the camera roll and have them perform the scene. I mean, that should probably be on information and belief because it sounds like it's not accurate. Baldoni chose to let the camera roll and have them perform the scene, but did not act in character as Ryle. Instead, he spoke to Miss Lively out of character as himself. And he says in his lawsuit, yes, I spoke out of character as a director to tell you to stop talking. That's what. It goes on to say, at one point he leaned forward and slowly dragged his lips from her ear down to her neck as he said, it smells so good. That is a very different breakdown of what happened based on the other recitation of what happened. Again, this is on a movie set. So Rose said, I think she assumed there was no sound recorded as there was no dialogue. It seems so, but it seemed that sound was rolling. So she said at one point he leaned forward and dragged his lips from her ear down to her neck, and he said it smells so good. None of this was remotely in character or based on any dialogue in the script, and nothing needed to be said because, again, there was no sound. Baldoni was caressing Lively with his mouth in a way that had nothing to do with their roles. When Lively later objected to this behavior, Baldoni's response was, I'm not even attracted to you. So that's what it says in the Lively suit. What it says in the Baldoni suit is that she was commenting on her spray tan and body makeup, and he responded, it smells good, and continued acting. He doesn't address her allegations that he was kissing her neck at all. He said, no, she was the one talking out of character and was joking about his nose. We'll see, because again, there will be film. It's a film set. There will be film. So we will see. They say Baldoni was wearing a microphone and that this allegation is documented and knowingly fabricated. What they're going to do is ask for every single bit of raw footage. That's what they're going to do. Every single bit of raw footage, every single take, every single everything. And if they're saying, no, we had sound rolling, then they're going to put that too. So we will see. They go on to say, moreover, it was Lively who engaged in unchoreographed kissing scenes. One scene, again, captured on camera because movie. This trial is going to end up being all of the uncut film A jury's going to spend days looking at uncut or dailies of this film. Moreover, it was Lively who engaged in unchoreographed kissing scenes. Oh, I didn't bing. We're back to the Baldoni federal suit. One scene again captured on camera exhibits Lively pulling Baldoni in to kiss her. It is clear Lively was initiating unchoreographed kissing. The thing is, wouldn't choreography be in the script too? Like, this will all be verified one way or the other, or a third way. In one take, she pulled Baldoni in and kissed him once, in another twice, and the number of kisses, entirely initiated by Lively, changed at her whim. Baldoni, a professional actor who, among other roles, played the lead love interest in TV's Jane the Virgin for 5 years, 100 episodes, is, like most actors, accustomed to rehearsing or filming scenes multiple times, often with variations, without needing, quote-unquote, permission while in character. While Lively now takes issue with any improvisation, Baldoni, as Ryle, may have allegedly initiated while in character. So they're saying this was part of the movie and that may have happened. So they're not saying it didn't happen. They're saying it may have happened, but that it was appropriate as part of the workplace. They say that may have allegedly initiated while in character, any improv that may have happened. Baldoni treated their relationship on camera as professional, each playing their part, each doing their job. So yes, there might have been some improvs on set, but they were perfectly appropriate for the movie. Lively's side saying they were not appropriate and it was not what was expected. If no one was supposed to improvise, Baldoni would have no way of knowing it based on Lively's own actions. Lively demonstrated again and again that this was normal and acceptable part of filming romantic scenes. They go on to say Lively also complains that there was inappropriate and improvised kissing during the first period of filming before the strike break, but in fact, there were only 2 kissing scenes filmed. But couldn't both of those things be true? There were only 2 kissing scenes filmed during the initial filming period. Both were scenes that included kisses as written in the script. These kissing scenes were not improvised. No physical touching of Lively, including hugging or comments about her physical appearance, except in connection with the character and or scene work, not to Lively personally. We're on point 4 of 17. Gabriella said, good night, you guys. It's 11:30 p.m. in Italy. Yeah, it's a long day. It's a long day. Excuse me. All right. They say, to be clear, none of the named parties touch Lively when not in character, especially not in the manner suggested. Baldoni and Wayfarer clearly agreed that coworkers should respect physical space. Lively's constant confusion of references to her character as played by Lively as opposed to Lively herself became problematic and interfered with production. This was caused in large part by Lively's persistent desire to direct and inability to accept direction. For example, her allegation that Baldoni inappropriately called her sexy was in fact a reference to a scene where everyone was wearing onesies, but Lively was covering her onesie with a big coat. Baldoni, her director, asked that she take off the coat so that her onesie would be visible in the scene. Footnote 17. Baldoni said it will be hot as it was 90 degrees in the small bar with no air conditioning. Lively mischaracterizes this in her complaint as Baldoni referring to her as hot, using the slang meaning of the term. Given that Lively herself had earlier expressed to him that she wanted her character's wardrobe to be sexier, he encouraged her to accept direction by saying it's sexy, meaning that without the big coat, the wardrobe was sexier, as Lively had said she wanted it to be. Lively took this personally and was unable to take direction, later alleging his behavior was inappropriate regarding the self-chosen wardrobe, stating, "That's not what I'm going for." Baldoni, recognizing she may have taken his direction personally and appeared offended, apologized more than once. His statements were immediately followed by his gesture that she had something in her teeth as a request for someone on set to get a toothpick This exchange, all of which is captured on camera, demonstrates how ludicrous and deliberately malicious Lively's allegations are. Well, that raises the question, what are the allegations? Hold on, we need... Control F onesie. Never thought I'd say that. I mean, I don't think onesie has ever come up in a federal suit. Let's see. What are the allegations about the onesie? You have a onesie in a bar? I'm looking for it now in the other one because now let's see. I'm trying to find it in the other lawsuit so that we just have let's see. So we have a back and forth of what it is. Okay, we found the onesie scene in the other lawsuit. Let's see. I think this is the onesie scene. All right, this is, yes, the onesie scene. All right. I'm going to attach both lawsuits down below because we're not going to get through. We haven't even started covering the federal lawsuit from Lively. We're not going to get to it today. At some point, we're going to have to get to the new filings from today. But the onesie scene was described. We're just going back and forth. The onesie scene was just described in the Baldoni suit. Now we are going to look at how it was described because now I'm curious in the Lively federal suit. This is from page 23 of 111 in the Lively suit. But at this point, I'm like, I've got questions. Emily Ippolito said, oh my God, it's an actual onesie. I thought they were using the word for romper. No, they were using actual onesies. On another day, it says, Lively wore a low-cut dress to facilitate breastfeeding, but had it covered up with a coat. When the jacket briefly popped open at one point to reveal the dress, Baldoni commented on how much he liked her outfit, which flustered Lively. Later that day, Baldoni pressured Lively, who was in her pre-approved wardrobe, to remove the coat in front of the crew and multiple background actors in a packed bar. He said that he wanted to see her onesie under the coat because it was zipped low to reveal her lace bra. Consistent with past practice, he said, I think you look sexy, in a tone that made her feel ogled, and exposed. With other female cast members present, she said, that's not what I'm going for. He bristled and replied, I'm sorry, hot. Deeply uncomfortable, Lively said, not that either. Baldoni responded sarcastically, I guess I missed the HR meeting, and walked away. Another woman on production spoke to Miss Lively afterwards to offer empathy and to share her own similar experiences with Baldoni, commenting about her in sexual terms. Those are two very different recitations of what happened, and this is what's going to happen. Ambling Soul said, bring on the tapes. That's really what's going to have to happen in this. It's really going to have to be, what is the difference? Because Baldoni's suit is saying, no, I was giving Lively in character scene direction as a director. Lively said, I think he was telling me personally, I think you look sexy. And she was like, wait, why are we talking about me? That's not what I'm going for. And he said, I'm sorry, hot. And he's saying, no, the bar was hot. The bar was hot. That Lively was covering the onesie in a big coat. Baldoni, her director, said that she'd take off the coat so that the onesie would be visible in the scene. This is documented on camera while filming. And Baldoni said it will be hot, as it was 90 degrees in the bar with no air conditioning. Lively mischaracterized it as talking about her. So, again, when you... Just, yes, for everyone in the chat that's like, we're just going to have to... The tape, yes, because the back and forth is so different for both sides. Just so different. We are back as we're flipping back and forth between lawsuits. Cammie in the chat said it's exhausting. It's Imagine what the jury is going to feel like if this ever goes to a jury. And the days of depositions going through whatever is the background of this. It's going to be playing all of this video and asking people about it. Because if it's all on video, it's all on video. So at the end of it, whatever either side interprets, we will see it on video. And at some point they're going to say, I interpret it this way. I interpreted it that way. And then the jury is going to have to, if it ever goes to jury, look at the video and be like, are either of these interpretations reasonable? But as it goes to the New York Times, if there are two interpretations, where does it leave the New York Times in all of this? Lively said she feels like he's directing it at her. Baldoni said, I'm not directing it at you. I'm trying to direct. Back and forth and back and forth and back and forth. All right. And he said, this is all on camera. And I think they put in the note that he was then like, hey, we need a toothpick, as a note that, no, we not only have it on tape, we've seen the tape. So they say all of this is captured on camera and it demonstrates how ludicrous and deliberately malicious the allegations are from Lively. They go on to say, while on one hand, Lively accuses Baldoni of making comments about her appearance, on the other hand, she made derogatory comments about Baldoni's appearance, which is not the heart of any of these suits. It's them saying, hey, she was saying we were doing this. We weren't. She said he was doing it. He says, no, she was doing it. And then it talks about this being something sensitive for Baldoni, and that this comment on his appearance made him uncomfortable, suggesting that he should get a nose job is inappropriate at mildest, is something he expressed insecurities about, and something that he's discussed on his podcast, and is something that he has struggled with, and that it's something that very much bothered him. And that the comment about his nose made him uncomfortable, and that is captured on camera. They say, but rather than write down a list of grievances against Lively, he brushed it off and moved on with the scene. They go on to say Baldoni's sincere direction to what he has repeatedly described as holding... This is a sentence. Baldoni's sincere dedication to what he has repeatedly described as holding himself accountable as a man was being used against him, just as Lively is attempting to do now. To characterize his sensitivity to her personal reaction to his creative direction, which was not only innocuous but well-intended, is malicious. That's a lot of a sentence. To then share this knowingly false characterization with the New York Times for publication months before filing any formal complaint, then waiting nearly 2 weeks to file a complaint with this court, thus depriving him the opportunity to engage in discovery before the damage is done, is inexcusable. They're saying, look, everything she said we did, she did. That's it. She did it. Point 5, no discussion of personal experiences with sex or nudity, including as it relates to conduct with spouses and others. They say when Baldoni was faced with this demand, he was utterly confused. By the time Lively and Baldoni were developing their intimate scenes together, they had developed a friendly relationship and were communicating often over text. Lively felt comfortable expressing herself and appeared to do so freely. She took photos of Baldoni holding and comforting her newborn. This is verbatim pages and pages earlier. Nothing about their interaction suggested Lively was uncomfortable around Baldoni. I don't know what point in time this all is. They go on to say Lively references in her complaint instances that were shockingly mischaracterized and in no way inappropriate or unprofessional. In response to proposal from the intimacy coordinator that Baldoni's character not orgasm after he satisfied Lively, this was in the New York Times complaint as well. Lively remarked, I'd be mortified if that happened to me, personalizing the character's sexual act. Baldoni, following Lively's lead in what he understood to be an attempt to connect with and develop their characters, remarked, "Those have been some of the most beautiful moments between himself and his wife," and then moved on. In another instance, Lively and Baldoni were developing their scenes. Lively said, "I don't want it to look like porn," and then offered up that she had never seen porn in her life, a very personal fact, which she does talk about in her lawsuit in a very different way, saying that she was trying to bring that up to get him to stop talking about his struggle with porn. He's saying, no, she said, "I don't want it to look like porn." She had never seen porn. And he said, that's wonderful, because unfortunately he was first exposed to it when he was 10 and struggled with a porn addiction for a period of his life, and writes openly about it in his book, Boys Will Be Human, written for young boys, and Man Enough, written for men, addressing pornography as a societal problem. And then it goes on to, anyone who knows or has done research on Baldoni would have knowledge of this. It can in no way be characterized as inappropriate. Well, Lively characterized it as inappropriate. Whether that's a reasonable reading of the situation, we will see, but it's been characterized that way. They say she opened the door to the discussion that was highly personal, and that at every turn Baldoni was entrapped, saying she talked about it, and then he talked about it, and then she said, you can't talk about it. Just, again, the wildly different viewpoints of every interaction. What we don't have, though, is any interactions where they're saying this interaction just never happened. It's all, these things happen, but not as they are characterized. They go on to say Lively continued with outrageous and knowingly false suggestions that she was shown pornography or naked images of Heath's wife on set. I don't think she said that she was shown pornography. Are we going to have to go look? We might. Lively continued with the outrageous and knowingly false suggestion that she was shown pornography or naked images of Heath's wife on set. This allegation knowingly and maliciously misrepresents an instance when, in connection with the birthing scene, Heath, at the director's request, Baldoni's request, attempted to show Lively a video that demonstrated the director's vision for the scene. This video, which ultimately was not shown to Lively, even though she stated she'd like to see it later while she was eating. No, as she was eating. Wait, what? Even though she stated she'd like to see it later as she was eating. Is, by all accounts, beautiful. Okay. Since Lively wanted to see it later, what she saw first, what she saw was the first image at the start of the video, which shows Heath's wife, himself, and their baby after his wife gave birth at home, a natural birth or home birth. To characterize this image that captures such a beautiful moment of their newborn baby, shared with the consent of his wife for purposes of the film as a naked photo or worse, quote unquote, porn, is deplorable. Nonetheless, Lively did not object and asked to see the video after she ate, having managed to convince the director to write and shoot the scene according to her specifications. There's a lot in there. Did she characterize the video as porn? We're never going to finish this. Okay. We're going back to the other federal suit, because now I have questions. Because what? All right, hold on. I need to control F and try to find it because this lawsuit is too long and it doesn't seem to want to do that. Why? That's not helpful. If we can't search, we're not going to get anywhere in trying to find it. There we go. Video? You guys are like, just search porn. No. We're control effing video. All right. Birth scene. There was lots of contention over the birth scene. We are switching to the other lawsuit. All right. Let's see how it is characterized in this lawsuit. Context. Okay. On the day of shooting the birth scene in which Lively's character gives birth, Baldoni and Heath suddenly pressured Lively to simulate full nudity, despite no mention of nudity for this scene in the script, her contract, or in the previous creative discussions. Baldoni insisted to Lively that women give birth naked. I mean, I think that is a fair characterization of birth. You do need access. I think that's a fair characterization. I do think in a movie there's probably ways to show that without needing, like, there's drapes and stuff. I think you can show that with legs draped. I think there's a way to do that. But yes, it is normal for people to give birth at least somewhat naked. But yes, a lot of you are saying with hospital gowns over the top half. Yes. Baldoni insisted to Lively that women give birth naked 4 months after she had just given birth, and that his wife had, quote, ripped her clothes off during labor. He claimed it was not normal for women to remain in their hospital gowns while giving birth. Chat, you can decide for yourselves, because you can decide for yourselves. Your experience may vary. Divan Ramuñez, no, I don't think I pronounced that right. Diva Nor Amuños? My brain cannot parse the two. Emily, can both courts use each other's filings? Both of the federal cases are before the same judge. So yes, these two federal lawsuits that we've gone back and forth with are before the same judge. They've been determined to be related. So with them being related, they're going to be before the same judge. So yes, the same judge is going to see all of these filings because the cases are now related. Let's see. He claimed it was not normal for women to remain in their hospital gowns. Miss Lively disagreed, but felt forced into a compromise that she would be naked from the chest, from below the chest down. Footnote 8. Footnote 8. Generally, nudity below the waist in films utilizes a small piece of nude fabric glued around the female actor's genitalia to provide some minimal privacy without disrupting the shot, because that fabric is not able to have visible straps from profile camera angles. Okay. Tape glued on without straps. So that's footnote 8, which I think we saw reference to earlier in this lawsuit. It goes on to say, when the birth scene was filmed, the set was chaotic. We've already seen this part referenced previously, saying that video shows it was not chaotic or crowded or lacking in standard protections. They go on to say, such as choreographing the scene with an intimacy coordinator, having assigned nudity rider. I don't know what date this was filmed. I would like to know when this was filmed at this point. Nobody's put a date in here. Tell me the date. Because at this point, the conversations with the lawyer over the nudity rider were happening in May. They're saying standard protocols weren't adhered to. The Baldoni lawsuit says that they were. They go on to say Mr. Heath and Baldoni also failed to close the set. What we just saw in their lawsuit is they say no, she never asked for the set to be closed. They say allowing non-essential crew to pass through while Miss Lively was mostly nude with her legs spread wide in stirrups and only a small piece of fabric covering her genitalia. The Baldoni suit said that she was wearing briefs. They go on to say among the non-essential persons present that day was the Wayfarer chairman, Mr. Sarowitz, who flew in for one of his few set visits. Lively was not provided with anything to cover herself between takes until after she had made multiple requests. This might be lawyer parsing. The other suit said that he didn't arrive till after this was filmed. They don't say when he arrived. They say he was on set that day. They don't say he was on set during that scene, but it's written in as they are talking about the scene. The other suit says he wasn't there during this scene. It was a later scene. Either way, it seems accurate that he was on set that day. And they are saying him being on set that day when these scenes are being filmed was not appropriate. They say it was after this scene was done. Script supervisor. Somebody will know who's on set. They go on to say Lively was not provided with anything to cover herself between takes until she made multiple requests. And Lively became even more alarmed when Baldoni introduced his quote-unquote best friend to play the role of an OBGYN, when ordinarily a small role of this nature would be filled by a local actor. When we get this is all addressed, that the best friend is, in fact, a very well pedigreed actor. And that is well documented. So does it shock me that somebody would introduce a friend in their industry as a friend, even if that friend is also an actor? No, it doesn't. When we look at all the things in this lawsuit that are, I interpret it like, it seems that she interpreted that to mean that this is a random. And it seems from the other lawsuit that they are friends and the friend is an actor who was hired. It goes on to say Lively felt the selection of Baldoni's friend for this intimate role, in which the actor's face and hands were in close proximity to her nearly nude genitalia, was invasive and humiliating. We'll get to that in the other lawsuit because that is addressed. I was just trying to get to the video part. It goes on to say, to add insult to injury, Heath approached Lively and her assistant on set and started playing a video of a fully nude woman with her legs spread apart. Miss Lively thought he was showing her pornography and stopped it. Heath explained that the video was his wife giving birth. Lively was alarmed and asked Heath if his wife knew he was sharing the video, to which he replied, she isn't weird about this stuff, as if Miss Lively was weird for not welcoming it. Lively and her assistant excused themselves, stunned that Heath would show them a nude video. So that's the difference between the two different lawsuits on how that happened, where she's saying, what is that video? I don't think she calls the video pornography. They say it is disgusting of her to call the video pornography. In this lawsuit, I don't think she called it pornography. I think she said that was her interpretation. Like, what is that? They said that's not a fair interpretation. The two sides of this are very different sides of every single instance. This is going to take so long for the courts to parse through. Okay. It goes on. We've switched back. For everyone in the chat saying we need the cast and crew. Yes. Lindsay said the delivery doctor was a famous actor. At least a well-regarded actor. We'll get to that. I don't know how we categorize famous. I don't know what it says down below. But he seems to be a very well-known and credentialed actor. Is it weird to me that actors have friends that are other actors? No. Is it weird to me that somebody would introduce a fellow actor as a friend? No. Does it seem like she interpreted that as some person who'd never acted before? It seems that that's the interpretation. It seems that that's wrong, but it seems that that's the interpretation. Let's see. They go on to say that the depiction of the video as porn is deplorable. I think that's lawyers being mad. Point 6, no one to enter Lively's trailer while she was undressed. To suggest this ever happened is illogical and categorically false. Not once would or did anyone enter Lively's trailer without knocking first and asking permission. Again, that's not what's said in the other lawsuit. More than once, Lively invited Baldoni, Heath, and other producers into her trailer so that she could multitask, understandably balancing motherhood with her work obligations. They say regrettably, well, when I'm trying to... Google Docs, go away. Oh, it's because I'm zoomed in too much. Google Docs is like, no, stop covering all the text. I can look at the complaint. Ali C said, I think the complaint says it's porn. Fair enough. We can take a look. I think because they do go back and forth between the CRD complaint and the federal lawsuit. In the federal lawsuit, it was believed or concerned that it was. We'll see. So they say balancing motherhood and work obligations, well, regrettably, while accommodating Lively, Baldoni and Heath were led into situations that would later be characterized as harassment. Lively herself invited Baldoni to her trailer to work on lines while she pumped breast milk. Lively regularly breastfed in front of Baldoni while they had meetings. Heath was invited into her trailer for a meeting at her request while she was having makeup removed from her collarbone because she was not able to meet at another time. She characterizes that as that meeting was forced at that time and she wasn't comfortable with it because he was not available at other times. They're saying she said she was not available at other times. Regardless, it seems like there's at least a nanny, makeup artist, and assistant present. In this instance, he was instructed to turn away while they spoke and respectfully did so while they figured out a time and place to meet the other producers. It goes on to say, well, it's possible he inadvertently made eye contact at one point. He does not recall. Lively later mentioned that he did, and it made her uncomfortable, to which he responded, I'm sorry, I really didn't realize. And she said, I know you weren't trying to cop a look, but they say she was covered and having body makeup removed from, the collarbone. They go on to say Lively's suggestion that not one but two professional and conscientious men barged into her trailer several times or attempted to enter or persuaded her to allow them to enter offends not only their long established integrity, but the sanctity of their vows to their wives and their dedication to their children and family. Lively is aware that both men are incredibly supportive and respectful of motherhood, to say the least. And then they get into that their wives work in this space and they have wives that have had children. They go on to say no filming, point 7, no filming nude or sex scenes except per nudity rider and no use of prior nude scenes without nudity rider. Lively was provided a nudity rider approved by the SAG intimacy coordinator and was given ample opportunity to provide notes before production commenced. Despite constant pursuit over several months, Lively's attorney never produced notes, and Lively not only didn't sign the nudity rider during the first phase of production, but never even signed her employment agreement. Like ever? At some point, don't you have to sign it before people get paid? It goes on to say her main point of, she didn't sign the nudity rider during the first phase of production. It sounds like it got signed before the second phase of production, but never even signed her employment agreement. Was it signed at some point? Because do you pay someone without signing it? They say her main concern while Wayfair's lawyers were all but begging for signatures was ensuring that her fee was deposited into escrow. In order to move forward, they had to pay her fee even though she hadn't signed her agreements. I would imagine that at some point it's signed. Let's see. The rider was provided to Lively's counsel on May 8th, 2023. Wayfair's attorney communicated that they would like it signed by May 11th and requested they send notes. On May 12th, Lively's attorney finally responded that they were reviewing the rider, would come back with notes, and then their focus shifted to the escrow deposit. They say Wayfair sent repeated requests for Lively to sign the customary certificate of engagement, footnote 18. Ultimately, despite constant pursuit, it became clear that Lively had no intention of signing the nudity rider or her contract at that time. I'm curious as to when it was signed. I know, for those of you going, how are we at page 60? I don't know. We're 5 hours in. It's so much, which is why there was no time to do it in an hour on Thursday. When working with an actor, this is the footnote, when working with an actor who may take time to sign the main actor agreement, it's customary to send a certificate of engagement to protect the copyright of the film. Wayfair negotiated the terms of said certificate of engagement. But though it was approved by Lively's counsel, never received a signed copy. Again, things that will be easily proven one way or the other. So Chetta asked, are there any criminal charges filed? No. And I don't think there will be. This is, on Lively's end, a workplace harassment retaliation case, and on Baldoni's end, a defamation breach of contract case. Ked said, I left a meeting a couple hours ago, and I'm still surprised you're still here. It's the longest, they are the longest complaints, and we've gone back and forth between the two a couple times. Lively's counsel, on Wednesday, July 5th, 2023. Hello, I hope you enjoyed the 4th of July. Very confused at what's going on here. This is from Wayfarers Council. Escrow has been made in good faith. We still don't have a signed COE, and that has been confirmed for almost 2 months. Also, we still don't have the SAG start paperwork, which has been outstanding for over a month. Lastly, please confirm the last 2 payments are still being held in escrow. Thanks. So Wayfarers Council in July is saying, hey, where is all of this? Get us the paperwork. The thing about these emails is there will be a ton of these emails back and forth, and the dates will be known one way or the other. They say months later, the demand for a nudity rider became part of the 17-point demands and presented as if it were Wayfarer, not Lively, who caused the absence. They also stated any footage previously shot without the rider in place may not be used without Lively and her legal representative's consent, despite the fact that no simulated sex had been filmed yet. Point 8, Lively entitled to a personal representative on set. They said fine. Notice of COVID exposure and Lively's complaint. I don't know about the federal complaint, but in the initial complaint, it says that Lively had been exposed to COVID and her baby had been exposed to COVID and they weren't told. They are saying that they had COVID protocols in place. No retaliation for requests. Point 10, Wayfarer in no way conceded that Lively's demands amounted to a report of genuine sexual misconduct. Wayfarer had no interest in retaliating against Lively for making these demands. Their only desire was to make a great movie. In the interest of maintaining a professional and productive atmosphere on set, they agreed to meet all of her demands, including a broadly defined statement that they would not retaliate in any manner, including quote unquote sarcasm. That is in the 17 point. It is written in there, including sarcasm. Yep. Wayfarer agreed, though later it became clear that Lively would consider any effort to push back against her demands with respect to production as unacceptable retaliation. I mean, in her litigation, they say that the retaliation is the social media smear campaign, which we haven't even gotten to yet. And I don't know if we're going to get to today without having to zoom a little bit. For all of you saying, what's the likelihood all of this will go away? It's going to take some time. But we had new filings we needed to get to, and we're still not even there yet. So let's see. Point 11, mutually agreed Sony representatives. Aaron in the chat asked, you can't tell someone not to be sarcastic. That's a First Amendment violation. No, the First Amendment applies to government agencies. There are things that parties can contract to, and this can be contracted to. Just like in work agreements, things can be contracted to, like what you can and can't post on social media, and you can contract to NDAs that you don't disclose information. I mean, that's a restriction on speech, saying, hey, you can't disclose this information because you can't tell someone what you learned here. But those can be contractually determined, and this was contractually determined. For all of you in the chat saying I'd be immediately fired if somebody tried to imply a no sarcasm rule, yes. They were like, okay, we'll sign it. But no, not a First Amendment issue, a contract issue. So they go on to say mutually agreed Sony representative required on set. They said that was happening. Wayfarer agreed to the concept of having a Sony representative on set whenever Lively was on set, though it gently pushed back on the idea it always had to be this particular Sony representative who might occasionally have other pressing work obligations. So it sounds like there was a Sony rep on set at least when Lively was on set going forward. Point 12, additional Lively approved producer to be hired and supervise filming. They agreed on one. That happened. Point 13, existing third-party producers empowered to actively supervise production, while disagreeing with the suggestion that any producer did not have appropriate and customary authority to actively supervise the production. In their capacity as producer, Wayfarer agreed to this term. Any third-party producer was already empowered to do so. Wayfarer to use Lively approved body and stunt doubles for intimate and sexual violence scenes, and they talk about them being pre-approved. Ultimately, they say no body doubles were used in the film at Lively's request. Lively and Baldoni displayed a courteous and professional relationship throughout phase 2 of the production. No filming of scenes except per the nudity rider. They are saying that this request was an overstep and an attempt to expand Lively's right to her own nudity rider, and assert control of the nudity rider of another actor who portrayed young Lily. While seeing this as an infringement on the young actor's independent right to her own rider, Wayfarer once again was forced to agree while informing Lively that young Lily had already filmed her intimate scenes pursuant to her own nudity rider, which is, I don't know what contract would extend to another actor, even if they're portraying different versions of the same character. I have questions. Point 16, all day players must be hired through talent agencies, not personal connections. It seems that this stems from the best friend. They say this point appeared to relate to Lively's misleading claim that Baldoni inappropriately cast a personal friend to play the obstetrician during the birth scene. They say Baldoni casting an experienced actor who happens to be a friend is no different than casting Lively's sister, who was cast because she was Lively's sister. They're like, hey, we're not the ones out here casting friends. You are. The actor portrayed playing the obstetrician is an award-winning Shakespearean-trained actor, and then they go through his accolades, saying that he is, in fact, a working actor, and that it does not make sense for Lively to be alarmed when Baldoni introduced him as his friend and allowed him to play an intimate role. They say that categorization was invasive and humiliating, and Lively's suggestion that a highly trained and experienced actor would have unseemingly interest. That should be unseeming, isn't it? Unseemingly interest in being in close proximity to her nearly nude genitalia, which, as previously established, was not nude or exposed. That is inappropriate, invasive, and humiliating to the actor. They're saying this actor was hired and he is an actor. It's okay if he's an actor that we know. We hired your sister. We hired an actor who is a professional actor, not somebody who's never set foot on a movie set before. They said to retaliate, Lively knowingly made a false statement that only a small piece of fabric covered her genitalia during the birth scene. They say, in fact, she was wearing briefs and a hospital gown. They covered that earlier. All hands meeting. Wayfarer understood this request to be a sincere offer to meet and discuss the needs and preferences of Lively and other cast members to ensure comfort and security while filming a movie that dealt with difficult themes. In spirit, Wayfarer readily agreed, believing that an opportunity to discuss concerns openly and plan resuming production would be welcome. As will be established, Wayfarer's good faith could not have been further from the truth. Importantly, Sony, who had a representative on set, found the 17-point requests confusing as well. It goes on to say Sony Business Affairs to Jamie Heath on November 10th, so the day after the lawyers sent the email. Hey, Jamie, took a look at this following our conversation. No change in my mind from what we discussed last evening. Items 1 through 10, 15, 17, basically, yes, of course. Interestingly, I'm surprised that you don't already have a negotiated nudity rider in place, given the subject matter and content in the book. Or am I misinterpreting her comment? Items, and again, those were being sent back and forth in May. So by November, you would think that they would be signed. The emails were happening in May 2023. So it says that should be in place, question mark. Items 1 through 13, I'd want to hear more about what is underlying and what she's hoping to accomplish, respectfully, of course, in the hope that some combination of the studio representative and the empowerment of Alex, the producer, presumably, whatever that means, again, hope for clarification, might mitigate the need to engage an additional A-level producer. Item 14 is another question mark, since it sounds like she approved the engaged stunt double. Like, why are we asking for a stunt double? We already have a stunt double. Why do we need a stunt double? We have a stunt double. Further, as discussed, overall, the tone of the response has to be part denying the underlying insinuations, allegations, but doing so in a way that doesn't inflame or escalate further, since most of what's on the list Wayfarer is acknowledging addressing, And of course, any unease on her part is of paramount concern to the production, and you all are committed to working with her to ensure that she's comfortable with the plan and the execution of the next few weeks in order to complete photography, right? Like, we're all committed to getting this done, right? Right? Sony, like, please just finish filming. I'm going to send a copy to folks internally and ask that our production attorney offer any assistance. If you get a lawyer letter, send it to the lawyers. All of the lawyers. It is starting to get dark outside my house. That's how long we've been streaming. So we started late for book. We're not going to finish. For all of you saying it's 179 pages we have to finish, we're not going to have time to finish. But we'll get through some more of what their key conversations are. The 17 points, I think, are one of the, for all of you saying send it to Daryl, yes. All of you, chat, just send it to Daryl. The 17 points line out the, hey, we understood what was happening with this film, and everything that went on set, and it was fine, and it's all being mischaracterized, and there was no smear campaign. We haven't even gotten to that part of it yet. This is all just addressing the sexual harassment claims, because one of the claims here is that the underlying sexual harassment that was lined out in the New York Times article didn't happen. So they're going page by page by page by page saying this is not represented accurately, and that's why it's defamatory, because you know it's not represented accurately. So, because we're in the public figure defamation with the willful disregard, with the the malice, which doesn't mean the ill will, but means the willful disregard of the truth. And they're saying this all is willfully disregarding the truth. And they say that was the groundwork for what they say is the extortion and taking over the film. That all of this led up to taking over the film. For all of you saying, "Who?" Music to My Soul said, "Who is Daryl?" It's a callback to Vanderpump Rules and Lala Kent's "Send It to Daryl," which is the lawyer when all of the stuff was going down on Vanderpump. What was it, a year ago at this point? So they go on to say that all of that was mischaracterized. All of that was not how things went down on set, that this was a professional set, that all of that is blown out of proportion, and it was done so that the movie can be hijacked, essentially. Let's see. It goes on to say that when they were getting ready to return to work, Lively had more script notes and changes beyond what was already done. And in the face of these terrifying and false accusations couched as demands, as well as Lively's threat that she would not return to production, Baldoni realized he needed to cede control of the script to Lively as she wished. So this starts getting into the very, very vast differentiations in these two lawsuits. The Lively lawsuit saying stuff on set was not okay. I was harassed on set. Others were harassed on set. We reported it. Nothing happened. We wouldn't return to work until we reported it. And because of putting the foot down on that for the return to work, there was retaliation in the form of a quote unquote social media smear campaign. Baldoni's side is saying all of this was grossly mischaracterized and exaggerated and was used to wrest control of the film and take over the film. And also there was no smear campaign. So it goes on to say that Baldoni realized he had to cede control. His film would be taken away from him by threats of coercion or threats and coercion, and there was nothing that could be done about it. In an email to his team containing notes on the revised script, he expressed his sadness and frustration over Lively's takeover of a film that they had spent years developing, writing, funding, having no energy left to fight. I'm not going to read their characterization of the emails. We're just going to go to the emails because we'll just go to the source material. It's summarized above, but we're going to read the whole thing anyway, and that's why we're here 5 hours in. December 27th, 2023, Baldoni to members of production team and including Jamie Heath. Hey team. So we are after the return to work, after the all hands meeting, after the 17-point document, after all of it. Hey team, attached is a revised script with the below notes, caveats in bold. This is not final, as there are things we need to discuss and then implement. Also, I have added in redacted name, our AD, to have eyes on this so he can digest at the same time as all of you. I appreciate that they've highlighted in different colors what they want to highlight about these emails. I've spent the better part of the last few days trying to figure this out. Everyone knows how I feel about all this and how angry I am that Blake has taken over our film and somehow rewrote a movie we spent years developing, writing, and funding. So yes, I am furious and sad. I will continue to get back up with the goal of getting us to the finish line. I have come to terms with the fact that this is the only way through. I'm waving the white flag and submitting. I am going to give her 98% of what she wants. I'm sure none of us have the energy to fight anymore. The team who has been working their ass January 2nd. So here we are. There are minor things I did to each scene. Some I made notes on, and teeny ones I didn't. Most of what I touched is below. The big issue are going to be intimacy, how and what we are shooting for these scenes, how this script is going to be presented to her and with what notes. To that end, it's so much harder to read highlighted in green. To that end, we all need to get on the phone and talk through it, as the risk of something innocuous or not meeting her standards could and would very likely be used against me, as it already has. And creatively, it's impossible in an environment shrouded in fear. And creativity, not creatively. Creativity is impossible in an environment shrouded in fear. By now, we all know what she is capable of. So that email that they included is from Wednesday, December 27th, 2023. Again, will the contemporaneous documentation of things after that meeting make more sense than what people are saying now? We'll see. What other emails are there? We'll see. But this is the internal team of Wayfarer going to how they are feeling about this being taken over, and how they're feeling about, well, now there's nothing we can do. We've had the 17-point document, and now there's nothing we can do, which means the underlying of all of this, the 17-point document, is going to be what happened on set, and was what happened on set completely misinterpreted by two parties, or was it misrepresented? Where is the truth in all of that? So Baldoni is saying, I give up. I don't know what we can do. We're stuck, and we've seen what happened. We've seen the November 9th document, and now we know. They go on to say, a producer thanked Baldoni for his thoughtful breakdown, especially considering the circumstances, on December 28th. Thank you for this thoughtful breakdown, JB, especially this week, and especially considering the circumstances. I'm free after 2 p.m. And then they go on to say they continue to work on filming. They continue to try to meet Lively's demands, recognizing that they would be in negotiation for what the final script looks like. This is January 1st. Between Baldoni, Heath, and members of production. Hey, buddy, unfortunately, it looks like we're not going to be able to send anything until Thursday night or so. I'm not quite sure how to handle, but I'm doing these small rewrites, and I'm going to be sending back to producers and all of you, and they're going to send it to Blake. And then we will be in negotiation for what a final script looks like. And then they're getting ready for the final set of filming. They say Lively brought Reynolds as her chosen representative. Notably, she did not request any attendees from her union, the Screen Actors Guild. Together, Reynolds and Lively blindsided the rest of the group with a list of grievances. This is the meeting that we saw in detail in the New York Times lawsuit. I don't know what day this happened, but they say it's the day before filming resumed. And everyone at that meeting included Baldoni, Heath, Sony representative, the film's first AD, and two producers, and Lively and Reynolds. So there's a lot of people at this meeting. Like a lot of people in this meeting. This we saw in the New York Times suit. Let's see. They say Reynolds demanded that Baldoni apologize to Lively for actions that had either never happened or had been grossly mischaracterized. Baldoni resisted apologizing for things he had not done, further enraging Reynolds. Everyone, including the producer, Lively, had asked the production to engage, and the Sony representatives left the meeting in shock. The producer said that in his 40-year career, he had never seen anyone speak to someone like that in a meeting. The Sony representative said later that she often thought of the meeting, and her one regret was not intervening to stop Reynolds' tirade against Baldoni. And if, again, there's a lot of people at that meeting, they're all going to be deposed. And they're all going to be deposed. So that's, again, a lot of people at a meeting. They go on to say Baldoni and Heath left the meeting deeply unsettled by the behavior and the power dynamics at play. It was clear to them that this was the last escalation in Lively's concerted campaign of extortion to extract concessions and creative control over the film, a campaign now apparently joined by Reynolds. I still don't understand why. Why? And they say in this that the why is ego. I think at the beginning of this is a lawsuit. This is a lawsuit. They go through that there's a calculated ego play to take over the movie. None of this takeover of the movie is addressed in Lively's suit at all. We'll see it maybe in the response. I imagine we'll see it in the reply because, well, they're going to have to put it in the reply because it's all in here, but it's not in the other suits from Lively. They go on through the list of grievances. They say it's crucial to note the list of grievances was read in the January 4th. Oh, there's the date. The January 4th, 2024 ambush were new and separate from the 17-point demand. So there were new grievances at the meeting that were not part of the 17-point demand. This was the 30-item list from the CRD complaint that was the meeting notes. So the meeting notes being that 30-page list, then the 17-point demand that had been signed, that was presented on November 9th and signed over 2 weeks after the meeting on January 19th. They say the CRD complaint on information and belief she disseminated to the New York Times well in advance of the filing is riddled with blatant and deliberate misrepresentations, as is the complaint here. They go on to say filming resumed the following day and then concluded without any further grievances or references to previous disputes by Lively. The parties agreed to implement and follow the protections for return to work. This is from the complaint. Which one? Footnote 19, the CRD complaint. Went back to filming to film it safely and successfully, and it was. Production of the film resumed January 5th, concluded February 9th. They go on to say Lively had unleashed Reynolds on Baldoni and Wayfarer. They felt powerless to oppose the couple. Just as Lively had warned in April 2023, 9 months before, Reynolds would ensure that Lively's demands were met at every turn. From then on, Lively would get her way or else. Unmistakably, they said Lively would use her carefully constructed paper trail to destroy Wayfarer, Heath, Baldoni, and the film. They talk about the usurpation of the film. We saw this in the New York Times as well. And we've seen it above as well. We're going to get to some of the other text because I do want to get to the some of the text messages, and B, to the new filing that we're not going to get to if we don't get through all of this. Some of this is in the New York Times suit, but we're on page 71 at F. Again, this will be linked down below because we are not going to have time to get through the rest of it today before I have to, make dinner for the kiddos. So they are saying this is the beginning of the takeover. Let's see. This text, notably, despite her allegations that Baldoni made her uncomfortable, Lively insisted on working closely with him through the process. This is from February 25th, 2024. So this gets into the editing and wanting to work in the editing and wanting to closely edit together, saying from Baldoni to Blake, good morning, Blake. Redacted name and I had a great chat the other day, and he let me know you'd like to come into the edit before you leave for your film, and I think it's a great idea. I agree that we work really well together, and with all you've put into this film, I completely understand wanting to give notes and have input before you leave for your other movie. With that, I started my cut on Thursday, so tomorrow will be day 3. The movie is currently all over the place, and I need a few weeks to get it into some sort of shape to even present to you. What I would love to do is to bring you in on the 18th and have us work together until you leave. Did I hear the first week of April, ? Then once you are in Italy, as things progress, you can jump in on any free days or even on days you have long wait times between scenes. I'm happy to send you progress, scenes, etc. with any big changes that are made. And we all know things change all the time during the cut. For me, the editing process is the time to try things and throw it all against the wall and see what sticks. It's my favorite part of the process. So once you take off, we can just keep you in the loop and send you stuff to the extent you want to see it as we get closer to locking the picture. So it seems that, hey, we're trying to keep you in the loop. In response to that, Lively said, hey, thank you for the note. I appreciate it. I'd love to be in the passenger seat with you as soon as possible. I don't need you to formally present anything. I understand you've just seen the first assembly and have a mountain ahead of you. I'll be invaluable to you in recall alone as you put together what you're looking for. I've also been watching all the dailies, tons of nuanced gems. The sooner we put our heads together, the better. Very excited to dive back into work. Let me know. Hey, Blake, I hear you. And I do know how helpful you've been and continue to be. I do need some time to get sorted with my editors and wrap my head around the film itself. I'll reach out to you at the end of the week and let you know what progress we've made. So in February and March, Baldoni ceded to the request that Lively, or it said acceded to the request that Lively be let in to the film. And that seems to be what is happening. We saw these texts with editors in the New York Times suit as well. So I'm not going to read them verbatim because we covered them in the New York Times suit with the editors saying, I mean, okay, whatever's best for the movie, we'll deal. And they put in numerous of those. We're on page 74 and 75. If anyone wants to go read them in full, talking about putting together the scenes, showing the scenes to Lively, and Lively getting in and editing. They say that this was all part of the takeover. She wanted to be the director and see her own creative direction for the film realized. And the editors, it looks like by the note typed on the top of this that we are now in March, with the editors talking back and forth about when Lively would have access to PIX or PIX, the software, it seems. And then when she was going to come into the editing bay, conversation between Baldoni and the editors. Editor 2 saying, I want Blake to feel like she's getting what she wants so we can move on from this need of hers. Like, can we just be done? For the record, she's getting what she wants this entire movie is from Baldoni. And the editors go, yes, and true. Editor 2, I don't want to give her any opportunity to say, well, because blank was in LA, we could only work on certain hours, so I need more time and I didn't really get what I needed or whatever it may be. So it sounds like the editors are all having a conversation to be like, can we do this quickly and be done so we can finish editing our movie? So correspondence back and forth and back and forth. Editor 1, you're definitely nicer than I am. I wouldn't want to stay here and make it less convenient for her since she's going to be on a completely different time zone. Justin has bent over backwards for her for months on end. I don't think you should have to do that too. Either way, you should just do what's best for you, not her. Editor 2 said, if it were Texas or some random place, I'd be much more resistant, but I'm a New Yorker. So some of my best friends live there. So I love going to the city. It's like, well, if you were going to make me fly anywhere else, I don't want to go, but we'll go to New York. That's fine. And then they're talking about when they're getting together to do that. And the editor is saying, look, we're letting her into the editing process, even though they're resistant to it. In April and May, they say Lively's extortionate threats coerced Sony to allow her to create her own cut. This is where they start getting into talking about the extortion. I still don't see how they bring in Lively or anyone extorting the PR agents. They're saying that these demands are forcing Sony to allow them to allow her to make a cut of the film. They say that's a right exclusively reserved for directors. Oh, my mouse just completely disconnected. Well, the mouse is like, hey, we're done. Really? Really? Just really? Really? Oh yeah, completely dead. Hold on. We need power. Where are my cords? We can't scroll through a lawsuit without a mouse. Give me 1 sec, you guys. I'm gonna have to find a power cord. The mouse is like, we're done. 5 hours is the limit. We're doing no more. Hey, B, my computer mouse. Oh, can you help me out? My computer mouse just died. Yeah, come on. Can you grab me? Can you grab? Yeah, I'm still live. I'm trying to finish up, but my mouse died. Can you grab me that?
Grab you what?
The charger. We'll see if we can hook the mouse up to an external charger and see if it will work. Thank you, B. Dr. B to the rescue. The charger has a cord in it. Thank you, B. Mm-hmm. I'm trying to be done. We are still not done, but we are going to have to get to the new filings.
What are you like on page 2?
Yes, we're on page 2. We're on page 2 of 9,795. Uh-oh. No, I need a different cord. Will you see if Travis has a USB-C to Lightning? Hmm? Yeah, I need a USB-C to Lightning. Please. Please. Thanks, Dr. B. I forgot that this mouse is a Lightning cable. Give me 1 second. Let's see if I have one. We're going to see. I moved everything in my office. So moving everything in my office, we're just like, let's see if we've got one. Hopefully we do. These drawers used to be accessible when I was on screen. Can I change the screen? No, we're out of luck. When did the mouse say it was running out of battery? Never, chat. It said never. When's the last time I charged my mouse? I do not know. This is not the right cord. This is not the right cord either. No. This is not helpful. Oh, it's a streaming crisis, chat. Nope. I redid the office, lost my cords, wrecked my toe. Streaming is dynamic. The mouse doesn't have batteries because it's a Magic trackpad, but my cords are over here. Hold on. We'll be back. I'm not leaving. I hear feet. My family is trying to find a cord. Of all of the things that have happened while streaming, the mouse dying is not something I ever anticipated. Hopefully one of these has a USB-C to Lightning in it. Otherwise, we are very out of luck. Or Dr. B comes back with a USB to Lightning because it's Dr. B has run a marathon.
I didn't go upstairs.
No, USB-C to Lightning. That's USB.
Yeah.
No, I need USB-C to Lightning. I need USB-C to Lightning, Dr. B. That's not going to work.
Well, why didn't you say so?
I did say so. We can roll the tape. We have it on film.
What?
Wait, no, don't take the mouse.
What?
Don't take it away.
Do you have what you need?
I don't know. Wait. USB-C to Lightning. I have. Huzzah!
Huzzah.
Huzzah! Chat said she did say so. USB-C. You tried.
Roll Roll back the chat.
I can't.
Let's
The
show
chat
it.
said,
Where-
show us the
where is
tape.
it?
Show us the tape. Hold on. Let's see if this works. We have now an external charger, USB-C to Lightning. So hopefully the mouse comes back and we can continue to scroll. Thank you, Dr. B. Appreciate the effort. I'm sorry. I appreciate your specific contribution to bringing me the wrong cable. The look I just got. He's like, are you joking? Thank you for the IT support. Dr. B is just, the mouse is like, this is it. We're not streaming for 5 hours. This is not what we're doing. The mouth is like, stop it. The mouse is like, give me a break. Okay. Are we back? Are we back yet? No. I am just, the mouse is attacking. I didn't know it was running out of power. Dr. B's like, IT support is not my thing. Okay. The mouse is saying it's connected. Oh, we're back, chat. We're back. Oh, my goodness. My goodness. We're back. It's just the longest lawsuit ever. And we're only at the very first part of it. We're going to have to do another part to get to the second part of it because there's not a chance. There's not a chance we're going to get through all of it. But we will jump to new filings. We will finish the rest of this. I'll attach the Lively suit that we haven't gone through at all because we haven't gone through it at all. But between going through the complaint, the PR suit, and the New York Times suit, we have a lot of what's in here. Not all of it, but a lot of what's in here. And we will have to come back around to the rest of it 6 hours in because we're just not going to finish it. But this goes on to the takeover of the film. The reason there is so much on the takeover of the film, I think, is one, it casts Lively in a negative light, which is part of this. It's part of all lawsuits to cast the opposing side as the unreasonable one who's doing things that they shouldn't be doing. That's why you're suing them. But it also goes to the extortion claims of, we wouldn't have just let this movie be taken over if it weren't for all these other things. That's why there's so much. I mean, there was way too much on and on at the beginning. But as we get into the narrative of the claims, that's why there is so much here. Court TV is like, oh no, the stream is almost over. It's been longer than a full court day. Oh, let's see. This looks like it's from May 2nd. Sony Executive 1. Jamie, I have blank on here too. Redacted has gotten Blake to approve the trailer we want with our narration, the chair kick, bruise, etc. And Blake is calling Taylor to approve the song. She, of course, just reached out saying she is asking for time with, name redacted, her editor. We know it was conditional on signing the contract. So Sony Executive is saying that we know that this was conditional on signing the contract. So it sounds like the contract still not being signed was, but I want this to sign the contract. I want this to sign the contract. I want this to sign the contract. At least that's how it's being portrayed. They go on to say, we know it was conditional on signing the contract. So it sounds like at this point in, I don't know of what year, it looks like it says May, that they are in edit. So I'm assuming May of 2024. I think that's a reasonable assumption that we're talking May of 2024, that they got approval for the, lips are so dry in the winter, the approval for the trailer. They want approval for the Taylor Swift song that's going to be in the movie. They need Blake to reach out to Taylor for approval, and she's reaching out asking for the editor, and the editing seems conditional on signing the contract, but asking if you will reconsider so Redacted can release this trailer and Blake does not change her mind regarding calling Taylor Swift. Okay. Flip that a little bit. It seems that Sony is reaching out to Wayfarer, Jamie Heath, everybody, saying, we know that you didn't want some of this to happen until the contract was signed. But we are asking you to reconsider so that we can release the trailer. And we, Sony, don't want Blake to change her mind regarding Taylor Swift approving the song, because she is going to approve the song. So can you just reconsider? Which goes to whether or not Sony is saying, can we just? Jamie, he said, I'm available to talk on the phone. Call me when you're free. Sony said, you guys don't want to play ball. You're going to delay and greatly hurt the movie. So it doesn't seem like Sony is mincing words on the, it seems to me, Sony is like, do it. Just do it. Get it done. I don't care what you need to do. Get it done. Sony, you guys don't want to play ball. You are going to delay and greatly hurt the movie. Good luck. I think the good luck is pretty much a good fucking luck with that. See how that goes. The Sony Executive 2 says, this is only if you want to make this date. You are going to need to push. Finish director cut, and we can have multiple previews down the road. Just get it done. Get it done. Get it done. Just get it done. We have deadlines. If you want the movie out and if you want this done, get it done. We don't want Blake to reconsider. We need to get this done. Baldoni and the film's editors were not even allowed to see Lively's cut. We've seen this in the New York Times suit. We haven't seen any other conversation about this because it's not in the other suits. So we will see if it comes up more. We will see, but it doesn't, at this point, it is not responded to in the other lawsuits that there was a cut. I don't think there is any controversy on whether or not there was a Lively cut. It seems that there was from all conversation around this movie, but not addressed in any of the Lively suits, addressed in this suit and the New York Times suit that Lively was allowed to make a full cut of the movie. I'm interested to see what Sony is going to say with that. We will see how this gets responded to on the, how is an actor in the movie making their own like director's cut of the film, but they are saying it was through extortion and that the film got completely taken over. We saw this in the New York Times suit that they say that it performed better, that Baldoni's director cut performed better than Lively's cut, yet Sony still released Lively's cut. I'm curious as to what Sony is going to say again in all of this, and whether they are going to say with the 17-point document, Sony say, we're not touching this with the 17-point document. If there'd been complaints on set that Sony was aware of, that they're like, we just want to get it done. Or if Sony's going to say, we're not going to burn the bridge with Lively. Lively has to go do the marketing of the movie. We're not going to burn that bridge. And that's what we're doing. So that's what we're doing. That's ASMR Queen said they released Lively's cut. That's what the lawsuit says. And I haven't seen any, again, we haven't seen a response to that. That's what the lawsuit says. This is in the New York Times suit as well that Baldoni had and was in the hospital for an infection in his back as this was going on and as the Sony cuts were going on. This is between Sony and this. This I covered in Quick Bits this week, but I found this to be incredibly interesting because I was like, how does any of this happen? In the New York Times suit, they're like, they cut him out of all of the posters and they cut him out of the Film By, and all of this stuff got cut. I'm like, how does this happen? Well, here's one email that seems to point in a direction of how this happens. June 18th, 2024, from Jamie Heath and others from Sony Executives. I appreciate that they are named Sony Executives 1, 2, and 3, and their names are redacted. Everyone involved is going to know who they are, but it does stop them from getting blasted publicly, which is probably for the best because they're all going to get deposed. Hey, Jamie, we had a very successful, I'm going to blow this up. We had a very successful weekend at Book Bonanza. The fans love the book art displayed at the event. We would like to release this art as our second teaser poster for domestic distribution, since it has already been released internationally in many markets. It only makes sense to use it domestically as well. We'd love to start printing tomorrow to get it into theaters. However, this version does not have Justin Baldoni's A Film By credit, so we would need to waive that. Please let us know if this is approved. So in the New York Times suit, they're like, all of this came off. He was cut out of the trailers, the A Film By credit, all of this was removed. And then asking how? Well, Sony's like, hey, we've already printed these internationally. Are you cool if we just go ahead and do that? Just, we good? Like, we good? We want to print them tomorrow. So we're going to cut off your credit. We're just going to print them tomorrow. I wonder, again, when they say waive that, it implies to me that in the agreement with Sony, and we may or may not see this, but it implies to me that in the agreement with Sony, this was agreed to, the A Film By credit, because they're not saying, hey, we're telling you we're cutting this. They're saying that we need to waive that, indicating to me, and it might just be lawyer reading into it, but it indicates to me that this was agreed upon in advance, that he would have a Film By credit in their distribution agreement, and that they are asking him to waive something that was already contractually done because they didn't put it on the international posters, and so they were just going to remove it. So that's Miss C said, is that on Lively or Sony? That's on Sony. These decisions are on Sony. So I'm interested to see what's going to happen with Sony in all of this. Sony has not been sued in any of this. We are going to see Sony, as this goes on, fighting over discovery, depositions. Sony is a necessary witness in all of this, but Sony is at this point not sued. Did Sony breach their contracts with Wayfarer? We don't know. We will see. But it seems like from this email, and we don't have all the other emails, but in plain reading, Sony said, so yeah, can you just go ahead and waive that? We're going to do this tomorrow. We want to print tomorrow. You good? Great. Thanks. It goes on to say, over Sony's objection, Lively insisted on screening her cut at Book Bonanza. This was in I covered it in Quick Bits B. It was in the New York Times that Lively's cut was screened at Book Bonanza, Colleen Hoover's annual convention, and that Lively was on a panel alongside Hoover and other cast members. What date is this? This is around June, so less than a month. Less than a month before this hits theaters. So it seems like it's nothing like the last minute, right? Hey, by the way, we need to do this tomorrow. Can you go ahead and just waive that? Great. Thanks. So Lively went to Book Bonanza. They screened her cut at the convention with the author and the fans. Baldoni had been excited to attend. Sony made it known to Wayfarer that per Lively, Baldoni could not attend, notwithstanding the obvious promotional and PR risks. Lively appeared on a panel alongside Hoover and other cast members, icing Baldoni out for this critical event. And then they go on to talk about him being cut out of every other event, including the premiere. And they show pictures of that. These are text messages between Jen Abel and Baldoni. Baldoni on June 3rd saying, she kicked me out officially from the film now. She's finishing it all. I can't be involved. Music, sound, VFX, everything. I'll make it through somehow. Just need to feel it all. And Jen Abel, the PR individual who's also a part of this lawsuit, saying, hey, Jamie just filled me on about BookCon. I know this is devastating and such a kick in the gut. It's petty and childish at this point. I'm just making sure you are okay. We will get through this. Eye on the prize. Her attending BookCon is a win for the film. And if she wants to drag her ass to Texas, then let her. Texas is getting dragged in this. Sorry, Texans. If she wants to drag her ass to Texas, then let her. I don't know why Texas is catching strays left and right. You can be home with your family, which is important. And then there are more conversations between the editors in June about the same conversation of this is getting taken away. They're airing her cut. The editors being pissed. I can understand why the editors are pissed. They were hired to be the editors of the movie. You would imagine they want to edit the movie. Baldoni telling the editors, I haven't even seen the final cut. I'm not going to be allowed to see the final cut. Baldoni in September saying, if you think about it, we didn't even finish our director's cut because she intervened. So ideally at some point we can take a week and I'll finish it with him talking to the editors. They say Lively continued to extort Wayfarer to get the PGA mark. We saw the PGA mark and the emails. I read them in the New York Times lawsuit. We'll go through a few lines of that again. But they are saying that the reason the PGA mark was given to Lively was because Sony told Wayfarer that any goodwill left between us is done, and that they allege Lively was leaning on Sony to say, make this happen, make this happen, make this happen, and give me the PGA mark. And they say and so this is one of the other claims that goes to extortion. Again, not to the PR agents, but to Wayfarer. Well, really to Wayfarer and Baldoni and Heath, that this was coerced and the PGA mark was not earned, and they were forced to write a letter in support of Lively getting a PGA mark on this film. We saw this letter before. I'm not going to reread the letter. The letter and the email go different directions. We saw this in the New York Times suit, June 27th, from Jamie Heath. Hi, all. Writing to you regarding a letter that I wrote on behalf of Justin and myself addressing the Producers Guild. As you know, we received a request to write a recommendation on behalf of Blake for her to receive the PGA mark. That was a request that we feel was unreasonable and cold-hearted, especially the movie, i.e. IEWU has been taken unjustly from Justin and has been taken unjustly from Justin as a director and essentially from Wayfarer's control due to the extortion of Blake. This again is in June. This is before the marketing of the film. So Lively alleges that the smear campaign started at the marketing of the film in August, it seems. This is all going down behind the scenes in their emails before that. So they're saying the movie has been taken unjustly from Justin and essentially from Wayfarer's control due to the extortion of Blake. Without going into all the details of the events that have transpired over the months, Justin and I ended up agreeing to write the letter due to feeling trapped. She continues to hold a threat over our heads, and every time we try to hold the line, she uses that threat either directly or indirectly to get us to fold. And again, they have listed that out as the 17-point return to work that they signed. Make no mistake, I'm not suggesting that we were literally forced to acquiesce. I don't know how we read that in this. We've been extorted. We've been forced to comply. I mean, I'm not suggesting that we were literally forced to acquiesce, but given the high profile of the movie, the partnership with Sony, the amount of money invested and needed to complete the movie, we have written the letter on her behalf, omitting the truth of how and why she was able to contribute in the ways we listed. We're not saying that this is literally what happened, but we're saying it's what happened. But what? They say this has nothing to do with this letter now. It only serves in a way to memorialize why the letter was sent in the first place, should we ever need to explain it. I imagine that on the other side, they're going to say that this was them setting up the other side of the smear campaign. We'll see. Again, the takeover of the movie allegations have not been addressed, but they're saying we're trying to memorialize this in the first place, should we ever need to explain it. And this is on June 26th, the Producers Guild saying Lively was amazing. Everything was great. She contributed hugely. She deserves the PGA mark. They talk about the premiere. We are not going to go into the premiere because we're not going to have time. But he was not allowed to go to the premiere. I don't think there's any question about that. That's what happened. Then we get into the text messages. We'll get into some pictures from the premiere. Then we get into the text messages. They say that the New York Times cherry-picked and sliced and misconstrued the text messages. Some of that is meaning changed. I think it's arguable. In some of that, I think it's more apparent. So these are from the complaint vis-a-vis. These are in the New York Times suit as well. We went over them then. So they put in what's included, what's excluded. There are a few text messages that aren't addressed. The way they cut it is so hard to see, just because of the size. But in the complaint, they talk about we can bury anyone. That's what they're talking about now. And they are split screening we can't write it down. We can't write down that we will destroy her. We will go like this. We will do that. And so they're saying what's included, what's excluded. Does it change the meaning? That's going to be it's going to be up for interpretation, but they're saying the New York Times misled by cutting things out. We can't write it down to him. We can't write, we will destroy her. We will go like this. We will do this. We will do this. We will do this. Excluded, of course not. I think the of course not goes to we can't write it down, but I told him that's the point of talking, though. They say they excluded the work is not the document. The work is the fucking crisis. Lol. If it's any consolation, he thinks this with everything, overthinks, stresses, high anxiety. He just needs to be educated on how the process works. And they included, we can bury anyone, but I can't write that to him. I will. I'll be very tough. You guys let me know what you think. Bell Moon asked, why aren't they all digital forensic texts? I don't know. They put in screenshots. I don't know if the point this was being written, this side had the forensic extraction or not. We don't know. They are putting in the screenshots. They're saying, look, we can do the things. We can't write the things down. I don't know if the rest of the text change the context there. In some of them, I think they do. So we can't tell him that. That's not how it works. Let's see. I can't write to them. I will. I'll be very tough. And then the rest of this is excluded. It seems like they move on to talk about how stressful this all is. I don't know if that's the New York Times cherry picking. I think that's maybe overreaching because now it's, as you know, this is twisting, turning because we don't know their moves, meaning we don't know what they're doing. So we don't know, but don't worry. I get it. I may just drink half a tank of Pepto-Bismol and be ready for the call. Now they're going through this is all going to be stressful. Maybe that's how you approach. Yes, exactly. And maybe that's how you approach the Baha'i thing, that we have no idea of this approach and why we can't be proactive as we have no idea what she will come out with. I think reading it in the light most favorable to the complaint here, I think what they are saying is why we can't be proactive, because that's what Lively's accusing, right? Lively's accusing of them going on a proactive smear campaign. So I think that one particular text saying, right, this is why we can't be proactive. We're waiting to see what she comes out with. That can change the context of, was this a smear campaign where they were planning things about her and doing social manipulation? Or did that 17-point meeting happen and then they said, fuck, we're going to need some PR because we don't know what she's going to publicly say. They're saying that text message, I think, can change the interpretation here if it was provided to the New York Times. So why we can't be as proactive, or why we can't be proactive as we have no idea what she'll come out with. And then they talked about Pepto-Bismol and espresso. I don't think those are all that impactful. And then they say he can't come across as a victim here. We are walking a very fine line. Exactly. He can't look guilty either by shying away from this stuff. And then what's interesting to me is that on the one side, they cut out Baldoni's text. It's on this side, but it's not on this side. In the complaint, it says, Baldoni texted with a screenshot, the "this is what we need" screenshot, and say, this is what we would need. And this is what we would need is a article talking about, or an X post talking about Hailey Bieber bullying women, and that this is what we would need. On this side, they have it in this little box right here. The screenshot is excluded, that this is what we would need. And then, yes, I literally just spoke to Melissa about this on break, about what we discussed last night for Social Digital, focus on Reddit, TikTok, IG. It seems like they are talking about this is the narrative we need. And yes, this is literally what we talked about. But they focused on the fact that they excluded a bio and said, she wants to interview me, want to have me email her. She's emailing me. I said I would make it happen. So now we've moved into them having a interview. I don't think the insinuation that that changes the context is a fair one. If you look at it quickly, maybe, but if you look at it closely, I don't think the insinuation that them scheduling an interview with whoever that bio is a change of context. So they don't address the "this is what we would need" text. They just kind of move past it and say, hey, but look, all this other stuff is excluded. So when both sides are saying the other side is leaving stuff out, both sides are saying the other stuff is leaving side out. Point being, both of these lawsuits are written in the light most favorable to the party filing them. That's what lawsuits do. How will this all come out? When it starts coming out more in filings, we will see. And then, let's see. They go on to point out other instances of where the entirety of the text messages weren't included, and when some of these are scheduling stuff that's excluded. But there is one, and the scheduling stuff, they left out when you're back and when you're not. They say again that excluding the response to the majority of socials are so pro-Justin, I don't even agree with half of them. Oh, I agree. I'm just anxious per usual. LA Times reached out to Justin's old assistant. You're okay. It's been too much press, too chaotic. I told you, People Magazine message. They're saying leaving all that out changes the context of it. And then talking about like ET annoying me, like there's a whole conversation about it, but they are saying that the way it was cut from the majority of socials are so pro-Justin, I don't even agree with half of them, cut directly to the OMG, yes, you will die. He doesn't realize how lucky he is right now. We need to press him on just how fucking lucky, the whispering in the ear, the sexual connotations, like Jesus fucking Christ, the other members feeling uncomfortable watching it. I mean, there's just so much. Doesn't matter if it's not true. Now, they are saying, look, the doesn't matter if it's not true being left out does change things. I think doesn't matter it's not true being left out doesn't look good at all. On the other ones, do I think it's a gotcha that the scheduling of when somebody's doing a interview changes the context? No, not necessarily. But when you're getting to the The whispering in the ear, the sexual connotations like Jesus fucking Christ, other members feeling uncomfortable watching it. I mean, there's just so much. Doesn't matter if it's not true. That can change the interpretation of it. And then they get, I don't think they get that. They think the truth wins. No, it doesn't. So, and then I'm like, you're dealing with a psychopath who literally called you a sexual predator, which is really strong language. So it's interesting to see that when they are including this, I think they bury some of their strongest arguments under stuff that just isn't that strong. There's so much of it. But I think this is a much stronger argument than some of the other arguments of the LA Times reached out to Justin's old assistant. Okay. So sometimes too much might be too much. I mean, too much might be too much, but this one gets kind of buried. And that one is a difficult exclusion, as it doesn't look good. Doesn't matter if it's not true. Does the New York Times interpret that to say it doesn't matter if it is true, doesn't matter if it's not true? Maybe, maybe not. So this goes on to say, let's all be happy with quote unquote difficult. And I'm like, we're dealing with a psychopath who literally called you. Oh, there we go. I have it on text messages, by the way. Unbelievable. Let's be happy with difficult. And he told him we took out misogynist, which seems to be coming out from conversations with people writing articles. Leslie can't possibly believe that. These things going through what Leslie is thinking, Leslie being the other PR person, those things may or may not be instructive when we get down the road. So we will see. Some of them are more impactful than others. Getting buried in it is a lot. Let's try to have a calm, let's give it a day to calm down. And then they keep going through the complaint saying that these were all talking points. These are the talking points attached to the complaint. We saw them. Page 101. These were all the Sony marketing that we went over. Saying what to avoid. Focus more on Lily's strength and resilience as opposed to describing the film as a story about domestic violence. Empowerment is not just about standing up to adversity, but also having the power to overcome within oneself and grow. Avoid talking about this film. That makes it feel sad or heavy. It's a story of hope. Like this marketing campaign from whatever date this was is not going to be good. This marketing campaign was going south at the beginning. Like, what to avoid? Avoid talking about the film in a way that makes it feel sad or heavy. The film about domestic violence. Avoid talking about the film being representative of every woman's story. I think that's fair. So this is what Lively side has said is the marketing plan. This is what we're talking about in interviews, what's being provided to reporters. And Baldoni's team is saying, we did not sign off on this. This was not our marketing plan. This is not something we signed off on. They say the film's against much resistance from the film's distributor, Baldoni from day one made it clear that he was making a film to bring awareness to domestic violence and would not refrain from doing so when promoting the film. He did not, quote unquote, go rogue as Lively alleges. Sunday, August 11th, we don't know what year. Good morning, team. I'm assuming 2024. Good morning, team. So I was thinking about the response to this weekend, and I feel like what we should do is make sure to emphasize the voices of the survivors. This is in both of the other suits. It's going to be a lot of buzz, how much money the movie made, but I want to be the one that always direct the back to the survivors or it back to the survivors. So I would love to come up with some sort of video or carousel of messages from survivors' responses to the film. This is as we're getting into all of the promotion. Aaron said, what's the date on the marketing plan? No one put the date in the marketing plan in any of these. No one. No one, not at all. None of them. This gets into the premiere. Baldoni not being at the premiere. They include photos of it. We're on page 105. Include photos of them not being at the premiere to go on to say, look, this movie got taken over so thoroughly that we weren't even allowed to be at the premiere. We weren't included in the premiere. We were in a basement. And we saw that in the, it's explained in more detail here, but we saw that in the New York Times suit as well. Why are we going over it? Because at the end of the day, it is not direct to any of the causes of actions. That's why this is attached. They say that the power grab was a miscalculation and then she wrecked herself in marketing. But there was one text that I had questions about, and then we're going to look at the new filings. And then we will have to resume some of this, well, another stream because there was no more time for today. Let's see. This is internal with Wayfarer and Sony and talking about the movie and the marketing, and can we be more mindful of the marketing, including the pushback from Wayfarer. There's an email from Wayfarer to Sony when Sony posted this that says it ends with us movie, grab your friends, wear your florals. There's an email from Wayfarer to Sony being like, this is the problem. Can you not post this? Sony posted this on the official movie account. And Wayfarer's like, yeah, no, can we not do this? Sony, can you not do this on the official movie socials? And then it seemed we don't have the email communications back and forth with Sony. We have Wayfarer emailing Sony saying, stop it. What are you doing? And this is purportedly from Sunday, August 11th. Jamie saying, to be clear, because Sony didn't like it, I think. This is the email I skipped. Apologies. Sunday, August 11th. From Wayfarer and team, from Wayfarer's team to Jamie Heath and Sony. So this is internal at Wayfarer, including Sony. Good morning. Sharing this post that's using the exact language that has been called out for inappropriate marketing of the film. Sony's included on this, so are PR. And then they include this post from It Ends With Us movie, the official movie account from Sony, saying, what the fuck? And then the email seeming to fix it is Heath to unknown parties, including Sony, saying, to be clear, we're not saying it's been inappropriately marketed in any way. In fact, you all have been brilliant. Thank you. I want to know what happened in the emails in between. Because something happened where they're like, wait. No. We're not saying it's been inappropriately marketed. Yes, you are. That's exactly what you said. Exactly what you said is don't do that. And I think everybody can agree, don't do that. To be clear, we're not saying it's been inappropriately marketed in any way. In fact, you all have been brilliant. Thank you. Extremely honored to be partners with you. It's been fantastic. The proof is in the pudding. This post is only pointing to the ones who have spoke about the marketing. And while I'm not dissuaded by their commentary, it's good to take some learnings from it. It seemed like Sony got pissed, like DEFCON pissed. And they're trying to be like, no, can we just take a minute to understand what's happening? Can we just maybe not market the film this way? I know and trust you understand the point, and I look forward to discussing it with you all. Congratulations on the huge success. You play a big and amazing part of it. Thanks, Jamie. It seems like they are trying to be like, please don't market it this way, and also not blow up the relationship. This is not the point of the lawsuit, but I am also very interested in what the fuck all of this has to do. Nella said, what do floral dresses have to do with DV? I think that they were trying to pull in the fact that the lead character owns a flower shop and trying to focus on the lead character owning a flower shop, and that the lead character's last name is Bloom and there's a flower shop involved. But for all of you saying I'm invested in the Sony interaction, me too. Very, very interested. But it's not, Sony's not being sued at this point. We'll see what happens. But there's a lot of back and forth here. And ASMR Queen said, Emily, it's awkward. I don't disagree. I don't disagree at all. But when asked to what is this about, I think that's what it's about. I don't disagree that it's awkward. And Kristen said, and the character's name is Lily Bloom. Yes, the character's name is also Lily Bloom. So there's back and forth here, and we will see how much pressure Sony exerted here, because that's going to go to some of these causes of action. The allegation is that Lively and Reynolds exerted that pressure on Sony, and Sony exerted that pressure on Wayfarer, and that they were stuck. And we're going through what they have put in here. We see some strongly worded emails from Sony. We'll see what the back and forth is more later. And then they talked about the backlash on social being organic and not a smear campaign, and that Lively is trying to make the backlash on social be because of the smear campaign that they allege, not because of any of one's own actions. And then they say, look, we hired Crisis PR because we didn't know what you would do, because we didn't think the movie would get taken over. Let's see. This is Leslie, it looks like Sloan with Melissa. Just also, I'm not doing one thing without speaking to you. They say Leslie Sloan was like, I'm not going to talk to any reporters. I'm not going to talk to any reporters. And then threw everybody under the bus to a reporter from Daily Mail. That was in the New York Times complaint before some of it was redacted out for reporter privilege, but that was in the New York Times complaint. And we have covered that. And it seems that the Daily Mail told someone, the lawyer or the other PR or someone, that what Leslie Sloan was saying. These texts were being shared by the Daily Mail reporter to this side. That's why they have them. Leslie Sloan is saying, I'm not going to say anything. And then Leslie Sloan is saying to the Daily Mail reporter, you've got it all wrong, which is exactly not saying anything. So this is that back and forth that's in the New York Times lawsuit. Let's see. Warning, I just got this. I'm going to speak to him and tell him it's nothing. This is going on about the reactive campaign, which is what they say it is. They say it's not a smear campaign. It is a reactive PR campaign. We're on page 125. You guys can go through that, because there was one other text I wanted to look at with you. But this lawsuit goes on a side quest to talk about how the messages from Jen Abel got into the hands of Lively's team and the New York Times. I want to cover that more thoroughly. I don't have time to cover it today. It's much, but this goes directly to the PR lawsuit that we've covered and saying that's not how this went down, including Stephanie Jones holding hostage Jen Abel's phone number. We're going to have to do that a different day. It is an entire side quest. Stephanie Jones is not being sued in this lawsuit. Stephanie Jones is not a party in this lawsuit, but all of this goes to, this is how the New York Times got it. And then they spend a lot of time saying, oh, and let us tell you what. We're going to respond to the Stephanie Jones lawsuit, even though it's not this lawsuit, but we're going to give you a whole lot of information about it and a whole lot of back and forth. This is some of the same text message. Yes, the same text messages are multiple places in this suit, which is why it's so long. So long. Let's see. They say that Stephanie Jones undermined the relationship they were working on with PR, was doing things that they didn't want her to do. These were in the New York Times lawsuit, the tag team text messages. So let's see. Do you believe, Leslie, can you spin the crisis PR thing so it's actually factual? They have been there have been lies put out up against powerful people, just protecting myself, tag reps a lot of people. And that headline was just to smear more. So they're saying, look, what are we going to do? This goes to their argument that this was reactive, not proactive. They weren't planning stories. The other side was planning stories. What they leave out of all of this is the conversation about their social media team, which is, Josie, we linked it. Josie said, where can I read the filing? We linked it on Thursday's stream. We'll link it on this stream. So we'll link it down below. We'll link both. This is conversation about bots. They don't talk about the person who was doing the social perception campaign, which is not bots. That is called kind of left silent in this. They said, we're not placing stories. They don't address some of those allegations in here. They do say it wasn't bots. We weren't doing that. But the other suit gets into, hey, we've hired Jed and his team. Sentiment on social media is turning. We're seeing social media sentiment turning, and that is different than bots. They're talking about whether Blake Lively has a bot team and that it's obvious and that that's what her team was doing, not what their team was doing. This is the PR agent saying we have to fight for every story. I also attach my phone record so you can see I didn't call the Daily Mail. I'm not posting these stories. This is their PR list of, hey, we didn't know what would be said, and we're making a plan, and we're making an alternative plan. This is all the Jones work stuff. There was one. Lively and Reynolds threaten plaintiffs unless they take the fall. This goes through something that they said they did not cede to, saying, look, we were told the gloves would come off unless we made an apology. And we didn't make an apology, and the gloves came off. That's what's happening. Does that count as an extortion demand? No, because they didn't comply with it. They didn't make a acquiescence. They didn't make an apology. But they're saying this is how we got here. They said, look, you are going to take the blame. You are going to take the fall. You are going to make a public apology. And if you don't, quote, the gloves would come off. They're saying this is how this all went down. And this is why it all went down. Where was the text? There was one text that was not in the lawsuit that we hadn't gotten to, in the New York Times lawsuit that I was looking for. We will finish reading through what we didn't get through today and whether or not it changes context. I'm just trying to not go through what we've already gone through in the New York Times lawsuit. This is all directly from the New York Times defamation lawsuit. Again, they say that the New York Times should have had all of this information. I don't think they did. I don't think the New York Times had. Maybe they did, maybe they didn't. Between Jen Abel and Melissa Nathan, they might have. And they're saying, look, this shows we're talking about it not being us. And if it's not us, then the New York Times knows it's not us. These are their more conversations. We'll get to these conversations because there's a lot to read, because they're talking about content creators. They're talking about not placing the stories. They're talking about her blowing herself up. This is page 161. Let's see. We are not done with the PR. How can we say it? How can we say that we're not doing any of this? It looks like we are trying to take her down. How do we say we're not trying to take her down? They leave out the text with the, this is all untraceable, which all of that. Conversations with Leslie Sloan that somebody screenshotted. I'm not paid to take people down. I'm honest, said Leslie. She hasn't done anything literally anti-Blake. Leslie says, okay. She told me the same thing that she told you, which is she said that Blake's backlash is organic. Leslie Sloan said it's not. She did nothing but help get a movie, make tons of money. Justin makes tons. And then somebody was responding, she was kind of off promoting it as if it was Barbie and just basically on the things that she said directly. So they're saying, look, people are reacting to her own interviews. The New York Times should have known this. We all had these conversations saying that we weren't doing it. And then we get into the parties. There was we'll find it as we go through this more thoroughly. We get into the parties. Everybody's got diversity. They say that jurisdiction is in New York because it happened in New York. So we've got a lot more to cover in this suit. We're going to look at, I think we got through the heart of the allegations that we've seen in 2 lawsuits. So the heart of what we saw in 2 lawsuits are the allegations of what happened on set. What we have seen in the Baldoni lawsuit and not seen in the Lively lawsuit is the allegations of the movie being taken over. And again, these are lawsuits. Everything in them is allegations, though it does seem that there is clear evidence that the movie had 2 cuts, that Sony was saying, we are going to have 2 cuts, that the premiere was staggered so that both parties weren't there at the same time. That all happened in real time. So when we get to the taking over of the film, we'll see how that's addressed. We haven't seen it addressed yet. Really curious to see what the response to that is, because it seems that it's pretty clear that the movie was recut by Lively, who was not the director of the film. So we're going to have to get to that when we see a response. All right, one thing I said we'd go to the new filings, even though we've been here for, sorry mods, 6 hours. I apologize. Let me copy this real quick. This is there might be new filings today. We haven't had a chance to look. We've been streaming all day. This is the new filing that we have talked about. Lyndon is ever practical. I'd like to see a list of facts not in dispute. There is quite a lot of dispute, but there's not dispute that things happened on set. The dispute is what those things were. Was it part of the creative process? Was it wildly misconstrued? Was it inappropriate? Everybody has very different sides. The thing is, it's a movie set. There's going to be a lot of people. There's going to be a lot of video, and we're going to know. We don't know yet, but we're going to know. Let's see. This is a filing from the 19th. Today's the 21st. Anybody remember when EDB would call 2 hours long? I know. I was trying to get through all of this today. There's no way we're going to get through all of it today. I've been overly optimistic. There is so much. This is from attorneys for Lively, and I think Reynolds. I don't know if it's the same firm for both, but it represents as it is. We're already at docket number 15. The thing was just filed literally on Thursday. This is regarding Wayfarer Studios et al. Versus Lively et al. Your Honor, and this, remember, is the same judge. Oh, I didn't even swoop. Hold on. Hold on. We forgot to swoop. There we go. We forgot to swoop. The defendants respectfully submit this letter to provide additional context regarding the executed waivers of service filed today. This is why there are dates in this case. One of the reasons we, Miguelina, no. No, because we did for quick bits. One of the reasons that we see this case already having dates on calendar is because there was a waiver of service. And the waiver of service means, hey, you can serve our lawyers. You don't have to send a process server to us. We can cooperate on getting served. There's multiple lawsuits. Nobody needs to fight over service. Just waive service. Can anyone waive service? Yes. Do people have to waive service? No. But it's the reason there are dates in this case already, because service was waived. Where did that go? No. Bring it back. My mouse is like, look, girl. I told you we needed a break. It's book day. What are you doing? Oh my God. Defendants Blake Lively and Ryan Reynolds respectfully submit this letter to provide additional context. I'm trying to make this just a little bit bigger. These filings utilize the standard forms, which reference a request to waive service of summons. Defendants Lively and Reynolds were not requested to waive service by counsel for plaintiffs. Nevertheless, clients have voluntarily waived service. Well, they're suing, they're being sued. I'm not surprised they're waiving service. It just makes sense. Our counsel have voluntarily waived service and communicated same to Mr. Brian Friedman, who appears to be counsel of record for plaintiffs in this matter alongside noticed counsel. They say appears because he's not pro hoc viced into the case yet, which makes sense. That doesn't, I mean, it will be. It just isn't yet. Such voluntary waivers are effective under the federal rules. The filing was necessitated by plaintiffs' curious decision to insist upon personally hand-serving defendants, notwithstanding prior correspondence in which counsel for Lively informed plaintiffs of their preference to work with opposing counsel to effectuate service in a collegial and efficient manner. Do people have to agree to service? No. But once you say, hey, we're the lawyers, we'll accept service, generally just serve the lawyers. They said, look, we told you. We knew you were going to file suit. You told everybody you were going to file suit. We said just serve us. Why aren't you just serving us? They go on to say, despite this history, plaintiffs' process servers made attempts at service on the evening of January 18th, which resulted in one of defendant's employees, who was not a party to this action, being followed to the residence in which she was staying by an unknown vehicle down a dark road late at night. This conduct was sufficiently alarming as to cause that employee to file a police report. Accordingly, undersigned counsel reached out to Friedman the evening of January 18th to express serious safety and privacy concerns that plaintiffs' attempts at service were creating and advised plaintiffs' counsel of the requirement under Rule 4D1 of the federal rules that any, quote, individual, corporation, or associate or association that is subject to service has a duty to avoid unnecessary expenses of serving summons. Look, just serve us. They go on to say undersigned counsel therefore told Mr. Freeman that Lively and Reynolds would waive service and that this firm was authorized to accept service on their behalf. Earlier today, I provided Friedman and his colleagues with copies of the waivers and requested confirmation of the receipt. But as of the time of this filing, I have received no reply. Your Honor, look, we're trying to effectuate service. This is why we waive service. And it's all on the docket. They waived service, and the court clerk already set a date for the reply of, what was it, March 20th? So they say that, and then they included the emails back and forth. Dear Mr. Freeman, I'm following up on my email of last night, which, like the emails from December and January it references, you have not responded to by email or phone. We're trying to talk to you. We'd like to can we just waive service? As you likely know, last night there was an incident where one of your process servers followed a young female employee of our clients late at night to the home in which the employee was staying. She was sufficiently disturbed by the conduct to file a police report. To avoid further wasting your client's resources, incidents involving third parties, and trespassing on private property, I reiterate that our clients have waived service and attach waivers regarding same. And then it lists the rules again. We ask you to comply with the obligation back in December when Lively filed her complaint, and again in January, and each time you refused to even respond, instead forcing us to go to the time and expense of serving all of your clients, after which you appear to have taken the position that our clients were at fault for attempting to effectuate personal service, even though you could have avoided that by simply complying with your obligations under Rule 4. They take issue. The lawyers take issue. The complaint says it was appalling that you served someone personally while they were trying to evacuate. And in the complaint says, this is how dare you serve our clients while they are evacuating in California. It's insensitive, it's appalling, it's reprehensible. And counsel has emailed them saying, hey, We asked if we could just serve all of you, and you said no. We wanted to work out service with you, and you said no. And then you said we have to personally serve everyone. And then you're mad that we personally served everyone after we asked if we didn't have to personally serve everyone. Like what? They say last night, to comply with the letter of Rule 4, we reached out to inform you that there was no need to incur unnecessary expenses of serving our clients in person and offered to accept service by emails. This isn't uncommon. We have now attached signed and executed waivers confirming same. Please respond in writing today with a copy of the complaint so that we may have a complete record of service that can be presented to the court. If you decline to do so, please explain in writing why you are insisting upon incurring the quote unquote unnecessary expenses of personal service rather than following the process contemplated by Rule 4. The lawyers are like, we didn't need to personally serve those in California because we asked if we could not personally serve those in California and you ignored all of our emails. So we're trying to work together and you don't want to work together. If this is already going on between the lawyers, it's not, if this is what's already going on between the lawyers, it's going to be a problem. However, I do not know where Attorney Freeman lives. I believe he's a California attorney. These emails are, when are these dated? These emails are dated January 18th. I don't know if Attorney Freeman and his firm were impacted by the fires and if these emails were happening during that time. I don't know. But it seems that the attorneys are already having some difficulty in communication, and that is why we see Lively's attorneys saying, hey, in December, we tried to work all this out. You didn't want to. And Lively's attorneys saying, we asked if we could, if you would accept service. We told you we would. You insisted that that wasn't going to work. And that's what's happening. So they say as of December, they were having those conversations with the attorneys. That would have predated what's going on in California, but they did not put a specific date. I do not know if the emails not getting returned are because people were impacted, but the point is, Lively's team is like, we said you didn't need to personally serve us, and yet you're trying to. Can we just work together? And it seems that their emails are not being responded to at all. The point being, this is going to be a mess. We already know it's going to be a mess. This is going to continue to be a mess. I'm going to answer a very few questions, but it is going to be a mess. Because if they're already fighting over service, it's not going to go well. It's not going to go well. It's not going to go well. It is not. So everybody's mad. The internet is mad. Everybody's mad. Everybody's mad. This case is going to take a long time to get through. Why? Well, there's a lot of information in this. There's a lot of information included. There's a lot of things that are cut and pasted into this. When that all becomes evidence, we will hear it argued over in filings. We will see how much comes out. Both sides are accused. Well, no. Baldoni's side is accusing Lively's side of cutting stuff out of context. Does Baldoni's side have every email in an email chain in there? No. Why? Well, they don't need to. It's a complaint. It's supposed to be a short and concise statement. I am going to continue to read everything with I have questions. The Baldoni side says, look, there was no smear campaign. The Lively side says, yes, there was. The Baldoni side talks about the takeover of the film. The Lively side has said nothing about the takeover of the film. That wasn't in their filings, and their filings were contemporaneous with the New York filing, the New York Times defamation filing, and before this filing. So in the list of filings, this one came last, and we will see in all of the litigation if there is a response to that. But right now, there isn't. Is there back and forth over what different text messages mean? Yes. Do we see some of these text messages being interpreted differently in multiple different lawsuits? Yes. Yeah, yes. It's like, wait, what? It's so much. So, for everyone that's going to ask, who do I think is ahead in this lawsuit? The lawyers. The lawyers are ahead in this lawsuit. The lawyers are knee deep in sassy writing, receipts, screenshots. I need them to add timeline in there because the dates get buried at the end. Receipts, screenshots, timeline. Baldoni's side has said, we're going to make all of this available for the public. We will see. We will see what happens. But right now, the lawyers, do I think it's overwrought? Some of it, yes. When we got into the line by line, no. At the beginning, yes, we don't need the same thing restated 7 different times in different places, and it doesn't need to be written like a Netflix show. But that's what happened in the lawsuit against Tom and Ariana. That is and this is how we're going to throw NBC Universal Bravo under the bus. This is everything that they did. I mean, they're not being sued, but this is everything that they did. And that's what we're going to get in these lawsuits. So we will see what happens. Do I have a side in this? No. Will the lawyers being overwrought get called out by me every time? Yes. Will we look at the different receipts on both sides and ask questions about them? Yes. When we're talking about who's splicing screenshots, there's some things that are unflattering to Baldoni that are left out. And there's things that say, look, truth or not, left out. We will see. But do we have a side in this? No, we don't. We are at the beginning of what happened. We are at the tip of the iceberg of what happened here. And have I closed the possibility that there was stuff on set that was uncomfortable and the movie gotten taken over? No, I think those two things can also both be true. Is there a positive or affirmative PR smear campaign, or is there a responsive smear campaign? Is it retaliation or is it reputational management? I don't know how a court's going to parse that. It's going to be a lot, like a lot. So we will see. But the court of public opinion is kind of already done with this case. They're like, nope, done. We're not going to be done. And again, like I said on Thursday, I am not here to just say this side versus this side. We're here to break down the law and the lawyering and to ask questions and to call balls and strikes and to see how it plays out. I know people are going to be upset that I do not take this side or do not take that side. It happens in every single case I cover because the pre-litigation stage versus where we get later in litigation often vary wildly. And we see that when we follow cases from the beginning through trial. The evidence that comes in at trial and what people are talking about on at the complaint stage are completely different. Some of the stuff in the complaints might not see trial. We'll see. Though the internet is divided, we're going to keep looking at this case. And if people want me to pick a side and are mad by that, okay. I'm going to cover it the way I cover it every single time we cover it. And that's what I do. And if the lawyers are going to be overly dramatic, then we're going to talk about the lawyers being overly dramatic. If things don't need to be in the suit that are all included in the suit, I'm going to tell you how I see it. We're going to call it document by document. And if it's good legal writing, perception will generally change based on the document. It's like, oh, that sounds really bad. And you read the other document and go, oh, well, that's not how it's portrayed in the other document. And you just go document by document. The Keller said, Emily, when do you think this case gets to a courtroom? 2026? The federal cases will be in court before then. But when do I think this will see a trial? Probably not. Probably not by 2026. No, I think it will take longer than that if it goes to trial. The discovery on this is going to take like a substantial amount of time. So we'll see. I want to see what happened, and I want to see what I really want to see what Sony was up to. I have a lot of questions. So we're going to do very brief questions. I think I swooped, and then we're going to jam because we're still not through this whole thing, and it's been 2 streams. Mel said, I want answers. All the filings are in the light most favorable. Yes. And Reximoto said, I'm not even sure this will go to trial. I'm not either. It might not. So again, we didn't get to the Lively federal suit. We looked at a few parts of it. I will link both of those down below. I don't think I have a link for the Lively one yet, but I'll do that when I finish streaming, because if you want to read it, I'll put it down below. I don't know if it's been, I know I haven't shared it. I don't know if it's been shared, but I'll put it down below if you want to read both. We haven't gone through any of the Lively federal complaint except for those little pieces to juxtapose and look at how it's discussed as they pointed out. In the Baldoni suit, we have been through the PR suit, still waiting to see if that gets a docketing number. We have been through the New York Times suit that focused mainly on Lively and then saying Lively knew this wasn't true and she told the New York Times, therefore they should have known it wasn't true and they defamed us. They should have looked at everything. They didn't. They cherry picked. They contextualized, and that is defamatory and more. This suit has a lot of what's in that suit plus more, because it also addresses the whole PR side that we haven't even gotten into yet. We'll do that. I don't know when, but we'll do that on another stream. So I'm going to link it below. And then we still haven't gone through the Lively federal complaint. We will get there. It's not going to be this week. But I'm sure there's going to be more filings before we do. It does. It's going to be long. Brandy, I did know it's a trilogy. Brandy said just finished Butcher and Blackbird. It is a spicy. Did you know it's a trilogy? I did. The 3rd in the trilogy comes out in February, I think. I'm going to go read books, that's for sure. Rachel said twinning. Absolutely. Love the hoodie. Love it too. Thankful for the plumber who fixed the heat Monday in -40. Yikes. Shabugi's asked, Emily, does your take on Baldoni Blake have anything to do with being sponsored by Ryan Reynolds? I'm not sponsored by Ryan Reynolds' company at all. Like Nick Vile's pod is doing. I don't know who the sponsors are on Nick's pod. I like going on to podcast and bringing legal opinion, but I realize a lot of the shows I go on to have their own opinion. It doesn't change my opinion. I try to bring the facts, look at what the lawsuits said, talk about how the lawyers are lawyering. But no, I'm not sponsored. I mean, not by Ryan Reynolds, or which company? There's a soccer team. So no, I'm not. And no, it doesn't change my mind on any of the lawsuits that I go on a podcast that has an opinion. I think Nick and crew is very clear on the fact that they have a perspective on this case. However, I worked as a lawyer. I was going to say lawsuit. I worked as a lawyer for a really long time, and people would come into my office all the time and be like, this is what it is. And you're like, okay, I will take that into account. And then you have to go through what can be proven and then decide what it is. So am I swayed by how other people feel about a lawsuit? No, that's why we talk about it. So I will give legal commentary where I think legal commentary can help, to talk about the lawyers lawyering and to talk about when two things can be true. But no, I'm not sponsored. And some of you are saying Ryan Reynolds followed you on Instagram. I've been told that I was not aware of, but I am now. I have since been told. But when Ryan Reynolds follows you, okay. And I've followed Ryan Reynolds on Instagram probably since one of the earlier Deadpool movies. But if I ever have contact with anyone in a lawsuit, I will tell you, but it is my policy that I don't communicate with the parties in a lawsuit. We have broken that policy once, and I did it on stream talking to Ethan Klein about his lawsuit because I thought that lawsuit was so ridiculous that I had a whole ass opinion about it when we went into it. So when we went into all of Ethan Klein versus what is the producer's name? I'm going to get it wrong. The Ryan Kavanaugh suits, I went and talked to Ethan about it, but that's the only time that I've talked to, thank you, Ryan Kavanaugh. That's the only time I've talked to parties in a suit because I thought that suit was stupid. I seriously think I still think that suit is stupid. But being followed on Instagram isn't really like the end all be all of my world. It definitely doesn't mean I know people. I follow people on Instagram who I like, who I don't like, who I'm interested in what they're going to have to say. 100,000, whoever, whatever, follow me back. Do I know all of them? No. Are a lot of them law nerds? Yes. But does that mean I have conversations with people? No. If anybody had reached out for me about this case, I would know when filings are dropping, which would be better, but I don't. But if people follow me, I'm not going to stop them from following me, but it doesn't change my opinion on anything, and it doesn't change how I'm going to cover it because I really don't care. I have followed people whose lawsuits I'm watching. I've only had to block people whose lawsuits I'm covering once, but do I have a personal relationship with anyone in this case? No. Do I know the lawyers in this case? No. If I do know the lawyers in the case, I'll tell you, like we have, but it's just what it is. So do people who I talk about in suits watch me talk about the suits? Probably, but I don't want to be involved with the parties in a suit. Don't talk to the parties in the suit. And a couple suits got skewered for not talking to the parties in the suit. I don't want to talk. I'm not an investigative journalist. I don't want behind the scenes information. I don't want to talk to people. I want to cover what's in the filings. So we're going to cover what's in the filings. That's it. But if somebody reached out about any of these cases, I would let you know. And we'd have a conversation about it. And we would clickbait the shit out of it. Do not worry. But do I talk to the people that everyone I follow on social? No. I mean, I don't think well, that's not true. The first time I noticed that a celebrity was following me on social media was Amy Van Dyken. And I absolutely lost my ever-loving shit. But she's in the chat all the time, and I love her. We talk all the time. I let you know that. The last time that somebody that I just adored followed me on social media, Sir Mix-a-Lot, I died. And we did an interview, and I let all of you know. Anybody else? I think on a members live, I don't remember which celebrity it was that started following me during one of the trials. We talked about it on a members live. And then Amos, who tagged me in some stuff during the Karen Reed case. And I was just like, oh, hey. But no, I live in Nashville. I do Jennifer Coolidge. Yes, we talked about that on a members only because I lost my mind. But do I talk to people that follow me on social? Some, not all, but I don't talk to parties involved in a case at all. Even if parties have reached out during a case, my team filters it out because they know the answer is I don't talk to parties in a case. So no. But if I did, I would tell you guys. If I felt that somebody was trying to interfere with how I saw a case, I would tell you guys, look, we're going to just cover filings like we always do. Had Commit said, wait, RR and EDB aren't BFFs? No. No, Judge Abby would be very mad if somebody tried to take BFFs. But y'all, that's it. That's the extent of it. But do I follow day to day who follows me on social? No, I don't. Because A, we do this, and B, we cover the filings and people like to talk about law. So how I see the filings, I'll let you know. How we don't see the filings, I'll let you know. But we don't talk about the parties. I saw a lot of people being like, I can't believe you were talking about Justin Baldoni. I'm not. I'm talking about what his lawyers are doing. Sometimes the lawyers are overdone. Emily said, do you ever find it difficult to be neutral? Yes. And when I do, I tell you. I just tell you. If I don't like a suit, I'll tell you. That's it. I'll just say, I don't like a suit. And then we will talk about it. Like the Idaho defamation case. I came into the beginning, I'm like, I don't like this suit. We're following it. I don't like it. I think the defendant should lose. I think that this case should never have to have been filed, and it pisses me off. So yes, there are times, but I tell you, this suit is such a mess. It's such a mess that I'm very comfortable that I know that there's a lot that we don't know, and we're going to keep asking. Like this, Denise said, how do Wayfair not sign off on the Sony marketing plan if they agreed to distribution? They had to agree to market it. I don't know. They say that they didn't. I don't know how that happens. And I don't know if we're going to hear from Sony. They've lobbed a lot of things at Sony. Sony doesn't really have a way to respond yet, do they? Like Sony can't make filings yet. I mean, I guess they could try, but Sony can't really respond to any of this. Sony can't say, hey, what? They're not a party yet. So that's going to be difficult for them. They're going to respond when they start getting subpoenas. That's when we're going to see Sony up in this, is when they start getting called for depositions and we get a deposition schedule. Sony's going to have chats. For sure. Kristen said, like the Karen Reed trial. Yep. We just covered what happened in the trial and watched it unfold. Some of y'all had been carrying that, covering or following that case way before I did. And you're like, oh, just wait. And we went through the trial. I'm like, oh, shit. There's solo cups. But it's why I don't cover the stuff outside of social media, because I want to see what's going to happen in the case, in the filings. When there's too much noise outside on social media, it's difficult to parse what's happening on social and what's happening in the lawsuit, which is why I stick to what's happening in the lawsuit. I'm not the arbiter of truth. I just want to see what the lawyers are doing and if they're proving their side. I still haven't seen how the PR agents have been extorted at all. We'll get there. So do we have a case where we have vastly different views on this? Yes. Yes, we do. It's going to be wild to see. And I don't know if we're going to even get it. Like, I wanted to see the PR smear campaign. Like, what? And now we're getting to a whole hostile takeover of an entire ass film. There's got to be so much more that happened that we don't know about yet. And I want to see it. I want to see it. So I'm waiting. But you know what we are going to get in this case? A lot of dramatic filings until a federal judge says knock it off. Until a federal judge says knock it off. For all of you that gifted memberships, Heather Long, thank you. We're going to have a members only tomorrow after I rest my voice. I have a busy morning tomorrow. Misfit Brat said, you know how Hollywood routinely seems to spawn random relationships from movie sets? They playing lovers and think there's real chemistry. What are the odds that this movie about DV has both of them feeling like they experienced it in real life? I mean, I don't know. I think both parties feel, I think everybody feels traumatized in this. I don't doubt it, that everyone's feelings are genuine, that they are just like, what in the world is happening? And there's a lot of allegations of that, but nobody's going to win in this lawsuit. This is a scorched earth you know, if I'm going down, you're coming with me type of a lawsuit. I don't think anyone comes out of this feeling good about it, except the attorneys who are just like, all right, let's go. I don't think anybody comes out feeling good. Annalise said, Emily, what's your opinion about this case? That there's so far to go in this case? Who's right and who's wrong? I don't know. I don't know who's right and who's wrong. I don't know where the truth is in all of this. What I do know is it's going to be a minute before we get to all of it. And it's going to take some time. But do I know who's right and who's wrong? No, I don't at all. J. Michael, good to see you. I'm addicted to Midas merch. Same. Same. The junk farm, and I had brought this up Thursday or when we did the New York Times suit, said, do forensic extractions omit emojis? Simple question. Every white paper says yes. And that's what I was wondering too. And we'll see, are those emojis being intentionally cut out, intentionally modified, or is it just the forensic extraction? I think it's the forensic extraction, but we'll hear when the forensic extraction is done. Aisha, thank you so much for the super chat question. Do you think they learned from the Depp Heard team and filed the lawsuit in federal court to avoid cameras? Maybe. Also, I was watching your videos on Depp Heard Sidebar and saw the live notification, and I'm torn which to watch. All will be on replay, but I wonder if federal court is just to get this done faster. A lot of you said this today, Shauna, that they put out raw footage of the slow dance scene. We'll take a look. I want to know if there was more than one take, and did they put out more than one take? That's why we go through evidence, right? We go through evidence because there are rules to see if evidence is accurate. We've seen cases where pictures have come out and then you get to trial and there's forensic extractions and examinations of those pictures. And it seems that maybe they went through, not seems, I think the jury also believed that those are run through editing programs. So it's a frustrating process to wait for evidence. I think the text messages, though context, not context, I don't know if any of those are specifically like altered. Maybe they're not all in the chain, but I don't think anything's been maliciously copy and pasted. If it is, it'll come out. But when it comes to emails and texts, I think those things are a little easier to verify. Those are much easier in forensic extractions. When it comes to things like photos and video, there's always questions of when does it start? When does it end? What happened before it? What happened after it? What are we seeing? What are we not seeing? And all the chat is saying waiting for evidence is hard. Yep, it is. It is hard. It is really hard. And so we will see that. So, let's see. A lot of questions about why this is federal. I think it's just, I think it's to get to court faster and get this moving faster. I think that's a big factor, but maybe the lawyers will address it at some point, why that strategy was there, and maybe we'll see it at some point. Heather said, EDB, would you agree that law is now practiced more in legacy media these days than old school filings? I don't know if I would say legacy media, but there's a very large public component to high profile cases. That has been the case. I think there are more high profile cases and there's more ability to cover high profile cases than in the past, just because media is so dispersed between who can be media. So I think there's more coverage of it. But yes, I think lawyers have gotten much savvier at how to make sure that a court filing can be read and appreciated by a legal audience. And again, a judge looking at 179 pages is going to be like, the fuck? Seriously? We've got the same text messages 3 times. But a public can read through these filings with a narrative and be like, oh, I get what the narrative from this side is. I get what the narrative from this side is. A narrative being like the recitation of the lawsuit. I understand what this side's arguing. I understand what this side's arguing. It is written very strategically, and it is PR very strategically. And the lawyers are going to have to play both court and public. And they're going to do that. Ice Baby, good to see you in the chat. I don't know why I can't bring up your chat. Hold on, there it goes. This just shows how often miscommunication happens on a daily basis. Good that there is proof because I'm any of our daily lives, no tapes. Exactly. And I think we will see that in this case because it's a film set. And so much of this is going to be witnessed and recorded. For sure. So what else? I know I need to go read PK. PK said you're still here. I know. Just because said, what I want to know is at this point, who hired Blake? Well, the production studio technically would have hired Blake. It sounds like she was kind of pushed into the movie by someone. I don't know if it was, I know she and the author are friends. I don't know if that happened during filming or after filming. That is what I've seen on social. I don't know if that was the choice of the author or if that was the choice of the production studio, but the production studio ultimately would have hired. I don't know if Sony was involved in that decision or if she was hired before Sony was brought on. I don't know. I think we'll see. I think that's one of the things that we will see. But it's just going to be a mess. Brian Scott Patterson asked, isn't the best case scenario a closed settlement where no one admits fault? Blake Ryan quietly pay a lot of money from the slander accusations. Worst case, lawyers make tens of millions and everyone else is ruined. I don't know yet, but it's something I'll keep in mind. Like at this point is too much damage done to stop because both sides filed lawsuits. It's not one side saying they sued me, I can't pull the plug. Everybody filed a suit. So each side could pull the plug. I don't know if they're going to want to. But yeah, the lawyers are going to walk away with a lot of money. And I think everyone's reputation is going to walk away tarnished. I just wonder, and you guys let me know what you think. I just wonder if both sides feel like there's already so much damage done to them that stopping at this point doesn't set the record straight for either side. And they're like, the record's not going to be set straight, so I'm freaking done. We'll see. Because it might be really hard to stop at this point for either side. Maybe down the road. We'll see. Jojo said, thank you. Here's your new IT intern. This is the problem with redoing my office is that the unexpected situations come up. Katie dropping in from snowy New Orleans. I can't believe it's actually 10 inches. I was watching Ryan Holyall's coverage of what he thought this storm might be. I know New Orleans is not prepared for 10 inches of snow. Stay warm, stay safe. Mel said in the chat, she doesn't think it's about the record. She thinks it's about the money. I don't know. I think the sides want to be heard. I don't know if it's just about the money. It might be, but I don't know. We'll see. It might be. There was one other question I wanted to grab. Oh, Music to My Soul asked, why is either side allowed to omit parts of a text conversation that seems like tampering with evidence or something? Music to My Soul, none of this is evidence yet. That's why. Oh, Mel, I misread. I do that. Said it's about the record, not the money. Thank you. I did misread. It's all about the record, not the money. Thank you. In real time, my brain flipped the words around. Sorry to transpose. Yes, I do. I think that's what it's about. And a lot of you have said it's about control of the sequel. Wayfarer owns the rights to the sequel. And I worry that the author is the one that's going to get crunched in the middle of this, because how do you make a sequel at this point? Right? Music to My Soul said, why is either side allowed to omit parts of a text conversation? Because they're demonstrative. They're not evidence yet. They're demonstrating the side. They're saying, look, I can back this up with this. Look, I can back this up with this. This isn't evidence yet in court. It hasn't been changed over in discovery. These are receipts at this point, and these are the receipts each side chooses to show to support the complaint in the light most favorable to them. So that's why. Do we see this level of receipts in filings? Not often, not in complaints, but both sides were like, no, we're going to show it. Baldoni's side more so, put in a bunch more stuff, but Lively's side did as well. So no, that's kind of gloves off. And I think the reason Baldoni's side did more so is because of how much the New York Times put in to their article. And all of this is always going to be partly responding to that article as well. And once the article has text messages, they're going to say, no, this is what's missing from the context. But all of it's going to have to be done in discovery, because just because it's a screenshot of a text doesn't mean it will come in a trial down the road unless it is confirmed and extracted. I mean, how much litigation have we seen over a Google search in the Karen Reed case? So much litigation, so much litigation, so much litigation. So that's the kind of litigation we'll see here. We saw it in every case with documents. What's the metadata? How is it extracted? What does the full forensic report show? Does it show that calls were deleted off of the phone but are still on the call log from the cell phone carrier? All of that we will see, but that's going to take quite a lot of time. So we're going to see it. Dawn said, wait, so will they go to discovery if they settle? It depends on when they settle. It depends on when. Let's see. Morgan, I will take a look at that. Thank you for giving me the heads up on messaging. I don't often go into my my DMs, but I will take a look. I will find it. Mistress is suing a wife, and it's just the beginning of fuckery and spoliation. Oh boy. We've got our hands full this week. Are there new filings? No, the new filings are not the nice pool accusations. That was a demand letter. I have not seen the demand letter yet. If I see a copy of the demand letter, I'll grab it and put it in the file. We'll talk about it another day. That is not a demand letter. It's a preservation. Like, hey, this might be relevant to litigation. Don't delete your shit. And we'll see that soon. All right. With all of that, chat, thank you for being here. I know. Thank you, Brian. Dr. B's like, dinner. Thank you. Thank you, B. You guys, thank you for being here. Thank you for being law nerds. This is why these are so long. It takes forever. So I will keep you posted on what's happening Thursday. No stream tomorrow, except for members only in the evening. I'll keep you posted on what's happening on Thursday. It's going to depend on whether or not we have court in Idaho for Kohberger. I have no idea what happened in court today in the sealed hearing. Once we figure that out, I'll keep you posted in the Law Nerd app. So make sure you have the Law Nerd app at lawnerdapp.com, and we will go from there. All of this is right at the beginning. Hang tight, Law Nerds. Good to see you, and I will see you in the next one. Mods and team, thank you for such a long stream. These lawsuits are just excessively long. I will see you guys in the next one. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.